Matter 230 for this reason, my lords. Document was impounded in a suit for specific performance. Matter is posted for trial court tomorrow, my lord. That is the urgency. 230.
Tomorrow.
Please.
My
Yes,
lord,
please keep.
Tomorrow.
Please keep.
Vacating entry ಮಾಡಮ್ಮ.
ಕೊಡಿ. Please keep.
my lord,
Suit
it
for
is,
partition, my lords. Order 39-1 reject
Good.
ಮಾಡಿದ್ದಾರೆ. Respond number 2 is trying to alienate the property, my lord.
That's
Can you
for-
tomorrow, my lords?
ಕೊಡಿ.
Sir.
Please give. Please give.
it is for dispensation of
Connected
notice,
matter.
my lord. ನಾಳೆ
My lords, this matter is listed on 27th, my lords, wherein our application is rejected.
Yes.
That's not it.
That was most of today, my lord, but the matter is not listed. In the report, matter is coming up on tomorrow, my lord.
Huh? ಕೊಡಿ. ಕೊಡಿ. Tomorrow.
My lord,
Yes.
kindly have it tomorrow.
ಕೊಡಿ. Please give.
My lord, suit has been withdrawn, my lord. Petition become infected.
Nale.
Kindly post it for tomorrow.
Yes.
2:30 one matter, yesterday we had moved.
Huh?
2:30 ಗೆ. Today, my lords, we are requesting for 2:30. Yesterday we had moved a matter.
ಹಾ.
The issue is on an expert.
Senior advocates move ಮಾಡ್ತೀರಾ ಬಂದು.
ಏನ್ ಮುಂದೆ urgency ಇತ್ತು ಅದಕ್ಕೆ. There is a settlement amongst the parties,
ಹಾ.
out of court settlement.
ಹಾ.
There are several cases against each other, including criminal cases. We have withdrawn all the cases. They have withdrawn except one case they have not withdrawn. Now they are trying to alienate the property. We have filed a suit. Pursuant to that settlement, there is a chance of settlement. We sought that they shall not alienate the property.
ಬರುತ್ತೆ ನಾಳೆ ಬರುತ್ತೆ. Please give it. Please give it. Yes.
My lord, in the list to serial number 5, my lord, the petition become infructuous, my lord. Filing memo for that. Voice number 125 of
ನೋಡೋಣ, ತೆಗೆದಿಟ್ಕೊಳ್ಳಿ. Yes. Yes.
Memo, my lord,
ಕೊಡ್ರಿ. Why are you keeping it like that with you? Please give it. Yes. Call out. Please call out.
serial number 7.
List to all of them will be disposed of. You'll have to please
My
wait.
lord,
Yes.
it may be dismissed, my lord.
ಅದೇ,
It has become
all of
infructuous.
them will be disposed of.
It has become infructuous, my lord.
ಹೌದ್ರಿ. The entire list will be disposed of. List number 2. Yes.
My lord was posted for judgment. Then statement was not taken on record. But there's only delay of 2 months because at that time the fresh matter.
ಏನ?
Posting ನಾಳೆಗೆ.
ಹಾ. Yes.
My
Please
lord.
call out.
Serial number 63, my lord, appearing per respondent number 1.
Adjournment only if the other side is present and says no objection. Otherwise.
Appellant
I'm
also
for
is present.
63.
63. Today received the wakalat respondent number 1 to 5 and 7 and 8. Kindly permitted to file it in office.
You are for the
Respondent number 1 to 5 and 7 and
for the
8.
petitioner.
Petition.
Huh?
I am for the.
Serial number 63 at the request of learned counsel for response number 12 and 13.
Alla, 1 to 5, today received the wakala.
Even ಇದಕ್ಕೆ ಬಂದಿಲ್ಲ.
Alla,
Not possible. We'll see. Yes.
Serial number 51.
Yes.
Seeking for adjournment. Petitioner counsel is present.
Serial number?
51. For the
You are
respondent.
for the other side.
yes, madam. 51 to
Connected matters.
connected matters.
The many matters are there.
Senior,
Huh?
senior has some personal inconvenience today.
You are for?
I'm for respondent, but in 2 matters I'm for the petitioner. In other matters I'm for the respondent.
ಬೇರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಇದಾರಲ್ರಿ.
ಎಲ್ಲ same office.
ಹಾ?
Same office, same office.
ಎಲ್ಲ ಸೇಮ್ ಆಫೀಸಾ?
Same.
ತಿಲಕ್ ಇಟ್ಟಂಗೂರ್.
I am.
You are for the
I'm
petitioner.
Sujay. I'm for the petitioner in 2 matters.
What is the name?
Sujay Indra.
Serial number 51. At the
Serial number
request
12,
of
my lord.
Learned counsel Sujayendra Sridhar. Release these matters immediately after Dasra vacations.
Lord, serial number 12, my lord. Serial number 12.
Entry order granted, wherever granted earlier stands extended till the next date.
Serial number 12, my lord. There is chances of a settlement, my lord, in trial court.
Who is on the other side?
Searching, my lord. Last time also jointly we submitted, my lord.
We will see.
Still
Yes.
talks is going.
List number 1, preliminary serial number 1, Harish Bhandari T.
So Harish Bhandari,
I
yes,
appear for the petitioner here.
yes.
If I could brief the facts, lordship, we have challenged annexure A, which is the settlement between the parties before the Lok Adalat.
Hmm.
Here, lordship, what has happened is the petitioners herein are having share in the property. The petitioner number 3, in this case, initially a suit was filed in OS 3 of 16, lordship, which is at annexure B, by the respondent number 1 herein. In that suit, The petitioner number 3 herein was arrayed as
But
defendant
you are
number
not
5.
party to the proceedings.
I was defendant number 5 in the first suit.
Huh?
In OS number 3/16
Huh?
at annexure B. I was arrayed as defendant number 5. So my contention is, I am the adopted son of defendant number 1 in that suit, Shivalingappa. So his wife had executed a will in my favor, in favor of defendant number 5. I have filed my written statement. Subsequently, I have been transposed as plaintiff number 2. Once I was transposed as plaintiff number 2, after issue was framed in respect of the will, what the parties does is, the parties file another suit. In that suit, the petitioner number 1 and 2 are made as parties. I have not been arrayed as party. Even petitioner number 1 and 2, during the time of settlement, it has not been signed by them. They have compromised between themselves. And I have been deprived of my right, as I have right in that property by virtue of the will, lordship.
Issue notice to the respondents. The issue notice. to-
Lordship,
Yes.
status quo in respect of the same may kindly be granted. Status quo, because the properties, lordship, here, the parties have already divided the
No, no.
property. And they're getting the documents mutated to their name, lordship.
No, madam, let them.
Serial number
Yes.
2.
Grateful, lordship.
Petitioner Milord. The petitioner Milord has filed a suit for partition.
Ah.
It's the response area. And it carries the copy of the plaint. And Milord, the said suit came to be decreed, thereby declared that the plaintiff is entitled to 1/6 share in the suitable property. Against that, the respondents have filed RA before the district court. The said appeal came to be dismissed. Against that, they filed RSC before this honorable court. RSC also came to be dismissed. Confirming the judgment passed by the trial court. We have initiated final decree proceedings. The respondents have appeared and produced the copy of the plaint. They have filed, after decree, passing the decree, they have filed another suit for partition in respect of the 2 items of the property. That 2 items are not the subject matter of the my suit. Based on that, the final decree court, FDP court, go on adjourning the matter from 14 years without executing the, without passing the final decree. And
So what's the prayer? Mandamus.
Please, directing the final decree court to conclude the proceedings
There is
by
no order.
drawing the final decree.
There is no order of stay.
No stay,
Huh?
no stay. Lord, get.
No order passed by this court. ಅಲ್ಲ RS pending ಇಲ್ಲ.
RSC also dismissed.
ಹಾ.
They filed another suit, Lord, for partition. I have produced the copy of the plaints at page number 133.
Anyway, it is permissible for the
133.
party
Please,
to seek stay of the proceedings for
No,
some reason or the other.
please.
No
There is
such,
no application for
no
stay.
such stay is granted.
That 2 items, Lord, have left out in the earlier suit. This is what they have taken contention in their suit. But they have filed a written statement in my suit, and they have stated that already partition has been effected. It is only, Lord, practice to drag on the final decree proceedings. Page number 132, order sheet, which I have produced, the final decree court.
Matter is coming up for preliminary hearing. Learned counsel for petitioner submits that the petitioner in whose favor judgment and decree is passed in OS number 305 of 2006. Has filed final decree proceedings in FDP number 12 of 2010. Full stop. The regular appeal and regular second appeal filed at the hands of the respondents have been dismissed. Full stop. Despite the fact that the final decree proceedings were filed in the year 2010, the learned senior civil judge and JMHC, Devanarli has not passed final decree. Full stop. The matter is being adjourned time and again only on the pretext that one of the respondents has filed OS number 385 of 2017 for partition and separate possession, which is pending consideration. Full stop. Learned Counsel submits that there is no application filed by the said respondent seeking stay of further proceedings, and no such orders have been passed either by the trial court considering the final decree proceedings or by any other court. Full stop. The petitioner is therefore seeking appropriate directions to the principal senior civil judge and JMFC, Devanalli, to dispose of the final decree proceedings within a time frame. Full stop. Next para. Having regard to the innocuous prayer made by the petitioner, this court is of the considered opinion that the writ petition may be disposed of without issuing notice to the respondents. Full stop. Next para. Accordingly, the writ petition stands disposed of with a direction to the learned principal senior civil judge and JMFC, Devanalli, to dispose of FDP number 12 of 2010 as expeditiously as possible and at any rate within a period of 6 months from the date of receipt of a copy of this order. Ordered accordingly.
Serial number 3.
Where the respondent can received a copy of the writ petition. I have to file my statement, my lord. Your lordship kindly have it day after tomorrow. This is the case in which the application filed GP holder.
I have no objection. Here, my lord, during the course of cross-examination, the first respondent, my lord, took time. Thereafter, she has executed a general power of attorney to lead evidence. It is not permissible, and that is the question that application has. I have no objection tomorrow or day after tomorrow. I have no problem.
The difficulty is this, my
Tomorrow,
lord,
last
because
time.
why the application is filed by the respondent number one?
Argue ಮಾಡೋದು
Bec-
ಮಾಡ್ತೀನಿ ನಾನು.
It's a simple matter.
ಹೌದು
ಅದಕ್ಕೆ ಯಾಕೆ adjournment ತಗೋತೀರಾ?
ಅಲ್ಲ ಅಲ್ಲ ನನಗೆ ವೈ
ಅವ್ರು ಮಾಡೋದು
ಅಲ್ಲ ಅಲ್ಲ ನನಗೆ ನೆನ್ನೆ ಕೊಟ್ಟದ್ದು ಪೇಪರ್ ನೋಡಿ
ನಾನು ಮಾಡ್ತೀನಿ. ನಾಳೆ ನಂದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಏನಿಲ್ಲ.
At the request of learned counsel for respondent number 1,
day after tomorrow.
release this matter on 27th of September. Yes.
4. Serial number 4.
For the petitioner, my lord. The petition number 2 is the husband, petition number 1 is the wife, and petition number 3 is the first daughter, and petition number 4 is the second daughter. She is a mentally discharged child, my lord, specially able child. In 1994, the father of the petition number 2 purchased the property. It's a joint purchase by the father and mother, my lord. In 17/6/2003, the father of the second petitioner passed away, my lord. The kata transferred to the mother of the second petitioner. In 2018, the mother of the second petitioner passed away. Ancestral property. When the brothers of the second petitioner tried to dispossess from the property and the petitioners, the petitioner approached the advocates and seeking for appropriate relief. As an advice, they filed a declaration suit before the court. Then they came to know
To
that.
pass an order for refund of entire court fee
Yes, madam.
in favor of the plaintiffs.
Yes, madam. Instead of filing partition suit, they filed a declaration suit. Then they came to notice there is a mistake. After the summons issued, the plaintiff filed application under Order 22 Rule Subclass 1(3) to return the plaintiff. We will file appropriate petition before the appropriate court, madam. Subsequently, the plaintiffs and petitioner herein filed a partition suit before the city civil court in OS number 2776 of 2021. Same
Separate
came to
suit.
be decreed, madam.
A separate suit was filed.
ಇಲ್ಲಿ ಅಲೋ ಆಯ್ತು ನಮ್ದು Order 22 Rule 1 Subclass 3 to withdraw the client, that was came to be allowed. Then I filed the partition suit. Same was decreed,
Hmm.
and FDP proceeding is going on, madam.
Hmm.
my grievance is, my lord, court fees, 2,70,000, my lord. The petition number 4 is a mentally discharged child, my lord. It is an honest mistake of an advocate and a citation, my lord. And the notice to respondent may be dispensed because we are seeking any relief against the respondent, my lord. The Honorable Trial Court rejected my court fees application under section 67 of Court Fees Act, read with 51, stating that ನಾನು ಮತ್ತೊಂದು suit file ಮಾಡೋ intention ಇರೋದ್ರಿಂದ court fees ವಾಪಸ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. It is an honest mistake of an advocate, and in n number of cases, Honorable Apex Court and other high courts said that, my lord, when the court fees is concerned, court should make a liberal approach.
Since matter pertains to court fee, the state of Karnataka represented by its principal secretary, Department of Revenue, should be included as part respondent to the proceedings. Full stop. The petitioners are permitted to implead the state of Karnataka as party respondent. Full stop. Learned AGA takes notice for the newly impleaded respondent number 10. Learned counsel for the petitioners is directed to serve 2 sets of copies of the writ petition along with annexures on the learned AGA. Full stop. Amendment shall be carried out forthwith. Please do it.
Seal number 5, Pramodar.
Plaintiff's writ petition, my lord. The suit for declaration permanent injunction with respect to A scheduled property and the delivery of question with respect to the B scheduled property. After the completion of the evidence, my lord, I have filed an application for appointment of commissioner in order to assess the damages where the trees of the suit scheduled property has been cut and removed by the respondent, my lord. For that, an application was filed to assess the damages which caused to the plaintiff, my lord. That application was rejected on the ground that the matter is posted for the argument and also it is not for the collection of evidence. Professor, kindly see the in page 23, my lord, where in the cross examination of the defendant, my lord, he says admitted that there is a cut and removal of the tree, my lord. 23, my lord, I may be permitted to
Suit for declaration of ownership and injunction.
injunction and delivery of person with respect to B scheduled property. Later, I filed a application after the completion of evidence of both the sides, my lord, for appointment of commissioner in order to assess the damages, my lord. That application. Damages.
Where is your application?
That is application you will have to kindly see. That is annexure. Annexure, page 16, my lord, in page 16, annexure C, my lord. May be permitted to read. ಈ ಕೂಡ ಹಾಜರುಪಡಿಸಿರುವ ಪ್ರಮಾಣ ಪತ್ರಿಕೆಯೊಂದಿಗೆ ಅರ್ಜಿದಾರರು ವಾದಿ ಗಣನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳುವುದರಿಂದ ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯಲ್ಲಿ ಸರ್ಕಾರದ ಆದೇಶವನ್ನು ಉಲ್ಲಂಘಿಸಿ ಮಂಜೂರಾಗದ ಕೆಲಸಗಳನ್ನು ಮಾಡುವುದರ ಮೂಲಕ ದಾವಾ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿ ಉದ್ದಕ್ಕೂ ಇನ್ಸ್ಪೆಕ್ಷನ್ ರಸ್ತೆ ಹಾಗೂ ಕಾಲುವೆಯಲ್ಲಿ ತೆಗೆದಿರುವ ಅನವಶ್ಯಕ ಮಣ್ಣನ್ನು ದಾವಾಸ್ತಿ ರಾಶಾಕ ಹಾಗೂ ಅಡಿಕೆ, ತೆಂಗು ಹಾಗೂ ಇತರ ಹಣ್ಣಿನ ಮರಗಳನ್ನು ಕಟಾವು ಮಾಡಿ ನಷ್ಟ ಉಂಟು ಮಾಡುವ ಜೊತೆಗೆ ಬೇಸಿಗೆಯಲ್ಲಿ ಗಿಡಗಳಿಗೆ ನೀರು ಹಾಕಲು ಉಪಯೋಗಿಸಿದ ಇಂಜಿನ್ಗಳನ್ನು ಹಾಳು ಮಾಡಿ ನಷ್ಟ ಉಂಟು ಮಾಡಿ ಗುರುತಿಸಿ ನಷ್ಟ ಭರ್ತಿಯನ್ನು ಅಂದಾಜು ಮಾಡಲು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯವರು ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಇಂಜಿನಿಯರ್ ಹಾಗೂ ತೋಟಗಾರಿಕೆ ಇಲಾಖೆಯ ಸಹಾಯಕ ಇಂಜಿನಿಯರ್ಗಳನ್ನು ಕಮಿಷನರ್ ಆಗಿ ಅಪಾಯಿಂಟ್.
What is the contention?
The contention is that, my lord, the suit scheduled property belongs to the plaintiff, wherein the respondent has formulated the canal, my lord, with regard to that road, my encroaching my land, my lord.
Respondent andre
Are the executive engineer.
Oh, Kaveri Neeravari Nigam.
Kaveri Neeravari Nigamದಲ್ಲಿ ಅವರು ನಂದು ಲ್ಯಾಂಡ್ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿ ನನ್ನದಿರೋದು ಮರದನ್ನ ಕಟ್ ಮಾಡಿ ಇದು ಮಾಡಿ. That's why I filed a suit for declaration on permanent injunction and also the delivery of question with respect to the B scheduled property, my lord. Wherein certain trees have been cut and removed, my lord, and also some of the machineries have been spoiled. So that after the completion of the evidence, my lord, I filed an application for appointment of commissioner to assess the damages, my lord. That application was rejected. It is only after the completion of the evidence I have filed it. And if the commission report gets it, my lord, the actual assessment of damage could be ascertained.
Issue notice to the respondent. The petitioners are also permitted to serve copy of the petition along with annexures and the learned counsel representing the respondent before the trial court. Stop. Next paragraph. Learned counsel for the petitioner submits that the petitioner has filed a suit for declaration of ownership, permanent injunction, and
Delivery of possession with respect to B schedule form. Two schedules are there. Page 11.
and for delivery of possession. Full stop. After the completion of the evidence, the petitioner filed an application under Order 26 Rule 9 of CPC seeking appointment of court commissioner for the purpose of ascertaining the number of trees cut down by the respondents and to assess the damages that is caused to the plaintiff. Full stop. The application has been rejected on the ground that the plaintiff has to firstly prove that he is the owner of the property, and thereafter the question of assessment of damages would arise. Full stop. Next para. Yes, what is your contention?
The contention is that, my lord, it is a cut and removed by the authority, and also it is admitted in the cross examination by the respondent. The trees have been cut and removed, my
So
lord.
you don't want to place reliance on any judgment.
But it is only after the.
This is the problem. You know what is the order. You know how it has to be attacked. But you come simply stand, whatever submission is made there, same submissions you make here.
The actual damage
Huh?
has to be ascertained, my lord. It is the.
Can't come with a judgment? Learned counsel seeks to place reliance on a recent judgment of a coordinate bench of this court in the case of Shadaksharappa versus Kumari Vijayalakshmi and others, reported in 2023(1) KCCR 637, wherein it was held that the discretion to exercise the power under Order 26 of the Code of Civil Procedure is not governed by any form of the suit. Full stop. The court can appoint the commissioner in any kind of suit, provided a report of the commissioner is necessary for elucidating the matter in dispute. Full stop. Next paragraph. Consequently, there shall be an ad interim order of stay of all further proceedings in OS number 92 of 2012 on the file of the learned civil judge and JMFC, KRPT till the next date of hearing.
6.
Challenge the order in the execution petition, my lord.
Huh?
They have challenge the order passed in the execution petition, my lord,
Huh?
in an HRC case.
Huh?
But in which, my lord, the learned.
You are the decree holder.
I am the
Decree holder.
decree holder.
Huh?
My lord, the background of the case is relevant. my lord. We purchased the property in year 2004. Thereafter, my lord, we file a suit for declaration and injunction against, my lord, the predecessor of the first respondent. On the ground that, my lord, they are in illegal possession of the property. We seek possession of the property and declaration also. In which, my lord, they set up adverse possession on the ground that their her predecessor was in adverse possession of the property. When the suit was pending, my lord, our contention is that she is the tenant in one of the building. The suit is filed for the entire property in which building is situated. There are other tenants also. We initiate HRC proceedings also parallelly. My lord, HRC proceedings also, my lord, decreed, and suit is also decreed. In the HRC petition, they file HRRP before, and my lord, writ petition before this honorable court. HRRP is also dismissed. They file a writ petition. In the writ petition, this honorable court says ultimately the properties are same, and my lord, the ultimately what happens in the suit and RA, that will be final. Then, my lord, they file RA. RA is also dismissed. In an RA, they bring one unregistered sale deed, my lord, of below 100 rupees and file it. RA is also dismissed. And RSA is filed before this honorable court. In the RSA, they for the first time they produce a sale deed. This honorable court, my lord, passing strictures, it dismisses the RSA also. After the disposal of the RSA, my lord, they file one more application. On the ground that now HRC is pending, we have filed execution petition, but the boundaries of the suit and, my lord, HRC proceedings are different. There is a, my lord, discrepancy in the boundary, and the decree is not in the HRC is not executable. This honorable court says, my lord, whatever contention you have to take before the trial court. That is the observation made by this honorable court. On that ground, my lord, they file an application before the executing court that there is a discrepancy. That application is also dismissed. Then, my lord, the respondents file a writ petition before this honorable court. In that writ petition, this honorable court observed, my lord, they had a liberty in the RSA that they can raise that contention before the executing court, and they are at liberty to and they directed the executing court to consider that contention. My lord, considering that contention, now, my lord, at annexure P is the impugned order, page 220. My lord, the learned trial judge, my lord, dismisses our execution petition on the ground that, my lord, there is a discrepancy in the HRC schedule and the execution petition, my lord. That is under challenge. My lord, kindly see page 32, my lord, annexure B is the OS.
Yes.
Your Lordship, I have instruction from the client that they will engage the service of learned senior counsel, Mr. V. Lakshmi Narayana, sir.
My lord, throughout the proceedings, they did not dispute, my lord, this is a different property and that's a different property. My lord, the kindly see, my lord, the last page, my lord.
And we will file statement of objection.
Yes, Z. Farid
Yes, Your Lordship.
has entered appearance for
Respondent number 1, Your Lordship.
respond number 1. That objection was filed only by respondent number 1?
Yes, Your Lordship.
My lord, respondent number 1.
Yes, respondent
They are
number.
claiming
The
under their
mother of the
predecessor.
respondent number 1 had.
The other respondents have not raised objection.
Not raised any objection.
They are not the contesting
one
parties
submission.
also, Your Lordship. They are not the contesting parties also before the trial court.
You want to file a memo for dispensation of
I have-
notice?
In the office note, my lord, in the petition itself, I have stated that, my lord, the respondent.
Insofar as the other respondents are concerned, a note has been put up below the cost title that response number 3, 4, and 5 are formal parties and no claim is made against them in the writ petition.
In the respondent number 2 is also, my lord, has not contested. So only, my lord, the second respondent be there, my lord, only 3, 4, 5 may be dispensed.
No, second respondent had not considered as the suit, your lordship. These 3, 4, 5 are the decree holders before the trial court, executing court. And respondent number 2 was a respondent number 2 in the before the executing, and he is not the contesting party. Just he is made a party before the court.
Learned counsel for respondent number 1 submits respondent number 2 is also a formal party
How so?
and he has not contested the matter before the executing.
Yes, sir.
Full stop. In that view of the matter, notice to response number 2 to 5 is dispensed with. Full stop. Next para. Having regard to the fact that the execution petition itself has been dismissed.
But they have not dismissed it, my lord.
Huh?
Not dismissed completely, my lord. They say it is execution petition cannot be, my lord, it cannot be executed and the defense of the raised by the JDR is sustained. My lord, it is still pending.
Therefore, the defense raised by JDR is sustained.
Sustained. My lord, formally it is not dismissed. My lord, if this order is not stayed, my lord, there is an apprehension that, my lord, they may dismiss it. Therefore, I have sought for stay of this order.
Another? The regard to the fact that the executing court is of the opinion that there is a discrepancy in the boundaries shown in the HRC petition and the execution petition, comma, the objection and defense raised at the hands of the judgment debtor is sustained. Full stop. The learned counsel would therefore submit that the executing court may proceed to dismiss the petition. Full stop. Next para. Consequently, there shall be an interim order of stay of all further proceedings in execution case number
13 of 2015.
No, 2015.
Is that what you have asked for?
Yes, your
What
lord.
is your interim prayer?
Lord, interim prayer is, my lord, the stay of, my lord,
Ah.
next of kin.
13 of 2015 till the next date of hearing. Yes.
7.
I appear for petitioner, Your Lordship. In that, the office of, I have written a submission wherein, Your Lordship, that the office has raised an objection to produce the copy of the final decree proceedings petition and the objection. I was not a party to any of the proceedings, Your Lordship. That's the reason I could not file those petition and objection copies in that. That is the submission I have written, Your Lordship. Throughout nowhere, I was not a party to any of the proceedings. And only in the second appeal, I had made an
Interim
application.
order has already been granted.
Yes, please, Your Lordship.
Then why is it coming up for preliminary
He,
hearing?
in fact, party in person has moved the matter. That is, he has not filed any application also. And he had made a mention on the other day that he has some urgency. That is the reason it has listed.
My lord, I am the respondent in this case.
Yes.
I am the plaintiff in the original suit and the decree holder in the FDP, wherein the party has submitted an application for impleading. When the party was not a party in the original suit, then the appeal, then right up to the SLP, the other parties had gone to the apex court. And case has reached its finality, granting me and upholding the decree, granting me the right and the property, suit property. Nowhere.
You will have to file an application for vacating.
No, now I'm there.
Matter cannot be reconsidered like this. You file objections and you file application for vacating the interim order, we will consider.
I am contesting the case on merit, my lord.
2 weeks are granted
My lord.
the respondents to file statement of objections and application to vacate the interim order. Yes.
Number 8.
Lordship, office objection may be
Office objection is overruled.
obliged.
Yes.
May I ask for the date on 22nd October, 22nd October?
sir.
Number 8.
The roster is going to change. You please come afterwards when the matter is listed, we'll see. Yes.
For the petitioner,
Sumit.
this case,
Waiting for the key bit.
the petitioner has challenged order passed on IA number 6 and 7. Milords, order, IA number 7 was filed under section 11 of Karnataka Court Fees and Suits Valuation. Milords, the prayer in the plaint is, I am the defendant before the trial court. The petition, the respondent is the plaintiff, Milords. Suit is for mandatory injunction against the defendant to execute the deed of cancellation of agreement of sale. Milords, it is a
Petition for amendment.
IA number 6 was for amendment, Milords. And IA number 7 is specifically for payment of the court fee, Milords. Direction to the trial court to direct the plaintiff to pay sufficient court fee.
How can you maintain one writ petition in respect of two orders?
Milords, the reason I have challenged both orders here is the trial court has observed, Milords.
How can you file one writ petition?
Have paid two court fee, Milords, in respect of both the IAs.
And officer does not raise any objection.
Yes, Milords. Both the IAs, Milords, is with respect to the court fee itself. Amendment also, what is sought
One is in respect of
the court fee.
amendment.
Yes, Milords. Amendment is to raise a objection in respect of the court fee paid by the plaintiff. And once the IA came to be rejected, Milords, thereafter I filed an IA under section 11 of Karnataka Court Fees and Suits Valuation Act. Suit is for cancellation of the agreement of sale. Milords, it is couched in the form of mandatory injunction. And they have paid court fee of 25 rupees, Milords, before the trial court. And the earnest money received by the plaintiff under the agreement is 1,85 lakhs. I have filed a suit for specific performance which is connected with this matter. I have paid court fee of rupees 2.5 lakhs, Milords. Whereas the plaintiff has
The second order.
second order, Milords, may kindly look into page number 25, Annexure B, Milords. Annexure B, page, the order portion is at page number 25, para number 10, Milords. From the above pleadings and evidence, it is obvious no dispute with respect to relationship between the parties. Suit for the plaintiff is one for cancellation of the agreement of sale. Not in dispute. The dispute with respect to court fee has already been decided by this court in passing the order on IA number 6. Milords, IA number 6, Milords, may kindly turn to page number 17, para number 11, Milords. Page number 17, para number 11. Here is the observation made by the trial court on IA number 6.
Yes.
It is noticed that even otherwise, if the plaintiff is able to get the decree of mandatory injunction as against the defendant for execution of the deed of cancellation of agreement dated so and so, then it is settled that it should be by way of registered deed only after payment of necessary registration and stamp charges before the concerned authority. As such, at this stage, the question of payment of deficit court fee does not arise. Milords, the payment of registration fee or the stamp duty is different from the payment of court fee. Under Court Fees Act, before claiming the plaintiff to claim the relief itself, he ought to have valued. The office of has raised objection initially, Milords, at the time of filing itself. At page number 19, Milords, the order sheet. Initially, the office has raised objection.
Yes.
To hear regarding payment of court fee under section 38(1) of Karnataka Court Fees and Suits Valuation Act.
Yes.
This has not been adjudicated. Now, without payment of court fee, the plaintiff is proceeding.
According to you, which is the provision?
Section
on which-
38 of the Karnataka Court
Right.
Fees and Suits Valuation Act.
Yes.
Suit for cancellation of decrees, cancellation of decree of money or other property having a money value or other document which purports or operates to create, declare, assign, limit, extinguish, whether in present or in future, any right, title, interest in money, movable, immovable property, fee shall be computed on value of the subject matter of the suit, and such value shall be deemed to be, if the whole decree or other documents ought to be cancelled, the amount or value of the property for which the decree was passed or to document as executed.
Yes.
Therefore, my lords, the court fee ought to have been paid under section 38. However, the plaintiff has valued the suit under section 26 and paid court fee of 25 rupees.
The court has considered that in page number 20, section 38(1), IA number 7.
7.
Ah.
That IA
And
has
what is
been
the
rejected.
conclusion?
Rejected on the ground that
Yes.
the issue has been decided in section IA number 6 under section
But
11.
in IA number 6, it is not decided.
Not. What is observed is regarding the registration and stamp charges and not
Yes.
the court fee.
Few dates are important.
Allah. The court has come to a conclusion since the same is decided in IA number 6. It cannot be re-decided. So in IA number 6, you please show how it is considered.
Is repetition filed?
If it is not considered, it will have to be reconsidered.
It is well reasoned order.
Yes.
The kindly produce the prayer of the repetition.
Huh?
First day, as far as the annexure is concerned, the repetition is filed after 1,265 days. No statement is made why belatedly approach this another.
That order was passed on 19/6/2021.
No, 8/4/2021.
8/4/2021.
Then after rejection of the order 7 application, again section 11 application came to the very same relief. That order, that application came to rejected 8/7/2020. That is annexure. See, kindly peruse my prayer in the line. For mandatory injunctions and directing the defendant to execute the deed of cancellation of the agreement of sale dated 22/8/2030. So it is not under section 31.
Mandatory injunction directing the defendants to
Defendant to execute the cancellation deed, not under section 31 of the Specific Relief Act. So I am seeking the relief under section 31 cancellation agreement.
direct.
Direction, I am seeking direction. Kindly peruse the section 38 of the Specific Mandatory Injunction.
So you have valued it under section 26.
Yes, then kindly peruse for the connection that I am not escaping when the liability. I said in I'm dealing with order IS 7, kindly peruse the para number 10 of the impugned order. Last order in order on the mail, the end line. They is principal in the strata. Page 20 finally.
Hmm.
2020 in the cross-examining post act, they are not cooperating with the court. One application upon their filing, kindly peruse the last end line on.
Yes.
The same principle of law applicable to the case on hand also. Further, as the counsel for plaintiff himself argued, issued with respect of the court fee may be framed and adjudicate the same in the trial. Same such options also with this court to frame an additional issue. What is wrong with this? If the court feels that I have to pay the court fee, suppose the court is bringing to the section 31, I'm ready. For that, there should not be any dragging this. From 2024 years dragging for cross-examination. Cancel the suit is filed under section 31.
Yes, madam, what you pointed out is not correct.
I'm relying, Milords, on the
Mandatory
decision.
injunction, which
Yes,
is the
my lord.
provision.
38 of
38.
Huh?
Milords, my,
38.
yes, in similar circumstances, Milords, this honorable court and the Honorable Supreme Court of India has held, Milords, that the prayer.
To direct the defendants to execute.
Yes, yes, Milords. That is how they have coached
Under
the
section-
prayer, Milords. It is
Under section 38.
actually they have coached the prayer. It is for declaration for the cancellation of the agreement, Milords. In this respect, I am relying upon two decisions, my lords, wherein similar prayers were sought to direct under mandatory injunction, and this honorable court as well as the honorable apex court have directed the plaintiff to evaluate the suit properly under section 38 and pay the requisite court fee.
Yes. Yes.
Para number 15, my lords, relevant para of the in WP number 10,782 of 2018. It is settled position, para number 15, my lords. It is settled position of law that where a person who is not party to the instrument seeks a declaratory relief to the effect that said instrument is not binding on the plaintiff, the valuation under section 24D of the Act can be resorted to. Whereas a party to a document who seeks relief regarding the document would be required to value the plaint in terms of section 38 of the Act, which provides for cancellation of the instrument. It appears that where a person is a party to an instrument, any relief, howsoever crafted would amount to relief relating to cancellation of the said instrument. Hence, appropriate valuation under section 38 of the Act is required to be made. In the present case, there is no reason to exempt valuation under section 38 of the Act. The mere allegations of fraud, even if accepted, relates to partial failure of the consideration and so on. So therefore, in this case, my lords, this honorable court has directed valuation to be made under section 38 of the Karnataka Court Fees Act, my lords. Here they have crafted the prayer so that they could escape the court fee.
This Supreme Court judgment
Court also, my lords.
has been called out in paragraph number 16 in the same judgment.
Yes, my lords.
Which is that Suhrid Singh versus Shardul Singh,
In the others
where
decision.
the executant of a deed wants it to be annulled. He has to seek cancellation of the deed. But if a non-executant seeks annulment of a deed, he has to seek a declaration that the deed is invalid or non-est or illegal, or that is not binding on him.
That
Yes.
comes under section 34 of this.
Yes.
In
I'm not
essence,
seeking
both-
the declaration under section 34, I'm not seeking the cancellation.
You have to seek. That is the
ಅಲ್ಲ, ತಾವು ಹಂಗೆ ಹೇಳಿದ್ರೆ
Issue-
that is the
I'm happy, I'm not escaping from
that is the
it.
finding of the Supreme Court.
ಅಲ್ಲ, ಅದರಲ್ಲಿ section 34 ಡೀಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ court can come to conclusion because they are seeking the declaration.
All right.
That's why what I'm requesting your lordship, suppose I'm coming under section 31 of.
You want to you want the court to reconsider? I will dispose of the writ petition.
That's why I'm before the trial.
Allah. It has to be considered now.
Yes, my lords.
ತೊಂದ್ರೆ ಇಲ್ಲ ನನಗೆ.
You want the application to be reconsidered? I will dispose of.
ತಾವು ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬಿಡಿ, if it comes under 31 ಅಂತ I'll pay the court fee, I'll go proceed with.
No, not at this
ಅದು
stage.
drag ಮಾಡ್ತಾರೆ ಸ್ವಲ್ಪ.
Not without hearing the parties.
Yeah, ನಾವು ಒಬ್ಬರೇ
Think of what can we hear?
ಕನ್ಸೆಂಟೇ ಮಾಡಿ, ತಮ್ಮ ತೊಂದ್ರೆ ಇಲ್ಲ. I'm ready to pay the court fee. That's why I made a statement before the trial court. I'm ready to pay.
You
If
want to-
my suit is comes under 31.
31.
31 of specific relief act.
But valuation
The
of court
Supreme
fee.
Court says, if you are seeking annulment of a document and if you are a party to the document,
Not seeking annulment of the document.
then
I issued only the notice. Thereafter I'm seeking direction.
your prayer,
That
sir,
is altogether.
you see your prayer now,
The direction I'm seeking, I'm not a declaration.
to execute deed of cancellation.
Deed of
Of what?
cancellation. Cancellation, I already, because of what you have issued the notice of cancellation.
By clever
Therefore,
pleading.
instead of wasting time on this issue, kindly direct me to pay the court fee, I'm ready to pay.
Now, under which provision is the question?
31. 38.
According to them, it is 38.
38.
38, ಆಯ್ತು 31 ಅಂತ ನಾನು suit consider ಮಾಡಿ 38 ಪೇ ಮಾಡಿ ಅಂತ I'm ready.
You want to pay it under 38?
Yes, I'm
Huh?
ready.
You want to pay
Yes, I don't want to
38.
waste my time.
ಮಾಡಿ
before
ಅಂದ್ರೆ,
time.
you please pay it.
Yes.
ಬರ್ಕೊಳ್ಳಿ. Learned Counsel Shri M. Veerabhadraya has entered appearance for the respondent, who is the plaintiff before the trial court. Next para. The issue brought before this court is regarding the court fee payable by the plaintiff in the suit. In the original suit 4310 of 2016. Full stop. Although it was pointed out by the learned counsel for the respondent that earlier an application under Order 6 Rule 17 read with Section 151 of CPC regarding the court fee payable by the plaintiff was considered by the trial court in IA number 6, and orders were passed on 8/4/2021, rejecting the said application. And further, the very same relief is sought by filing another application in IA number 7 under Section 151 of CPC, read with Section 11 of the Karnataka Court Fees and Suits Valuation Act, to adjudicate the office objections raised when the suit was filed. And it was noted that court fee is required to be filed under Section 38(1) of the Act. Full stop. The said application is, however, dismissed, rejected by the impugned order dated 4/7/2024.
8/4/24. 8/7/20.
Huh?
Yes, it's 8/7.
4/7/2024. Full stop. Next para. Learned counsel for the petitioner defendant pointed out to the prayer made in the suit, where a mandatory injunction is sought to direct the defendants to execute deed of cancellation of the agreement of sale dated 22/2/2013. Full stop. In this regard, attention of this court was drawn to a decision of this court in the case of Sri Venkatesh S versus State of Karnataka in WP number 10782 of 2018, dated 29th of May 2018. Full stop. This court held as follows ಅಂತ ಮಾಡ್ಕೊಂಡು ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 15 ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತೀನಿ. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 15 ಮತ್ತೆ 16. 16 ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಬರೀ 4 ಲೈನ್, ಅಲ್ಲಿವರೆಗೂ ಮಾತ್ರ ಸಾಕು. A to A ಅಂತ ಮಾರ್ಕ್ ಮಾಡ್ರಿ. Learned counsel for the petitioner defendant would therefore submit that merely because the plaint and the prayer has been drafted craftily to circumvent the payment of court fee, the court should not give in to such craft and go deeper into the contentions raised in the plaint and thereafter decide whether court fee is required to be paid under section 38 or any other provision as stated by the plaintiff. Full stop. Next para. For contra, learned counsel for the respondent plaintiff seeks to point out that the earlier order was passed. Earlier order on IA number 6 was passed on 8/4/2021, and the same was not questioned by the plaintiff petitioner defendant. Full stop. There is an inordinate delay of more than 1,000 days in questioning the said order. Full stop. Nevertheless, learned counsel for the respondent plaintiff would submit that in the subsequent order, the court has taken note of the submissions made on behalf of the plaintiff. That the issue with respect to the court fee may be framed and adjudicated after conclusion of the trial. Full stop. Learned counsel would submit that the suit is filed in the year 2016 and the petitioner defendant is making all efforts to derail the proceedings without stepping into the witness box or cross-examine model one or even cross-examining the plaintiff witness. Full stop. The learned counsel, however, submits that the plaintiff is ready and willing to pay the requisite court fee, and he has not at any point of time stepped back from paying the necessary court fee. Full stop.
31.
The learned counsel for the respondent plaintiff submits that having regard to the prayer made in the plaint, the provision applicable is section
38 of specifically.
court fee 26. (26) bracket C now of the Karnataka Court Fees and Suits Valuation Act, 1958, and not section 38. Full stop. Next para.
Here are the para. Definitely.
Having regard to paragraph number 3 of the plaint, this court finds that the plaintiff is claiming to be the absolute owner in possession of the suit schedule property. Full stop. It is also admitted that the plaintiff entered into an agreement with the defendant on 22/2/2013 to sell the property to the defendants, and the agreement of sale was executed in the office of the sub-registrar, Banaswadi, Bangalore. Full stop. The plaintiff is therefore seeking a prayer to direct the defendants to execute deed of cancellation of the agreement of sale dated 22/2/2013. Full stop.
Your notice is narrated in para number 8 of the thing.
In this background, having regard to the settled position of law, that where a person is a party to the document and seeks for relief regarding the said document, such party would be required to value the plaint in terms of section 38 of the Act. Full stop. A word of caution has been issued in various judgments of the Honorable Supreme Court, which has been noticed by the coordinate bench in the judgment cited by the learned counsel for petitioner, namely Sri Venkatesh S. Bracketal Supra. That any relief, howsoever crafted, would amount to a relief relating to cancellation of the said instrument, and hence appropriate value under section 38 of the Act is required to be paid. Full stop. It was therefore held that mere allegations of fraud, which, even if accepted, relates to partial failure of consideration and does not permit the plaintiff to value the suit under section 24 bracket D of the Act, thereby getting over the valuation under section 38 of the Act. Full stop. Next para. Having regard to the said position of law, this court is of the considered opinion that the plaintiff should have paid court fee under section 38 bracket 1 of the Act and not under section 24 26 bracket C of the Act. Full stop. Next para. Consequently, the writ petition is allowed. The impugned orders order dated 8/7/2024 passed on IA number 1 7 IA number 7 6 ಬೇಕಾಗಿಲ್ಲ, not necessary.
ನಂಗೆ ಹುಡ್ಕೊಂಡು ಅದೇ ಸೇಮ್ ಪರ್ಪಸ್ ಫೈಲ್.
ಆಯ್ತು ಹಂಗಾದ್ರೆ 8/4/2021 on IA number 6 and 8/7/2024 on IA number 7 in OS number 4310 of 2016 are hereby washed and set aside. Full stop. the plaintiff is directed to pay the court fee in terms of section 38 of the Karnataka Court Fees and Suits Valuation Act within a period of,
Authorization ಮಾಡಕ್ಕೆ. Consent of section 31 of.
huh?
Suits consent of section 31 of the specific.
ಅಲ್ಲ ನೀವ್ ಏನೇ ಹೇಳಿದ್ರು ಕೂಡ we'll have to go by,
ಮಾಡ್ಬಿಟ್ರೆ ನನಗೆ ಲಿಮಿಟೇಷನ್ ಎಲ್ಲ ಕವರ್ ಅದರ್ ಪ್ರಾಬ್ಲಮ್.
huh?
Limitation is the problem ಆಗುತ್ತೆ. Because the mandatory injection period 38. Now the lordship was holding that it is comes as cancellation of the and pay directly to pay the court fee. Then now if it is not comes under section 31 cancellation fee, then limitation is the problem. 31 ಬರುತ್ತೆ ಅಂದ್ಬಿಟ್ಟು ಸಾಕು.
ಇಲ್ಲ,
Cancellation of the document. Since it is comes under the section 31 of the Civil Act, the court fee has to be paid for under section 38 and
31 of the specific relief act. Huh?
a cancellation arrest provision. ಅದರಲ್ಲೇ ನಾವು ನೋಟಿಸ್ ಕೊಡಬೇಕು ಅದರಲ್ಲೇ
but they have not done so, my lords. At present, we can take the defense in the trial court. Before the trial court, they will have to consider.
ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಹಾಗಾಗುತ್ತೆ ಅವ್ನು ಅಬ್ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ರೆ ನನಗೆ ಕ್ಲಿಯರ್ ಬಟ್ ಪ್ರೊಸೀಡ್
They're trying to overcome all the points here itself, my lords.
What are you
We have to be
specifically
paid under section 38.
ಟೂನಲ್ಲಿ ಇದು ರಿಲಿಜಿಯಸ್ ಆಗಬೇಕು.
All those facts are admitted, my lords.
ಹೌದು ಬರುತ್ತೆ.
ಅದೇನೆ
It is admitted facts.
Since because the suit comes under section 30 of specific directed to pay the court fee under section 38 under then it will clear the area. So clarity ಅಷ್ಟೇ.
ಅಲ್ಲ I have said so since.
ಅಲ್ಲ, ಇಲ್ಲ, 31 ಬರಲೇ ಇಲ್ಲ. 31 38 ತಗೊಂಡು
The provision of law even before the
Court
trial
Act
court in the
38
plaint, they have not mentioned, my lord.
specifically fact.
Even before the trial court in the plaint, nowhere it is stated.
Regard to section 38 of specific
What?
mandatory injunction.
What they have sought, my lords, in the
How you
plaint
shift
is
what?
for cancellation of the document in clear terms.
38,
Para-
31 shift ಮಾಡ್ತಾ ಇದೆ.
Para number, my lords, 8 of the 7 and 8 of the plaint, my lords. What is mentioned is cancellation.
Our argument ಅಲ್ಲಿ, respondent counsel argument ಅಲ್ಲಿ, the learned counsel also submitted that at any rate, the relief claimed by the plaintiff will be in terms of section 31 of the specific relief act common
38 ನಾನು
1963.
ಕೇಳಿದ್ದೀನಿ. ತಾವು 31 ತರ್ತಾ ಇದ್ದೀರಿ.
ಅಲ್ಲ ನಿನ್ನ submission,
Mandatory.
your submission.
ಅದೇನೆ 38 ನಲ್ಲಿ ನಾನು prayer
I have recorded your submission that it will come under section 31 at any rate.
ಹೌದು cancellation of the document.
Full stop. ನನ್ನ ಇದು reasoning ಅಲ್ಲಿ, insofar as the submission made to the learned counsel for the respondent plaintiff, that the relief claimed by the plaintiff would at any rate fall under section 31 of the specific relief act common 1963, comma, that contention will be kept open to be considered by the trial court. Yes.
Serial number 9.
Okay.
You pay the court fee within.
ನಾನು next week ಅದು ಟೈಮ್ ಅಮೌಂಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ 2016 2020 4
In
years.
fact, my suit for specific performance
Plaintiff
also is connected with this fact.
is
my lords.
ನನಗೆ ಒಂದು ವಾರ ಟೈಮ್ ಕೂಡ ಇಲ್ಲ.
directed to pay the court fee within a period of 2 weeks from the date of this order.
ಇಲ್ಲ today ಅಂತ ಹೇಳಿ already.
ಅದೇ date of this order.
And dispose. Special circumstance ಇದೆ ಇದು.
this court should also notice the fact that the suit was filed in the year 2016.
Yes.
And it is contended by the learned counsel for the plaintiff that the defendant has failed to cross-examine
From
the plaintiff
17
witness
2020.
from the year 2020. Full stop. Therefore, the learned fifth additional city civil judge from Bengaluru, CCS 13, is hereby directed to endeavor to dispose of the suit as expeditiously as possible and at any rate within a period of 1 year from the date of receipt of a copy of this order.
Yes, yes, yes. 6 months titles are made.
Number 9.
Appear for petitioner in this matter. But the one, my lords, Hanumappa, who is the my lords,
Final decree proceedings.
my lord,
Final decree proceedings.
Final decree.
Matter arises out of final decree
Final decree.
proceedings. Suit for partition, huh?
good for partition, my lords, it was decreed, that is not under dispute. Now, my lords, the respondent number 1, initially, my lords, one Hanumappa, my lords, he filed a petition for
Determine the question as to whether Sri A. Venkatesh
yes,
is the legal representative of deceased petitioner.
yes,
Hanumappa and Hanumakka.
yes,
And to direct the DDPI Kolar to
There are two
produce
applications.
the entire service register and relevant documents pertaining to appointment and service of Sri A.V. Venkatesh, son of Ajappa.
Lordship, Lordship may kindly turn to page 36, the FDP petition. One Mr. Hanumappa, my lords, he was the original plaintiff and he is the, my lords, the person who filed FDP. He died. Subsequently, my lords, what happened was his wife is Hanumakka. Along with Hanumakka, my lords, this respondent number 1, claiming to be the, my lords, the son of this Hanumappa, they filed an application under order 22 rule 3 of CPC to come on record as LRs. Of course, my lords, we could not file objections because sufficient opportunity was not granted. That was allowed. That was allowed. Subsequently, my lords, we have filed application for permission to recall that order. To recall that order and contest the matter on merits by producing this document to show that this person, respondent number 1, is not the son of Hanumappa. By producing, my lords, the records, that is,
According to you, Hanumappa and Hanumakka,
they have no issues.
did not have any issue.
Any issues. Even according to the deposition of Hanumappa in the original suit, Your Lordship may kindly turn to page number 77. Typed copy is that. Page number 83. Para number 9, madam. Typed copy. Para number 9. Last 3 lines. ನನಗೆ ಮಕ್ಕಳಿಲ್ಲ ಅನ್ನುವುದು ಸರಿ ಇದೆ. That is the statement of Hanumappa in the original suit. That apart, Your Lordship may kindly see, he has filed an application before the administrative tribunal for some because he was working as a teacher. Your Lordship may kindly turn to annexure H.
Page number?
Page number 66. Typed copy is at page number 71. Page number 71 is the typed copy. There also, my lords, he shows his name as Venkatesh, son of late Ajappa. He is the assistant teacher. And that apart in service records also, my lord, that is at page 64. Page 64.
The application has been dismissed.
Right.
Your application is dismissed.
My lords,
On what ground?
on the ground that, my lords, the earliest point of time, because when the application under 22(3) was allowed, we could not, my lords, since we have not filed objections to that application that came to be allowed, now we cannot challenge that order.
No, the Millards, documents are admittedly standing in the name of Millards. He is the son of Ajappa. In fact, the original plaintiff himself said that he has no issues. Now he is trying to come on record. Yes, he is already on record. Now we have filed application under 22(5) to determine the status, whether he is a legal representative or not. If an inquiry is held, my lord, if he is able to prove that he is the son of Hanumappa, then the matter will end. The trial court holds that because 22 Rule 3 application was allowed. No, we cannot.
Allowed, but there was no objections filed.
But there,
And therefore,
there
was no consideration of the issue.
That is the
Yes, what do
finding
you
of the
say?
trial court.
During the pendency of the FDP proceedings, my lord, the father, my lord, Hanumappa died on.
Aitri, gottaitri. The application is rejected only on the ground that earlier application for bringing the LRs on record was filed and you do not file any objection.
Yes,
that is the ground.
The allowing the LR application concern, my lord, the petitioner hearing challenge before this honorable court, my
Yes,
lord,
my lord.
by filing a writ petition, my lord. The writ petition came to be disposed
That
of,
is
my
in,
lord,
I have
with
already
resolution, my lord.
stated in my writ petition also. Writ petition number 19517 of 21. My lords, we have filed application for recalling that order that was dismissed. That was, my lords, challenged before this honorable court. In WP number, in writ petition itself, I have stated. 19517 of 21. My lordship may kindly turn to last para. Last para number 5. That is at page 10, my lord.
Order first in the
The conclusion is this.
dispute ಮಾಡ್ತಾರೆ, but ಇಲ್ಲಿ interfere ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ, interfere ಏನಕ್ಕೆ ಆಗಲ್ಲ ಅಂದ್ರೆ because we could not file objections. That is the reasoning.
10 years, my lord, after lapse of 10 years, they have raised. Their mother, my lord, filed application before the FDP proceedings. ಅವಾಗ ಅವರೇನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದಿಲ್ಲ. ಅವ್ರ ಮದರ್ ಬದುಕಿರೋವಾಗ, ಈಗ ಅವ್ರ ಮದರ್ ತೀರೋಗಿದ್ದಾರೆ, ಈಗ ಅವ್ರ ಮಗ ಅಲ್ಲ ಅಂತ ಬರ್ತಾರೆ.
See, it goes to the root of the matter. If this question is not decided, then grave injustice will not only be caused to this respondent who has raised the objection. The share of Hanumappa, what should happen to the share? If you are not the legal representative or you are not the son of Mr. Hanumantappa, are you not illegally taking away share of Hanumantappa?
Inspection, my lord.
Therefore, unless an inquiry is held,
ಗಂಡ್ಮಕ್ಳು ಹೆಣ್ಮಕ್ಳು ಇರ್ಲಿಲ್ಲ, ಆ ಟೈಮ್ ನಲ್ಲಿ ಸಾಕು ಮಗ ಅಂತ ಹೇಳಿ ಸಾಕ್ತಾ ಇದ್ರು.
therefore, that is why they are asking for.
Let
they are asking for an inquiry.
Be held, my lord.
Inquiry has to be held.
If he is able to prove
Inquiry
his
ನಾನು
son.
objection ಏನಿಲ್ಲ ಸರ್. ಅದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಅವ್ರಿಗೆ ಹೆಣ್ಮಕ್ಳು ಗಂಡ್ಮಕ್ಳು ಸಂತತಿ ಇಲ್ಲ.
If you agree that a direction may be given to conduct an inquiry, we will direct.
ಸಾಕು ಮಗ ಅಂತ ಹೇಳಿ.
Whatever
you will have all the opportunity to place any material before the court. Perfect. Learned counsel Sri C. Venkatesh has entered appearance for respond number 1.
So far as other respondents, my lords, notice may not be necessary because he has only filed objection. He has opposed the application.
My lord, LR application already allowed, amended, petition also filed. ಅವ್ರ ತಾಯಿ ಇದ್ದಾಗ ಇವರು ಪ್ರಶ್ನೆ ಮಾಡಲಿಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಅವ್ರ ತಾಯಿನೇ filed application before the trial court, my lord. ಈಗ after lapse of 15 years they have questioned, my lord. ಏನಂದ್ರೆ ಅಲ್ಲಿ adopted son ಅನ್ನೋದು ಒಂದು ಅವರು ತಗೊಂಡಿದ್ರೆ ಸರಿ ಹೋಗ್ತಾ ಇತ್ತು, ತಗೊಂಡಿಲ್ಲ ಅವರು. ಬಟ್ ಅವ್ರ ಪ್ರಕಾರ ಸಾಕು ಮಗ ಅವ್ರಿಗೆ
ಆಯ್ತು. You will be given all the opportunity. Let an inquiry be held.
2000 ಇಸ್ವಿನಲ್ಲಿನೇ ಒಂದು ವಿಲ್ ಮಾಡಿದ್ದಾರೆ, ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ದ ಸೂಟ್ ಅದೆಲ್ಲಾನು ಅವ್ರ ಹೆಸರು.
Consideration and allowing of the application by itself will not be a conclusion that an inquiry has been held. If an objection was raised and an inquiry was held, then you can say there is, that question has attained finality. They had not raised objections and therefore that issue has not been gone into.
ವಿಲ್ ಒಂದು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
ನೀವು ಏನಾದ್ರೂ whatever material you want to place, you please place. Insofar as the other respondents are concerned, come on, learned counsel for the petitioner submits that the other respondents are formal parties and no relief is claimed against them in the writ petition. Full stop. Next para. Learned counsel for the petitioner. Though the matter is coming up for preliminary hearing, with the consent of the learned counsel for petitioner and learned counsel for respondent number 1, the matter is taken up for final disposal. Full stop. The petitioner is aggrieved of the impugned order.
N6/2024. Next check.
Passed on 10/6/2024. On IAS number 35 and 36 in FDP 16 of 2004. Full stop. The application was filed by the petitioner herein. Respondent number 1(F) to determine the question as to whether the first respondent herein, namely Shri A. Venkatesh, is the legal representative of the deceased petitioner Shri Hanumappa and his wife Srimati Hanumakka. Full stop. Attention of this court is drawn to the deposition of Shri Hanumappa recorded when he was alive, in the original suit proceedings. Full stop. It is pointed out that Shri Hanumappa has himself stated in paragraph number 9 of his deposition that it is true that he does not have any children. Further, attention of this court is also drawn to
Page 66.
copy of the application number 2782 of 2012 filed by the first respondent herein before the Karnataka Administrative Tribunal, Bengaluru, where his name is shown as Shri Venkatesha A, son of late Ajjappa. Full stop. Having this information in hand, the application was filed by the petitioner herein seeking a direction to the DDPI, Kolar and BEO Kolar to produce the service register of respondent number 1 herein, who was working as a teacher in government higher Kannada primary school, Vemagal. Full stop. Next para. However, learned counsel for the first respondent submits that the petitioner herein had filed a writ petition before this court in WP number 19517 of 2021, calling in question the order passed on
17/8/21.
17/8/2021 on IA number 32.
ರಿಟ್ಟಲ್ಲಿ 11/2/21 ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. ರಿಟ್ಟಲ್ಲಿ 11/2/2021 ಅದು ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ ಮೇಲೆ ಇವರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ 17/8/21.
ಸ್ವಲ್ಪ ನೋಡಿ ಅದು
ಪ್ಯಾರಾ 7.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಕಾಪಿ? ನೀವೇ ಕೊಟ್ಟಿದ್ದಲ್ವಾ ಇದು?
ಇದೆ.
ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 7. Quash the order dated 17/8/2021 on IA number 32.
The application was filed before the trial court for recalling the order dated.
Leave to contest
Yes, miss.
the permission accorded to the wife
Yes.
and adopted son of the original plaintiff to come on record. Ade bere, that was a
That
different-
was allowed on 11/2/21.
ಇವರು ರೀಕಾಲಿಂಗ್ ಆರ್ಡರ್ ಅಂತ ಕೇಳ್ತಾರೆ ಸರ್. ರೀಕಾಲಿಂಗ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಬಿಫೋರ್ ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್
That was rejected.
ಅಲೋ ಆಗುತ್ತೆ. ಅಲೋ ಆದ್ಮೇಲೆ ಅವರು ರೀಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ IA ನಂಬರ್ 32.
That was dismissed. That was challenged before this honorable court. Para number 8 mein. Last 4 lines. Para number 8 of the order of this honorable court. That is on his demise. That is on the demise of.
Para number 8.
Sorry, page number 8, para number 2. Page number 8, para number 2. Last 5 lines, my lord. On his demise on 14/1/2011, that is Hanumappa's demise. His wife Srimati Hanumakant, the contesting respondent, the first respondent, have filed an application for 22 Rule 3, read with section 151 of CPC to continue the proceedings as a legal representative. This application is allowed by order dated 11/2/2011. My lords, this order, we have filed application to recall this order. That was rejected. Against that, we have approached this honorable court. That was rejected on 17/8/21.
To recall the order dated 11/2/2011.
11. That was dismissed by the trial court, my lords, against which we have filed writ petition.
ಏನ್ ಹೇಳಿದೆ? Challenging the order dated 11/2/2011, by virtue of which the application filed under order 22 Rule 3 by respondent number 1 herein was allowed. Full stop. However, this court, by order dated 30th of November 2021, disposed of the petition, not being inclined to interfere with the order dated 11/2/2011. Full stop. Next para. However, learned counsel for the petitioner submits that the writ petition was filed not questioning the order dated 11/2/2011, but the subsequent order dated 17/8/2021, which was passed on IA number 32, filed at the hands of the petitioner herein, to recall the order dated 11/2/2011. Full stop. Next paragraph. Having heard the learned counsel for the petitioner and learned counsel for respondent number 1, and on perusing the petition papers, this court is of the considered opinion that since no question was raised on the application filed by respondent number 1 under order 22 rule 3 of CPC, it cannot be concluded that the issue as to whether respondent number 1 is the son of Sri Hanumappa and Hanumakka has not been decided. Full stop. Moreover, a prima facie case has been made out by the petitioner having regard to the material placed on record. Full stop. In that view of the matter, this court is also of the opinion that an inquiry in this regard is required to be held by the trial court. Full stop. No prejudice will be caused to the first respondent if an inquiry is held into the issue as to whether he is the son of late Sri Hanumappa and his wife Srimati Hanumakka. Full stop. If it is the contention of the first respondent that he is the adopted son of Srimati Sri Hanumappa and Srimati Hanumakka,
Bill was executed, my lord, in favor of.
all material to substantiate that fact may be placed before the court. Full stop. Next paragraph. Consequently, the writ petition is allowed. The impugned order dated 10th of June 2024, FTP number 16 of 2004, is hereby quashed and set aside. Full stop. Direction is hereby issued to the learned principal civil judge and JMSC, Kolar, to consider to conduct an inquiry as to whether the first respondent, Sri A. Venkatesh, is the legal representative of deceased Sri Hanumappa and Srimati Hanumakka, and shall pass orders on the applications filed by the petitioner in IA number 35 and 36. Application
Another application is to secure 16 rule 6, Maharaj, to secure the records from the BDO service register.
All right.
Much.
Ordered according.
Much.
10. Narendra HN.
Appear for the petitioner in this matter.
Responding.
Matter arises out of an FDP proceeding. And an application comes to be filed. If I may request your lordships to kindly take page 144. My lords. Page number 144.
Yes.
My lords, I am the respondent in the FDP proceedings. the application that my lords would see in page number 144 is one that is said to be filed under sections 54 and 64.
What is the judgment and decree?
The judgment and decree was in a suit for partition for partitioning in separate possession of the property. I'm sorry.
Yes.
So resultantly in the FDP proceedings, the petitioner who is now the respondent before your lordships, they file an application which my lord sees at page number 144. And in this application, essentially, the relief that is sought is one for attachment.
Direct attachment of
Yes, my lord.
scheduled property.
Attachment of the scheduled
Direct
property.
sale of attached property
Please.
and handing over plaintiff's share
Of the sale proceeds.
proceeds to the petitioner.
Please. And therefore, they have set their position today very clearly to say that what they now want is a value for the property. And thereafter, I file the application. My lords, and if I may, before I go to my application, if I may request the lordships to kindly take page number 148, which is part of the affidavit of the application. The reasoning on why they have sought for this particular relief.
Yes.
Right on top, the finding in the judgment dated 10/5/2022, they're referring to an earlier Supreme Court judgment, my lords. The finding in the judgment dated 10/5/2022, wherein it is stated that even in the event of partition, division by metes and bounds cannot conveniently be carried out. It is not disputed or contested by the parties. Clear exculpate, so on and so forth. Now may I request my lords to kindly take the following page, at page 149, paragraph 17. Para 17, my lords, it is said that as the question of law and facts in the case on hand is almost identical with one decided by the Honorable Supreme Court, that referring to what I read in the previous page. This Honorable Court be pleased to allow the accompanying application so as not only to protect the scheduled property from being used and misused without accountability of the defendants, and also to ensure that the share of the plaintiff is given to her without further delay. And finally, right at the bottom of the page, there is a prayer again to say, wherefore the submissions made supra, this Honorable Court be pleased to allow the application, attach the property, direct sale of the attached property, handing over plaintiff's share of sale proceeds. Therefore, their position has been made very, very clear. They have now taken a stance to say that we do not want a specific share in the immobile property. What we rather want is for value of the share. And this is the application that comes to be filed. Whilst, my lords, the application comes to be filed under sections 54 and 64, which in my respectful submission are incorrect provisions applicable, it should ideally go under section 2 of the Partition Act. Nevertheless, my lords, once that application comes to be filed, I thereafter go ahead and file my application, which is IA number 2 in page number 156. My lords have page 156. My prayer is at page 158. Here I seek that I be allowed to purchase the property, their share.
The share of the petitioner.
Please, their share. And for me to be directed to give them the proceeds of this hearing. So fairly simple. And I file this application once they have filed IA number 1 before me, saying they want the proceeds. Now, when I file this application, they come forward to file objections to it, saying, no, now we want a portion of the property. We no longer want a sale proceeds. And this can be seen in page number 161, which is their statement of objections.
They have not withdrawn the application.
They have not withdrawn the application. That subsists. Now, what the learned trial judge does is that in passing the impugned order, which my lords will see in page number 53, the learned trial judge completely ignores the fact that they had even filed IA number 1 seeking sale proceeds through attachment and sale of the property. Relevant page is at page number 54. May I read this? Orders on IA number 2. IA 2 filed by the respondents under section 3 of the Partition Act, seeking permission to purchase the share of the petitioner in respect of item number 1 of the suit property. This is order on my IA. The said application is supported with affidavit of one Mr. So-and-so, wherein he has stated about filing the suit, decree of the suit, and filing of FDP, and stated that the respondents are intending to buy the same. Accordingly, pray to allow the application. The learned counsel has filed objections mainly contending that an extent of item property is 27 guntas, of which 3.25 guntas has been acquired by BMRCL. And the said remaining portion of 23.75 guntas can be partitioned by meets and bounds. Accordingly, prayed to reject the application. On the basis, here is the consideration of whether the respondents made out sufficient grounds to allow the application. In the reasoning, which is rather short, may I read reason. So the suit filed in OS number so-and-so is for partition, and the said suit has been decreed on 21/1/2000, holding that the plaintiff has one section. My lords?
Your contention is
Yes, my lords.
that without disposing of the earlier application filed by them,
Yes, my lords.
in fact, both these applications should have been taken together.
Absolutely, my lords. One.
That application is still pending consideration.
Yes, my lords.
And you filed the application having regard to this application filed by them.
Yes, my lords.
If they are seeking sale of the property,
Yes.
you are coming forward to purchase it.
Yes, ma'am.
That is your contention.
That's my contention, my lords. And may I also add, my lords, that the once that application comes to be filed, whether or not an order comes to be passed, fact of the matter is that once they have taken a stance before the court, they cannot approbate and reprobate. They cannot subsequently, once I file the application, go back and say that the sale should not happen. Now they need the property necessarily. And my lords rightly pointed a question to them, which is, have they withdrawn that application? Fact of the matter is that's not. And there is no intent to withdraw either. And my submission also, my lords, is that because CPC under section 60 alone deals with the sale of property, and their application is filed under sections 54 and 64, they are inapplicable. Might be wrong provisions. But fact of the matter is when it comes to suits for partition and where they need to seek for sale of the property for getting proceeds, that comes within the purview of the provisions of the Partition Act, my lords. Therefore, their application was one that is filed under section 2, though a wrong provision was mentioned. And once section 2 application is filed, then I'm entitled as a matter of right to file an application under section 3. And the Honorable Supreme Court says that once I file that application under section 3, then necessarily the court has to go ahead and grant me that relief. There is no leeway, there is no discretion otherwise vested in the court. This is my submission.
Please, a few dates, relevant minutes.
Allah, if you have still, see, you filed the application earlier.
No. The reason is, my learned friend has only read the provision.
Yes.
What is relevant is a recent.
No, the prayer in the application.
Recent decision of the apex court has come that we have.
Prayer in your application was to.
Why we said that, my lord will get it in page 147. Please read. That prompted us to file that application. Identical set of facts. Are they both in some? In the aforesaid page 16 at page 147.
Yes.
Last paragraph. In the aforesaid circumstances, I am given to understand that the Honorable Supreme Court in a recent judgment in the case of Vikrant Kapila versus Pankaj Panda reported in so and so had an occasion to consider a similar matter involving senior citizens where the scheduled property involved was not in a position to be property divided, was pleased to give several directions. The direction given reads thus: the majority of the parties to the list are either septuagenarian or octogenarian. We appreciate the need for speedy and timely adjudication of the issues between the parties. The finding of the judgment dated so and so, wherein it is stated that even in the event of partition, division by meets and bounds cannot be conveniently be carried out. It is not disputed or contested by the parties. We have accepted the prayer IA2 and therefore to avoid repetition are not adverting to the prayer once again.
Correct. That is the reason.
No, here
you are yourself saying.
No, what the court
it cannot be divided.
No, what the court said, ultimately Supreme Court said is the DD, Delhi Development Authority should take over the property, evict all the persons, and then give a sale between the two persons. I am ready for that even now, not for third party. He wants to throw me out. That I am not agreeable.
No, sir. Your application, please see your application. The prayer in the, what is the prayer?
By placing reliance on the decision of the Supreme Court.
Correct.
My application is still pending. I am going to withdraw that application.
That is the problem.
That cannot be permitted is what the Supreme Court also says. I'll place the judgment.
Having made this
No, because we have placed reliance on the decision of the Supreme Court, where the Supreme Court says, first step is division between the parties. Then sale between the parties. If that is not possible, then go to the third parties. I'm agreeable for that. Division is permissible here. That's why my lord secured the records in the instant case. The record says the commissioner has, ADLR has clearly said it is possible. Learned Advocate Commissioner said in one line, he says it is not possible. Whereas the ADLR has given the sketch also, he says it is possible like this. We are ready for that.
You are ready for what?
Partition between us. Shares, my lord, 1/6 share.
That is that is what is to be done in a final decree proceedings.
Yes.
Yes.
But what my learned friend wants to see is, he wants to buy our share. We are not ready for that.
No, he filed that application because you filed this
No,
application.
because, no, we place reliance on the decision of the Supreme Court, wherein he said,
That is the very first sentence that you read
no, Mirza,
is where it is not
No,
where
here,
it cannot
no,
be partitioned.
but here it is possible. That's what the ADLR says.
Therefore, if it is possible, that judgment will not be applicable at all.
Then, since the ADLR says.
Why did
it
you
is-
file the application then?
No, because in the,
If it was possible to partition it,
what the Honorable Supreme Court says is, bring a sale between the two first.
yeah, where is the question of sale, sir? If it is partible,
No,
where is the question of sale?
we are willing to buy the entire share ourselves.
The final decree proceedings,
True,
if a suit schedule property can be divided, it should be divided in meets and bounds.
Yes.
And the share of falling into the share of each person should be identified and accordingly finally decreed.
ADLR
As
has
the
done,
alphabetical.
ADLR has done that.
Yes,
It is possible to divide according to that minute.
correct. So you should have pressed for the partition.
So.
Why did you file this application then?
No, because in the Supreme Court says, Honorable Supreme Court has said, first find out whether it is possible. If it is possible, then bring a share.
All right, if you want to withdraw this application, you withdraw the
Yes,
application.
we will withdraw that application.
You withdraw this application and they will also have no issues if the subsequent application filed by them is rejected.
Please.
No difficulty.
Yes, we will withdraw that application. Your lordship may record our submission.
You can't claim, no, you divide and give me the proceeds of the sale.
No,
Your
yes,
prayer
that's
is like that.
No, what I'm insisting, is either sell the entire property amongst us, as done by in the Supreme Court.
Hang madilla. That was not your prayer.
As done by the, because we have
They
placed,
also would not have been
because we
agreed by.
place reliance on the decision of the Supreme.
In fact, if I may,
Hmm.
if the senior counsel has made his submissions, I'd like to point a few things. The specific contention of theirs before the trial court also, and of course before this honorable court as well, is that ADLR has made a certain sketch according to which the property is divisible. Of course, cross-examination of the ADR has also transpired, during the course of which he says that his sketch does not record the fact that there are so many developments on the property. There are two advocate commissioners who were appointed, and both the advocates file detailed photographs, etc., to show
No,
that there are
according to
significant
you,
developments.
Is it possible to
It's not, my lords.
divide the property?
It is not, my lords. That's my submission. Yes, my lords. That's my submission even before the trial court. And therefore, even before the trial court, I said that I'm willing, therefore, to buy their share, because it's not possible in a manner that is feasible. Because there are so many developments, there are roads that are made in between, but fact of the matter is those are common access roads and also require roads for the purpose of fire engine access, so on and so forth, for fire safety requirements. If they say no road is available, you please give me a road, then that is not a feasible ask from their side. And therefore, my respectful submission, even if the trial court, was that this is not a property that can be feasibly divided. Therefore, let them sell the property. I will pay the proceeds of a market value. I'm not asking for upset value. And therefore, they filed the application, resulting in my application. And today, therefore, to come and say that they will withdraw that application, my respectful submission, my lords, cannot be permitted. And even the Honorable Supreme Court, if I may place the judgment for my lord's consideration, the Honorable Supreme Court also says that in a situation such as this, once a party has asked for proceeds to be given to them, they cannot subsequently go back and say that no, they did not want the proceeds. So Once they have filed this application, my respectful submission is that there's no permissibility for withdrawal either.
Yes, let us see.
Please. It's a 1972 judgment, my lords, which still holds the field. And the Ramurthy's case, the relevant portion, my lords, is at paragraph number 11, senior reporter copies. The relevant portion, my lords, is at paragraph number 11.
Nimmat Ridiya,
No, what is?
you have, yes.
A question, para 11 I'm reading, my lords. Question which presents a certain amount of difficulty is at what stage the other shareholder acquires a privilege or a right under section 3 of the Partition Act when proceedings are pending in a partition suit and a request has been made by a co-owner owning a moiety of share that a sale be held. One of the essential conditions for the applicability of section 2 of the Partition Act is that it should appear to the court that a division of the property cannot reasonably or conveniently be made. To attract the applicability of section 3, all that the law requires is that the other shareholder should apply for leave to buy at a valuation. Once that is done, the other matters mentioned in section 3(1) must follow and the court is left with no other choice or option. In other words, when the other shareholder applies for leave to buy at a valuation, the share of the party asking for a sale, the court is bound to order valuation of a share and offer to sell the same to such shareholder at a price to be ascertained. Coming back to the question of withdrawal of a suit in which the provisions of sections 2 and 3 of the Partition Act have been invoked, we find it difficult to accede to the contention of the appellant that the suit can be withdrawn by the plaintiff after he has himself requested for sale under section 2 of the Partition Act and the defendant has applied to the court for leave to buy at a valuation the share of the plaintiff under section 2.
That was the case of
no doubt, it was a suit and there a suit was filed and they asked for the sale. And here
We are in a final decree proceedings.
Please.
The court has to first decide
Please.
whether the property can be divided or not.
Please.
Once it comes to a conclusion, it will give an option to the parties.
Yes.
Then you can say, yes, we are also prepared to see for ascertaining the value of the property.
Please.
Some action has to be taken by the court. Otherwise, each one will be saying, if there is understanding, that well and good, there is no difficulty.
Yes.
If there is no understanding, and each of them will be saying, no, this is the value, that is the value, court will have to do some exercise.
Please.
To find out what would be the valuation of each share. Firstly, what is the value of the property?
Yes.
If it is divided into so many shares, what would be the value of each share? This exercise has to be undertaken by the court.
Right.
Now, in view of the application filed by them, and now that they are saying, no, all right, we are not pressing on that application, we will in fact withdraw that application. The court will have to thereafter proceed in accordance with law. This, you can't insist. This is not a suit that they have filed and they want to withdraw. It's not like that.
Perhaps, my lords.
In a final decree proceedings, these are the exercise that the court has to undertake.
Please.
So now, if it is not clear whether this the property is or not, the court has to undertake that exercise now.
In the instant case, FTP proceedings has been allowed way back in the year 2015. Page 92 may kindly be seen. They
allowed.
Allowed, Miller. That's
the final
why
decree has been drawn.
Miller, for drawing, commissioner was appointed. For drawing of the final decree, Miller, commissioner's assistance was taken. Miller could kindly turn to page 103, Miller. Order that has not been challenged by them. FDP number 5 of 2006 filed and so and so is hereby allowed. Consequently, in exercise of the procedural powers under so and so, order to appoint a court commissioner to make partition suit items 1 and 3 properties and put the petition and her 1/6 share as mandated in the exhibit P1 and P2 judgment so and so. The petition is directed to take steps as to appoint court commissioner so that in such a name, the court to issue warrant to make partition of the suit item numbers 1 and 3 of the properties. Then Miller, advocate commissioner, the page 111. After 5 pages, please see how it is written, Miller. Having regard to the nature of the scheduled property, it is not possible to make division of the scheduled property into 6 equal shares. There are no other possibility of feasibility of to partition the suit premises into
ಏನು
partition.
ಸ್ಕೆಚ್ ಏನಾರು ಹಾಕಿದಾರ?
ಇವ್ರು ಹಾಕಿದ್ದಾರೆ, ADLR ಹಾಕಿದ್ದಾರೆ, and my lord, instructing counsel says photos were taken at the spot. There before the court, my lord.
ಅಲ್ಲ ಈ ಫೋಟೋಗಳಲ್ಲಿ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
ಅಲ್ಲ ಅದಲ್ಲ ರೆಕಾರ್ಡ್
There
ಇದೆ.
has to be some sketch.
Yes, sketch is also there, means. Sketch ಇದೆ. ಅಲ್ಲ ಇವ್ರು ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. Yeah, let us tell me.
So I think you are referring to the sketch at page one.
Page 137, can be seen, means. Page 137.
ಇದ್ರಲ್ಲಿ ಏನು ಗೊತ್ತಾಗೋದಿಲ್ಲ.
Correct.
If there are constructions,
ಅದೇ
ಏನು ಹೇಳೇ ಇಲ್ಲ ಅದ್ರ. Nothing is there.
ಅದೇ
If I may also.
ಫೋಟೋಸ್
proceed,
ಫೋಟೋಸ್ ಕಳಿಸಿದ್ದಾರೆ.
ಫೋಟೋಸ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
If I may also persuade the honorable court.
If you have any other information to show why it cannot be partitioned, please show it.
Okay, in terms of why it cannot be partitioned, my lords, because of the Advocate Commissioner's report itself. There are two commissioners who specifically call out saying what is the status of the property. And if I may invite my lord's attention to page 109 for the totality of understanding on what the Advocate Commissioner says. Here is page 109. One Mr. Anand Tirtha is the Advocate Commissioner appointed by the respondent before this honorable court, our court commissioner, or Namma Oralla. He says, as per the orders of this honorable court, I have been assigned to do this in para 1. The undersigned has issued notice.
ಅದೆಲ್ಲ ಬಿಡಿ.
ಅದೆಲ್ಲ ಬಿಡು. Para 4 in the following page, in page 110. My colleague, Mr. So-and-so, has informed me that surveyor was measured the suit premises as stated above through chain, and he was noted the measurements of the property. And another court commissioner advocate was present and she supervised the work of the surveyor. During the inspection of the scheduled premises, I have prepared the mahazar and taken the signatures of advocate for the petitioner, so-and-so, GPA holder of so-and-so, so-and-so, so-and-so. During the inspection at the scheduled premises at so-and-so, it is found that one motorcycle accessory shop, Maruti Car Sales and Service Center, behind the said service center, 2-story parking area, and adjacent to the parking area and adjacent to that cafeteria, shed. Since the survey has measured the entire scheduled premises with chain, I have not measured the petition scheduled premises. So he says and identifies that there are so many developments that have happened on the scheduled property. And therefore, in the end, he says, having regard to the nature.
The total extent is more than 27 guntas.
It was total of 27 guntas. BMRCL
After what was acquired by
acquired for
BMRCL?
23.5 guntas.
3.5 guntas.
Please, 23.5 guntas.
So,
Only 23.5 guntas nalli. In fact, of course, those records are perhaps not available. Nearly about 1.5 guntas is straight away taken for an exclusive access to the property behind, who has an easementary right, who is none other than me, as in one of the petitioners before this honorable court. Now, aside to that, you have certain leftover areas where there are developments that have come up cumulatively. These are large Maruti car showrooms, their service centers, bike showroom, bike service centers. Then you have generator areas, cafeterias, parking avenues that are made, and roads in between to get access to each of these areas. And therefore, there is a significant development that has been carried out within the 23 guntas of land. With these significant developments having been made, the only way that access can be achieved to each of these tenements in the property are through certain common roads in between. And the area that today they claim is, please give me the common road because that is available. Now, my respectful submission is that it is not a feasible division of the property, as also for the reason that you have to have fire engine access. We need to have setback regulations, all of those to be complied and regulated as well. One the cornerly uri kotre, it becomes then a part of either setback regulations or it becomes part of.
the learned Senate Council has pointed out that the final decree FDP has been allowed.
FDP has been allowed, which is the procedural order right in the beginning. No difficulty on that. In fact, FDP has to be allowed on the premise that they are entitled for the relevant share. Now, the conclusion of the FDP order also says, now we need to move to the next part, which is to identify whether the property is divisible or not. FDP allowance order does not say it is divisible, and therefore the division now has to happen. And therefore, advocate commissioners come to be appointed after that to verify the
ADLR
divisibility of
says,
the
my lord,
property
is-
or not.
My lord, could kindly turn to page 162, my lord. We have given the breakups, my lord. Calculations we have given. 1 gunta is 1089 square feet. And I will be entitled for 4.5 guntas.
Allah, this is legitimately.
True. And no,
Not
Practically.
what the ADLR
whether it
says
is
is,
practicable
Please.
or not is
what the
something
ADLR says is,
that is the purpose for which the court commissioner
yes,
is appointed.
yes, what
But
the,
if they have not undertaken that exercise,
No.
I don't think it's a.
no, what
May I also
the
make this
ADLR
sub-
says is, I was not asked to divide, it can be done. He was not instructed to divide, minute, he can be now directed to divide, minute. It is permissible.
Our divide ಮಾಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ.
Sir, but there is one problem. Even according to the Partition Act, wherever there is a dwelling house, the dwelling house would include all car park anta adante whatever everything is to be part of the dwelling house, you will not be permitted to divide it. There are some problems. So, but basically that exercise has not been undertaken at all.
No, let them, that's what I said, let them examine that matter.
You please, if you say, I will note down that you will withdraw the
Please,
application
that can be recorded.
and but no useful purpose would be served considering the subsequent application filed by them.
Please, Roshan.
Oh, I will direct the court to conduct the court commissioners to
ADLR.
properly give them instructions as to what is required to
Warrant
be
should
done.
be proper, means properly worded. Your Lordship.
They have to say, they have to make a sketch and show if constructions have come up, where they have come up, what is the type of construction, what is being done in that building.
Please, sir.
All information has to be given. And they have to then state whether it can be divided or not.
Your Lordship, that can be.
I exercise madilla illi.
Sketch ಅನ್ನೋದು ಮಾಡಿಲ್ಲ.
Madilla.
But
Can be done.
Without that sketch, it is not possible for the court to come to conclusion.
Your Lordship,
Whether it
record
is
our
divisible
submission
or
that we are withdrawing the
may
time.
make this submission. My lords, of course, are absolutely right on this
Yes.
matter. But the coordinate bench of this honorable court, my lords, I have furnished the judgment.
Yes.
An earlier matter in 2015, order comes to be passed. ಅದರಲ್ಲಿ ಕೂಡ ಹೀಗೆ ಆಗತ್ತೆ. During the course of the proceedings, my lords have Satyavelu's judgment.
Yes.
In Satyavelu's judgment, para 2, if I may read, my lords, it's a short thing to read. The facts leading to the filing of these petitions are as follows. Pramila, Prabhakar, Puglavani and Vinodini were plaintiffs in OS so-and-so. They chose to file the suit for relief of partition and separate possession against the petitioner G. Satyavelu and 6 others in respect of house measuring so-and-so. Said suit came to be decreed on so-and-so date, granting 1/8 share to each of the plaintiffs. After obtaining preliminary decree, the plaintiffs therein chose to file final decree proceedings in terms of so-and-so for demarcation of the share by meets and bounds.
Yes.
During the pendency of the suit, a commissioner was appointed to ascertain the feasibility of partition of the suit property in terms of the decree passed in OS so-and-so. Mr. Devapan, architect, was appointed as commissioner of the court. He has submitted a report stating that it is not feasible to divide the property into 8 parts and that putting the property to sale in open market is only avenue. As per the report dated so-and-so, the guidance value of the property was at so-and-so per notification of the department. Next paragraph, that's relevant. During the pendency of the petition, one of the parties died and therefore 1/8 share is modified to 1/7. An application came to be filed by IA3 by the petitioners, therein requesting the court to order for sale of the scheduled property through public auction and to distribute the sale proceeds as per their entitlement. Said application was filed in terms of section 2 of the Partition Act, read with 151 CPC. After hearing the learned counsel for the parties, the following order came to be passed by the learned judge, appointing so-and-so as civil architect as the court commissioner to execute sale warrant. IA number 3 filed under section 2 of the Partition Act is allowed no cause. Advocate for a petitioner prays to appoint earlier court commissioner to execute warrant and to sell scheduled property in public auction. Hence, so-and-so is appointed as court commissioner. Court fee is tentatively at so-and-so, deposit commissioner's fee. Later on, an application was filed by this petitioner, first respondent FTP, in terms of section 3 of the Partition Act, read with 151 CPC, to permit him to purchase the shares of other co-owners in respect of the scheduled property and to ascertain the value of each share and offer to sell the same to him in the interest of justice. The said application was objected by the petitioner therein by filing detailed written statement. Ultimately, the learned trial judge allowed the said application filed under so and so under section 3 of the Act, in part permitting this petitioner and the petitioners in FDP proceedings to participate in the public auction for sale of the property. After this order was passed, an application was filed by this petitioner requesting the court to review the order passed on IA number 4. Said application is supported by an affidavit sworn by the petitioner. According to him, there cannot be any public sale as per section 3 of the Partition Act, and there can be a sale only amongst the sharers, and that would be to protect the dignity of the family's sentiments. According to him, several authorities cited by him were not considered by the court, and no reserve price was fixed before ordering sale, and therefore the order dated so and so are opposed to mandatory provisions of the law. Said application was objected by the respondents on and 4. Ultimately, the learned judge has chosen to dismiss the said application, as these orders which are called in question in these petitions on various grounds as set out in so and so. Now,
That
if I
question will
may
arise
request my lord.
only if my application is not there. Since I am withdrawing that application, that question will not arise.
ಅಲ್ಲ ಒಂದ್ಸತಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕದ್ಮೇಲೆ ವಿಡ್ರಾ ಮಾಡೋದು ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Withdraw ಮಾಡಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ ಬಂದಿಲ್ಲ.
That is not the
I'm
only.
pointing.
It has to be clear.
Please.
That's,
The court
it's not
had to
divisible.
record a finding,
That is
having
not-
regard to the reports filed, that it is not possible
Yes,
to divide the
that's,
property.
yes,
That exercise has not been undertaken in this case.
in the instant.
If we,
I agree with it.
That is the basic thing that is required.
if I may submit my lord. On a reading of the Partition Act, section 2, in my respectful submission, it would also imply that it is not necessary that only in those circumstances will the court go ahead and ask for auction of the property. It in fact gives a provision for a residuary situation also. And if I may read section 2 for that purpose. Section 2 says power to court to order sale instead of division partition suits. Whenever in any suit for partition in which, if instituted prior to the commencement of this act, a decree for partition might have been made, it appears to the court that by reason of the nature of the property to which the suit relates, or the number of shareholders therein, or any other special circumstance. Therefore, this is a residuary provision, or any other special circumstance, a division of the property cannot reasonably or conveniently be made, and that a sale of the property and distribution of the proceeds would be more beneficial for all the shareholders. The court may, if it thinks fit, on the request of any such shareholder interested, individually or collectively to the extent of one moiety or upwards, direct a sale of the property and distribution of the proceeds. So my respectful submission is that if there is any other special circumstance, then it is for the court anyway to go ahead and allow for the auction of the
What is
property.
that special?
In my case, the special circumstances, they themselves having come to the court and asked for sale of the property, and that is the special circumstance.
There
Therefore, it's not
also-
mandatory at all instances is my respectful submission.
There also, they are of the opinion that it is not possible to divide the property.
Please.
I do not know how they came to a conclusion.
Ala,
Whereas the court said, on the basis of any report filed by the court commissioner, that the court has come to such conclusion.
Please.
That has also not happened.
ಹೇಗಾಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ ಒಂದು ಗಾದೆ ಇದೆ the proof of the pudding is in eating ಅಂತ ಹೇಳ್ತಾರೆ.
That's all.
Right? If they have themselves come and acknowledge the fact that this is clearly not partitionable or divisible, it is on that premise they have come to the court and filed the application, and that also cannot be lost sight of. ಅವರೇ ಬಂದು ಹೇಳಿದ ಮೇಲೆ even they are clearly under the understanding that this is not a divisible property, and that is their affidavit as well. And we cannot now derogate from their affidavit, nor can they derogate from their own affidavit.
But this court is not able to find anything on record.
Please.
It is not divisible.
To show why the property is not divisible.
May I make this?
Neither is the court recorded that finding.
I understand. ಅದು ಇನ್ನ ಅಲ್ಲಿಗೆ ಬಂದೇ ಇಲ್ಲ.
ಬಂದೇ ಇಲ್ಲ.
In fact, what happened was that once the commissioners also placed their records before the court, they were not cross-examined by the respondent before this honorable court. Petitioners have not even cross-examined them. When the advocate commissioners categorically said that this is not divisible, they have not cross-examined. The implication of that also is that they go by the report of the commissioner. They've chosen not to cross-examine, which means they've chosen not to controvert the reports of the commissioner.
Did we call for the records in this matter?
Yes, my lords.
Your lordship had come. It has come in.
In fact, the records will.
If you are able to point out anything from the record, yes, this is the reason why it cannot be divided.
Even my application is not disposed.
Those records, my lords, will I have already produced as part of my petition. It will be no
So
different.
there's
my lords.
nothing more.
Nothing.
There's nothing more, my lords. There's nothing
When
more.
my application is not yet disposed. So therefore I can withdraw that.
If that is indeed the case, my lords, may I make one submission?
Yes.
My lords would appear to now make an order for appointment of a commissioner to carry out these
Yes.
proceedings.
Court should have given proper instructions.
Please.
In fact, it should have called upon both the sides to give memo of instructions.
Kottidvi.
So the report was to be, the inquiry was to be carried out in terms of the
Warrant.
instructions.
Those might be available on the trial court records which are before this honorable court. There are instructions given by both the parties specifically catering to these issues.
Yes.
And based on those instructions, the advocates have carried out the commission and have placed the report categorically saying that this is a property that cannot be divided. The only thing that could be missing is a sketch aste. Adu bitre, everything else alludes to the fact that this property is not divisible. It's already there on record before this honorable court. Those instructions likely will also be on the record before this honorable court. Trial courts mandirat. That I'm not aware of, my lords. Those I have not filed either with the petition. But if I'm able to ascertain from the records of the court, then I can.
Record idra ಕೊಟ್ರಿ ಅವ್ರಿಗೆ.
Instructions Ibru party kuda hakidvi trial court.
But as I was pointing out earlier,
yes,
in this partition suit, that difficulty arises when there is a dwelling house.
There is a dwelling house as well.
Idra kashtane ma.
Dwelling house is there. One of the petitioners lives there. There's a dwelling house. Our compound is there.
As far as possible,
yes, Manoj.
Option should be given to that person.
Please.
Who is dwelling in that house.
To acquire.
Purchase the shares of the other persons, if
Please.
possible.
Please. In fact,
if that is also not possible, then
illa, all the other respondents for petitions before this court are aligned. They all sail together. It is only the petitioner who is not sailing. And as my lords rightly pointed out, if there is a dwelling house person living there as a family.
Who is residing there? Not this person.
No, not that.
Not this person.
Not that person. One of the petitioners, my lords. I will need to ascertain that, my lords, because I don't recall offhand. One of them does live there. I can verify that and submit to this honorable court. I do not want to make an incorrect submission before this court.
Nobody is residing there. It's only some shops are there. The shops can come to the share of one or the other person. They're dwelling, residing there, there's one thing. They're not residing there. And taking advantage of the fact that suit is pending for the last 30 years. They have been developing the property.
Section 4 talks of that dwelling house.
Please.
But that should be only a dwelling house.
There are other tenements other than dwelling house also.
So therefore,
And
all
to
these
be-
aspects have to be taken into consideration by the court commissioners.
Please.
All this information should have been placed along with the sketch showing this is how it is. And if it's possible to divide, it can be divided like this. Otherwise, they should say, this is why it cannot be divided.
The otherwise is what has happened in this case.
Huh?
The otherwise is what has happened in this case. And that. The court commissioner goes on to say that it cannot be divided.
Anyway, I will record the undertaking of the learned senior counsel that they will withdraw that application.
If that could be omitted, because my respectful submission still is that it cannot be withdrawn, because once they have taken a certain stance before the court, the withdrawal will necessarily mean approbation. And that, my lords, cannot be permitted. Once they have said that they want this, that they cannot be permitted to
But the
withdraw.
prerequisite for that is that the court has to come to a conclusion, it cannot be divided. As a stage bandila inno.
If I may also make this submission for my lord's consideration, notwithstanding that particular stage having come or having been incorrectly concluded.
Yes.
If a party nevertheless comes to the court and says, no, I want only sale proceeds proportionate to my share and nothing more, then would the court even burden itself to go into the rest of the procedures once they've asked for it is the other question, my lords. And that question also assumes significant importance. Once they are ಕೇಳಿದ ಮೇಲೆ ತಿರ್ಗಾ do we go back and do all of these things? Especially when it appears, my lords, with the judgments that are placed before my lordships, that once the position has been taken, that cannot be withdrawn.
Court had passed an order on that. No orders are passed still till date on my application. Therefore, having filed an application is always, I can withdraw that application.
Withdraw ಮಾಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ.
What is actually, see, your party is aged about 84 years now.
Yes.
What is it that she wants?
And bedridden.
They want their father's property, they want to enjoy.
ಇಬ್ರು ಮಕ್ಕಳಿದ್ದಾರೆ, ಅವರು ಇಂಡಿಯಾಲಿಲ್ಲ, US ಅಲ್ಲಿದ್ದಾರೆ. The rest of the people are enjoying the property.
So her one child is buried there in one of the properties in that area. So therefore, they have sentimental value for her. Her son has been buried there.
ಅದೆಲ್ಲ ಇದ್ರೂನು ಇದರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಲ್ಲ ನೀವು.
No, application because of the judgment of the Honorable Supreme Court.
Right.
So we wanted to buy the entire property.
Huh?
We wanted to purchase the entire property. That's what the Supreme Court says, Millard. The sale should be between the parties, not just for share.
Really, where is your application? Page number? Our application page number ಏನು?
144.
And there the Supreme Court judgment ತಾವು ನೋಡ್ಬೇಕಾಗುತ್ತೆ. Our entire reliance is on that.
You were asking for handing over the sale proceeds.
Oh, specific ಆಗಿ.
Yes. No.
You also accepted the fact that it is not possible to be divided and therefore you put it for auction. Give me my share.
Placing reliance on that, that's what I said. Let me read the entire judgment of the Honorable Supreme Court, the directions given.
ಅದರಲ್ಲೂ ಅಷ್ಟೇ, the first sentence is,
yes,
if it is
not possible.
ಅದೇ.
But here it is possible.
Then why did you file the application?
No, because of the judgment of the Honorable Supreme Court.
The judgment of the Supreme Court is also again the same thing.
No, wherein
it
the
is not
sale is
possible
between
to
us.
partition anta.
Wherein the sale is between us. Wherein the sale takes between us. Even today, Millard, I am ready for sale if it is between us. We'll have the sale auction between us. We are ready for that.
No, but our affidavit ನಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ, this cannot be partitioned by meets and bounds ಅಂತ they specifically said. ಅವರೇ ಹೇಳಿದ್ದಾರೆ. If we read, coming back to 148, my lords, which I had read initially,
Perfect.
they themselves say that our case is exactly the same. It cannot be divided by meets and bounds ಅಂತ affidavit ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
Have you gone through the records? Has the court come to a conclusion that it is not possible to divide the property?
That decision has not been passed by an order, my lords.
The petitioners who are respondents before the trial court considering the final decree proceedings, are aggrieved of the impugned order, whereby their application in IA number 2 filed under section 3 of the Partition Act was rejected. Full stop. Next paragraph. Learned counsel for the petitioners submits that the respondent had earlier filed an application
IA 1 of 20
in IA number 1
of 24.
of 2024 under section 54, 64, read with section 151 of CPC, with a prayer to direct attachment of the scheduled property, semicolon, to direct sale of attached property and to hand over the plaintiff's share of the sale proceeds to the plaintiff petitioner. Full stop. Learned counsel pointed out from the affidavit filed along with the application that having regard to a judgment of the Honorable Supreme Court in the case of Vikrant Kapila versus Pankaj Panda, reported in 2023 SEC Online SC 1298, the applicant sought for the sale of the suit scheduled property and further sought for the sale of the sale proceeds, share of the sale proceeds to be handed over to the plaintiff. Full stop. Having regard to the said application filed by the respondent, the petitioner herein also filed IA number 2 under section 3 of the Partition Act.
Section 2 of the partition.
3 ಅಂತ ಹಾಕಿದ್ರ ನೀವು in the application.
ನಮ್ಮದು 3.
ನಿಮ್ಮ application.
ನಮ್ಮ application.
Yes, yes.
I'm sorry.
To permit the petitioners herein to purchase the share of the respondent in respect of item number 1 of the suit scheduled property. Full stop. The said application has been rejected. On the ground that the parties have not made out a case to show that the property show that it is impossible to divide the property. Full stop. Learned counsel for the petitioner, however, seeks to place reliance on a decision of the Honorable Supreme Court in the case of R. Ramamurthy Iyer versus Raja V. Rajeshwara Rao, bracketed 1972, close 2 SCC 721, wherein it was held that when the other shareholder applies for leave to buy at a valuation, the share of the party asking for a sale, the court is bound to order valuation of his share and offer to sell the same to such shareholder at a price to be ascertained. Full stop. It was also pointed out that in paragraph number 12, it was held that it was difficult to accede to the contention of the appellant therein, that the suit can be withdrawn by the plaintiff after he has himself requested for a sale under section 2 of the Partition Act, and the defendant applied to the court for leave to buy at a valuation, the share of the plaintiff under section 3. Full stop. In that view of the matter, learned counsel seeks to contend that it would now be impermissible to permit the respondent to withdraw the earlier application filed in IA number 1 of 2024. Full stop. The learned counsel would therefore submit that the impugned order is required to be set aside while permitting the petitioners herein to purchase the share of the respondent in item number 1 of the suit schedule property. Full stop. Next para. For contra, learned senior counsel Shri Puttige Ramesh, appearing for the respondent, would submit that the application in IA number 1 of 2024 was filed by the respondent having regard to the law laid down by the Honorable Supreme Court in the case of
Kapila.
Vikrant Kapila versus Pankaj Panda, as could be found in paragraph number 16 of the affidavit filed along with the application. Full stop. However, having regard to the findings of the trial court in the impugned order that the parties are not able to show that it is impossible to divide the property, the learned senior counsel would submit that the respondent should be permitted to withdraw IA number 1 of 2024, since it was filed on a wrong premise that the property cannot be divided. Full stop. On the other hand, it is now the contention of the respondent that she has a sentimental value attached to the property and she would like to retain a portion of the same, if the property can be divided. Full stop. Next para. Having heard the learned counsel for the petitioner, the learned senior counsel for the respondent, and on perusing the petition papers, this court is of the considered opinion that the trial court, considering the final degree proceedings, has rightly come to a conclusion that the parties are not in a position to show that it is impossible to divide the property. Full stop. The basic requirement in terms of section 2 of the Partition Act is that the court should come to a conclusion that it is impossible to divide the property. Full stop. No material is placed before this court to show that the court has come to a conclusion having regard to the reports filed by the court commissioners that it is impossible to divide the suit schedule property. Full stop. In that view of the matter, this court does not find any infirmity in the impugned order. Full stop. At this juncture, it should also be noticed that the learned senior counsel appearing for the respondent has submitted, and it is placed on record that the respondent will withdraw IA number 1 of 2024. Full stop. Next para. The writ petition is accordingly disposed of, while permitting the respondent to withdraw IA number 1 of 2024. Full stop.
If I may.
The parties are also permitted to file necessary application to appoint court commissioner with proper instructions to ascertain as to whether the suit scheduled properties can be divided or not. Full stop. That would be the basic requirement that would enable the parties to proceed after the court comes to a conclusion that the property is impossible to be divided. Full stop. On the contra, if the court comes to a conclusion that it is possible to divide the suit scheduled property, then the first option would be to divide the property by metes and bounds and allot the share to the parties. Full stop. Ordered accordingly.
Some time limit we fixed.
Huh?
Some time limit, and court commissioner may be from revenue department. means.
Allah, the provision says if it is a revenue land, then the Tahsildar has to be appointed.
Tremendous.
Or any officer above the grade of Tahsildar. The provision itself says so. So if it is not a revenue land, you cannot ask for appointment of Tahsildar. But of course, you can still ask for the help of the revenue authorities, because chain links or if it is a larger property, it is not easy for an advocate to undertake this exercise. For that purpose, you can seek the assistance of the revenue authority, survey settlement authorities.
That observation.
Necessary application have to be filed.
In fact, in a matter like this, an advocate commissioner may also have to come into play only to oversee whether they are doing it properly. There is a legal aspect of how it needs to be done according to the provisions of the CPC and Act.
No.
The authorities may not themselves understand that.
Report, adikkene instructions kodabeku. You have to give instructions according to you what you feel is right. They also will be permitted to do so. And the common issues can be taken into consideration, and you will file a report. That will be not final. You can cross-examine the court commissioner
Please.
on any aspect of the matter which you say is not correct. Thereafter, the court has to come to conclusion. That is why I have said the court has to come to conclusion.
Correct.
That exercise has not been undertaken at all.
Please. And if I may only make one submission. I would be completely remiss in my duty if I did not bring to my lord's notice one particular aspect. It's only in the context of that IA1 being permitted to be withdrawn. So one judgment of the Supreme Court, my lords, of 2018, which would say that, if I may. My apologies, my lords, I should have brought it to.
Idrallo bantalla, I have recorded that.
Adalla. This is only on the aspect of the last page, if my lords could turn to.
Yes.
Para 12 and 13, the Supreme Court says that, my lords, a litigant can take different stands at different times, but cannot take contradictory stands in the same case.
So therefore, see.
So once they take a stance, then estoppel kicks in. Anta Supreme Court ಹೇಳುತ್ತೆ. ಹಾಗಾಗಿ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ, they may not be permitted to withdraw that application.
If it is based on a wrong premise, why not? They have said,
please,
in view of the judgment of the Supreme Court, we have filed this application.
Illa.
Alli
Identical set of facts.
Para 17, they say.
Avaru helidare, I have recorded it in paragraph number 16, they have said so.
17 ನಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ, Supreme Court says in that case.
ಅಲ್ಲೂನು ಅಷ್ಟೇ, Supreme Court judgment ಅಲ್ಲೂನು ಆ judgment ಅಲ್ಲೂ ಅಷ್ಟೇ.
Yes.
The basic requirement is the court has to come to a conclusion that it is impossible to divide ಅಂತ.
Right.
ಆ ಎಕ್ಸೈಸ್ ಆಗೇ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
ಅದಾಗಿಲ್ಲ, but ಇವ್ರೇನ್ ಹೇಳ್ತಾರೆ,
Holding the gun, if they have said, yes, you can, we will, please proceed to auction the property.
ಇಲ್ಲ, jumping the gun, what they say is that ours is exactly the same case. ನಮ್ಮಲ್ಲಿ ಕೂಡ partition ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ section ಅಲ್ಲ para 17 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅವ್ರ affidavit ನಲ್ಲಿ. That is what they have said. Even according to them, it is not divisible anta. I understand where my lords are coming to say that unless that process was concluded, even if they made that statement, it may not be incorrect. I understand, my lords.
The records may be ordered to be written.
Huh?
Records may be ordered.
Ah. The original records are directed to be transmitted to the trial court forthwith.
Please.
I'm deeply obliged. I'm sorry, my lords, if I took more time than I should have.
11.
Lords, suit for enforcement of right of easement. Lords, may it straight away take your lordships to a sketch, my lords, so that I can explain, my lords, what the page number. Which page? 30? Page number 31. Lords, that rough sketch your lordship gets it. Lords, in this, on the right hand side, your lordships will find A schedule property 174/1, that is my property. Lords, then the C schedule property, there is a mention, my lord, this is the road which we claim that we have right of easement. E schedule property is another 12 feet is there. Both put together, my lords, is about 32 feet road which leads up to my property. This is the claim and contention with which we went before the court, saying that I have an access from C schedule property as also E schedule property to A schedule property, therefore protect my rights of easements. Now, the person who is blocked is survey number 173/2, my lords, your lords will find 173/2. He has blocked at point A and D and point B and C. He has blocked it. Then the neighboring owners, my lords, they have blocked E and H and F and G. These 3 points are blocked. This is not a disputed fact. They say that yes, we have blocked it because you don't have a right of way. Now, written statement was filed by these defendants. In the written statement, I have asserted that I am the owner of A schedule property. Defendants say it is here, but it is denied that you are the owner.
Who has filed the suit?
The plaintiff, my lords, A schedule property owner.
Has filed the
Yes, I have filed the suit.
Yes.
In the pleadings, I say that I am the owner of the property. This was our ancestral property, so and so. Then there was a registered partition deed in which the property has come to me. Registered partition deed is produced. Revenue documents are produced. Defendant files a written statement saying that the contention of the plaintiff that he is the owner of the property is hereby denied. See, this is the nature of defense which has been filed by them. And further, they say that there is no easement as such. This is their property. This is all what they say. Notice the trial court says, since there is a denial of your title to the property while filing the written statement, and in the suit which we had filed pertaining to one more property, 172/1, that is next property to 173/2, where you have not referred to the existence of the road, and even in my partition deed, there is no reference to the road. It is held that you are not entitled to the right of access at this stage. That is the order of the trial court, which is confirmed by the first appellate court. Notice, whenever I claim that I have a right of way to my property, first question is whether I have any other way through which I was passing through the property. This is the first question to be answered. If not, then right of easement should be presumed, my lords.
But the manner in which this sketch is made.
Drawn, yes, my lords. Lords, this
is it revenue lands?
These are revenue lands. These are revenue lands. Lords, the 12.5 guntas, my lords. 174/1 is 12.5 guntas. 12 gunte. ಅದೆಲ್ಲ ಅಷ್ಟೇ ಇರೋದು 8 ಗುಂಟೆ 10 ಗುಂಟೆ ಆ ತರ ಇದೆ ಪೂರ್ತಿ ಪ್ರಾಪರ್ಟೀಸ್.
So revenue sites are formed.
Revenue sites, notes the property.
Revenue sites.
Not the property itself is measuring these extents 12.5 guntas, 8 guntas. Survey number 173/2 is only 4.5 guntas. Like that, the properties are divided. Now the question, my lords, is this: the court asks itself a wrong question. Whenever a person comes to the court saying that he has a right of way and this is the only way through which he has an easementary right, the court should ask the question, if he had any other way, then I will have to independently establish that I had this right of way. Lords, may I just refer to the judgment of the Supreme Court? What should be done in such circumstances? I'm sorry, my lords, that's a marked copy. I'm sorry. Sorry. Lord, this is exactly the same case which presented itself before the Supreme Court. Para 24. Lords, Lords, I will read from the sentence at Placitum E at para 24. It is also not in dispute that the appellants were not able to establish that the original plaintiff, since deceased, was using any other pathway for access to a scheduled property of the plaintiff and the building therein, which is in occupation of the original plaintiff. The case of the appellants that since there was no mention in the deed of settlement enabling the use of B scheduled property for access to A scheduled property and the building therein, cannot be the reason to hold that there was no grant, as the grant could by implication as well. It is not in dispute that the fact of use of B scheduled property as a pathway even after execution of Exhibit A1 settlement deed in 1982 by the original plaintiff would amply show that there was an implied grant in favor of the original plaintiff relating to B scheduled property in favor of the plaintiff for its use as a pathway to A scheduled property of the plaintiff in residential occupation of the original plaintiff. In the absence of any evidence being adduced by the appellants to substantiate their contention that original plaintiff had an alternative pathway for access to A scheduled property, it is difficult to negative the contention of the respondent that since the original plaintiff had continuously been using the pathway at least from year 1940, original plaintiff had acquired easement right by way of implied grant in respect of B scheduled property. Here is a case where they don't even take a plea that I have an alternative road. Now let's just kindly take page number 40. The agreement of sale executed by the defendant is at page 32, which is on 21/9/2015. It's a registered document. Let's kindly have a look at page number 40, 173/2. Let's and juxtapose this with this sketch at page 31. 173/2. ಬೊಮ್ಮಸಂದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 173/2 ವಿಸ್ತೀರ್ಣ 24 ಗುಂಟೆ ಪೈಕಿ 6 ಗುಂಟೆ ಜಮೀನಿಗೆ ಚೆಕ್ ಬಂದಿ ಪೂರ್ವಕ್ಕೆ ಇದೇ ನಂಬರ್ ನಾವು ಉಳಿಸಿಕೊಂಡಿರುವ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಕೃಷ್ಣಪ್ಪ ಬಡಾವಣೆಯ ಸ್ವತ್ತು, ಉತ್ತರಕ್ಕೆ ಇದೇ ನಂಬರ್ನಲ್ಲಿ 20 ಅಡಿ ರಸ್ತೆ. This is in 2015 by the defendant.
173/2.
ಅದರೊಳಗೆ ನಾವು ತೋರಿಸಿದೀವಿ 173/2. This is exactly the property which we are claiming as the pathway. Now, if your lordships were to see the findings, lords, of the trial court, lords, it's a very, very critical findings, lords. Page number 107, the reasoning starts.
Application on 39
rule 1 and 2. Lords, at page 109 is the consideration. Second para, as per the Easement Act, it is the right of a person who enjoys in others' property for the beneficial enjoyment of his own land. In the present case, plaintiff has denied title of defendant number 1 over the B scheduled property and has contended that he is falsely claiming title and interest or portion over 172/1, measuring 3 guntas and 3.5 guntas. When plaintiff has denied the portion and title of the defendant over property, she cannot claim easement from the defendants. Notice, it's merely a case of denial. I can understand if the defendant sets up a title in herself, saying that I am the owner, you are not the owner, this is how I have the title to property, I can understand. No, written statement is a case of denial. And then the document, next paragraph. The plaintiff is claiming rights over the scheduled property under the partition deed of 29/5/2002. Plaintiff has produced the copy of the partition deed. On perusal of the partition deed, it's clear that in the scheduled set partition, there is nowhere mention about the alleged road, similar to the case which I now referred. If the trial court records a finding, I have any other road, then I don't have a case.
So the regular appellate court also is
exactly the same wordings. Lords, at page number 136, last 3 lines. Under such circumstances, the plaintiff has failed to make out a prima facie case as discussed above. Plaintiff has denied the ownership of defendant number 1 with reference to B scheduled property. Question of claiming easement right does not arise.
136.
136 minutes.
136 only?
Last 3 lines. Last 5 lines. Therefore, the plaintiff has not approached the court with clean hands. In order to get the equitable relief of injunction, the plaintiff shall approach with clean hands. These 2 suits are the suits for partition. Next. Under such circumstances, the plaintiff has made to make out a prima facie case. As discussed above, the plaintiff has denied the ownership of defendant number 1 with reference to B scheduled property. question of claiming easement right does not arise. Further, the owners of escheatable property is not made as parties. This is factually incorrect because I have clearly admitted to the ownership of the different number 1 with reference to B schedule property because there are about five siblings to my father. 4 siblings have sold the property in favor of different number 1. I say your share, your purchase is restricted to 1/5 share, 1/5 to 4/5 share, 1/5 share I am entitled to partition is the suit for partition filed. That essentially means I am admitting his title to the property. But the trial court record, the first appellate court says that you are denying his title by filing a civil suit. That's not correct. I filed the plain copy also. I am admitting his title to the property. Lords, as things stands, I have absolutely no road to go to my property. It is completely landlocked. The photo could you Lords, may I just pass on this, Lords. I'll just mark this.
This is a suit for?
Lords, this is a suit for declaration of easementary rights.
And you have also filed a suit for partition.
Lords, partition in respect of a different property. Lords, if your lords were to see that the place where I put the cross mark is my property. Lords, I have marked it, Lords, as per the sketch, wherever the markings are come, B and C is this place. This clearly indicates it was used as a road at some point. Now they have blocked it. Idella haki block madidare. And F and G is the block, Lords, which I have indicated here. Now absolutely no way to go to my property. One more coordinate bench view, Lords. Of course, this was after commissioner was appointed, but the view taken is until and unless the court comes to the conclusion that there is an alternative way, a right of easement claim should not be denied.
ಯಾವ paragraph?
Let's paragraph number 33. The core issue or the point of dispute between the plaintiff and the defendant is relates to access of the plaintiff in survey number 97/2. On the other hand, the plaintiff is content that ingress and egress to his land is through survey number 113 and 114. There is no other access to his land and is an easement of necessity, whereas defendants 4 to 5 have contended that in order to have an access of 97/2, plaintiff has to pass through so and then enter his land situated 97/2. Since the plaintiff is content the road or car track path with his land in survey number 97/2 as indicated or suggested with the fifth defendant is not in existence, fifth defendant asserting that their existence of a road or pathway or car track is pointed up a court commissioner has submitted a report along with the sketch. Court commissioner's report in the nature of answering the memo of instructions filed by both parties came to be marked as so and so. In reply to memo of instructions of defendants, it has been stated by the court commissioner. Notes after extracting the reports of the court commissioner, then at page number, paragraph number 30, 38 and 39.
This will be on the merits of the matter.
This is ultimately the point was the question to be answered while dealing with any easementary suit is
39 rule 1 and 2.
39 rule 1 and 2. The first question to be asked is whether there is any other right of access. Now I will come before the court and say, this is the only road through which I am accessing the property. This is by easement of necessity as well also by prescription. I have perfected my rights of easement over this property. Unless the defendant takes the plea that there is any other approach road to this property, then my plea is to be accepted. That is what the Supreme Court says. I could not have dropped from heir into my property. It should have been used somewhere. And his document itself shows that there is a 20 feet road.
You have put up construction.
Yes, minutes.
Huh?
Yes. Now I am unable to access that. The defendant also admits, minutes, that I had put up a construction and I was carrying out a cottage industry. He says that this industry should not have been done because this was an agricultural property. That's the nature of defense. But he is admitting.
Issue notice to the respondents. The petitioner is also permitted to serve copies of the petition along with annexures in the learned counsel representing the respondents before the trial court. Full stop. Next para. Learned Senior Counsel Shri D.R. Ravi Shankar, appearing for the petitioner plaintiff, submits that the application filed by the petitioner plaintiff under Order 39 Rule 1 and 2 ಅದೇನು initially ad interim temporary injunction was granted.
That's initially ad interim temporary injunction was granted. That injunction order was vacated by virtue of the order impugned in the first appellate court.
Has been rejected after initially granting an ad interim ex parte temporary injunction restraining the defendants from obstructing or closing
C and E schedule properties.
C and E schedule property which form the access to the
It's A schedule property.
to A schedule property belonging to the plaintiff. Full stop. Learned Senior Counsel submits that the trial court has proceeded on a wrong footing, noticing the stand taken by the defendants that they deny the title of the plaintiff in respect of A schedule property. Full stop. Although such a stand is taken by the defendants, it is not supported by any documentary evidence. Full stop. On the other hand, the plaintiff has also filed one more suit for partition.
Please.
In OS number?
That's 905 by 2023.
2023. Seeking partition and separate possession, not in respect of the suit schedule properties, but in respect of some other immovable properties which belonged to the joint family of the plaintiff.
Lords, it is in respect of, I'll just correct it, Lords. It is in respect of survey number 172/1, through which the C schedule property also passes. Page 163, I produced the plain copy.
In respect of survey number 172
bar 1.
Which also has an access through the same road, which further reaches suit schedule A property.
Yes.
Full stop. Learned Senior Counsel submits that in a suit seeking easementary rights, what was to be considered by the court is whether the other party has taken up any contention that there is some other access available to the plaintiff to reach the suit schedule property. Full stop. It is the contention of the plaintiff that other than the access through B schedule property,
By C and E schedule property.
C and E schedule property, comma, the plaintiff has no other access to A schedule property. Full stop. Moreover, the plaintiff has admittedly put up a construction over
A schedule
schedule A property. And he was accessing the suit schedule A property only through suit schedule C and E of the suit schedule property. Full stop. Now, by denying the interim relief sought by the plaintiff, comma, the plaintiff has been put in such a situation where he cannot access A schedule property. Full stop. In this regard, learned senior counsel would also place reliance on a judgment of the Honorable Supreme Court in the case of Shri Swayam Prakash Ashramam and another versus G. Anandavalli Amma and others, bracket 2010, close 2 SCC 689, wherein it was held that in the absence of any evidence being adduced by the appellants to substantiate their contention that the original plaintiff had an alternative pathway for access to A schedule property, comma, it is difficult to negative the contention of the respondents that since the original plaintiff has been continuously using the said pathway at least from the year 1940, comma, the original plaintiff had acquired an easementary right by way of an implied grant in respect of B schedule property of the plaintiff. Full stop. Learned senior counsel submits that the First Appellate Court has also passed similar orders on the same lines as was passed by the trial court. Full stop. Learned senior counsel submits that both the courts have failed to take into consideration the balance of convenience and the irreparable loss that would be caused to the plaintiff if the application for temporary injunction is not granted. Full stop. Next para. Unless yes, the learned senior counsel would also submit that no prejudice will be caused to the defendants if the order of temporary injunction is granted in favor of the plaintiff, comma, since it will not in any way prevent the access to the properties of the defendants. Full stop. Next para. Consequently, there shall be an ad interim order of stay.
Lords, page 72, my lords, interim order, they have sought for stay of the orders, which is not correct. Page 72 is the nature of order which I am seeking, my lords, page 72. Restraining respondents 1 to 5 from obstructing or closing C and D schedule properties.
Of stay of the impugned orders dated 27/1/2024 and 6/4/2024 at annexures
L and M2. L and M2.
L and M2 and further the respondents herein are directed not to obstruct or close the C and D suit schedule properties which provide access to A schedule property, comma, till the next date of hearing.
Please. Great. My lords, one submission, my lords. My lords, this is a ground rent matter, my lords. I am requesting it to be tagged along with the batch matters. I have gone before the my lords.
Serial number 12, my lord. Other side is there, my lord. We'll seek for adjournment, my lord.
With my lord.
Serial number 12.
Yaru?
Time for the respondent.
12.
My lord. There's compromise is going on, my lord.
Howದಂಡ್ರಿ?
I will seek the instruction from my client.
Huh?
I will seek instruction from my parties.
Serial number 12 at the request of learned counsel for petitioner. Release this matter after Dasra vacation.
Humble submission, my lord.
My lords, this matter may be.
MO is missing.
ಗ್ರೌಂಡ್ ರೆಂಟ್ ಮೇಲೆ ನಾನು ಸಿಜೆ ಮುಂದೆ ಹೋಗಿದ್ದೆ, ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದು ಆರ್ಜೆ ಮುಂದೆ ಹೋಗಿ, ನಾನು ಸಿಜೆ ಮುಂದೆ ಹೋಗಿದ್ದೀನಿ, ಅವ್ರು ಹೇಳಿದ್ದು ಆರ್ಜೆ ಮುಂದೆ ಹೋಗಿ ಅಂತ. ಇವಾಗ ಫೈಲು ಬೋರ್ಡ್ ಅಲ್ಲಿ ಇದೆ, ಸಾಹೇಬ್ರದ್ದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಮೇಲೆ ಟ್ಯಾಗ್ ಮಾಡ್ತಾನೆ ಸರ್.
ಸರ್ ಇದು
ಟ್ಯಾಗ್ ಆಗುತ್ತಾ ಸರ್?
ಸರ್ ನಾಳೆಗೆ ಫ್ರೆಶ್. ಸರ್ ನಾಳೆಗೆ ಫ್ರೆಶ್ ಮಾಡ್ತಾರೆ.
ಸರ್ ಸರ್ ಸಿಜೆ ಸಾಹೇಬ್ರೆ ಹೇಳಿದ್ದು ಇಲ್ಲಿ ಅದೇ ಬರ್ತೀನಿ. ಲೀಡ್ ಮ್ಯಾಟರ್ ಯಾವ್ದು ಲೀಡ್ ಮ್ಯಾಟರ್ ಯಾವ್ದು ಸರ್? ಸರ್ ಗೊತ್ತು ಸರ್, ಅದು ಟ್ಯಾಗ್ ಆಗ್ಲಿ ಅಂತ.
Serial number 62 ಚೆನ್ನಾಗಿದೆ ನೋಡಿ.
ಸಾಹೇಬ್ರೆ ಹೇಳಿದ್ದು
ಅವರು ಇವಾಗ ಬೋರ್ಡ್ ಅವರು ಲಿಸ್ಟ್
ಯಾವ್ದು ಮಾಡ್ಬೇಡಿ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಾತ್ರ ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೀವು ಫೋನ್ ಮಾಡಿದ್ರೆ ನಾವು ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ ಇಲ್ಲ ನಾನು ನಿಮ್ಮೇನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅಲ್ಲ ಸರ್, ನಾವು ಹೋಗ್ಬಿಟ್ಟು ಫಾಲೋ ಅಪ್ ಮಾಡಿದ್ವಿ. ಅಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಿದ ಡೇಟ್ ಕೊಟ್ರು ನಾಳೆಗೆ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 62 ನೋಡಿ.
ಹಾಕಿರ್ತೀರ ಕಳ್ಸಿರ್ತಾರ, ಪೋಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ, ನಾನು ಬಂದು ಫೋನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ. ದಿನ ಬರ್ತಾ ಇರುತ್ತೆ ಅದನ್ನು.
ಅಲ್ಲ ಸರ್, no, that's not what I meant. I meant senior counsel meant the judge gave the date for tomorrow.
ನಾಳೆ ಕೊಡಿ, ನಾಳೆ ಬೆಳಿಗ್ಗೆ. ಮೆಮೋಸ್ ಯಾವ್ದು ತಗೊಂಡೋದಿಲ್ಲ ಇಷ್ಟೊತ್ತಲ್ಲಿ.
ಸರ್ ಪೋಸ್ಟ್ ಲಂಚ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಇದು ಮ್ಯಾಟ್ರಿಕ್ಸ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 62 ನೋಡಿ.
ಇಲ್ಲೇ ಬನ್ನಿ ಸರ್, ಈ ಕಡೆ ಬನ್ನಿ ಸರ್.
ಸರ್ ಬೆಳಗ್ಗೆ ಒಂದು ಮೆಮೊ ಕೊಡ್ತಾರೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 62. ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
ಬೆಳಗ್ಗೆ ಒಂದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ರು.
ಏನ್ ಹೇಳೋದು ಸಾಹೇಬ್ರು, ನಮ್ದು ಬರಂಗಿಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್
ಸರ್ ಇವತ್ತಿಂದ ಮೆಮೋಸ್
ಅಲ್ಲ, ಆರ್ಜ ಮುಂದೆ ಹೋಗಿದ್ದಕ್ಕೆ ಏನಂತ ಹೇಳಿದ್ರು ಯಾರು?
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 62 ಅರ್ಜನ್ ಆಗಿದೆ.
ಸರ್ ಇವತ್ತು ಮಾಡಿರೋ ಮೆಮೋ
ಫೈಲ್ ಅಲ್ಲಿ
ಬೆಳಿಗ್ಗೆ
ಅದಕ್ಕೆ ಏನಾದ್ರು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಏನಾರ ಇದೆಯಾ? ಈ ಮೆಮೊ ಕಳ್ಸಲ್ಲ, ಹಾಗೆ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿಸ್ತೀವಿ. ಈಗ ವ್ಯಾಲಿಡ್ ಇಲ್ಲ, ಬಿಕಾಸ್ ನೋ ದೇರ್ ಇಸ್ ನೋ ಇದಕ್ಕೇನು ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ ಯಾವ್ದು ಆಫೀಸರ್ಸ್ ಕಡೆಯಿಂದ. ಅದಕ್ಕೆ ನೀವು ಅಷ್ಟೆಲ್ಲ ಹೋಗಿ ಬಂದಿದ್ರೆ ಏನು ಇಲ್ವಲ್ಲ. ಇದೇನಿದು WP 230866?
ಅದು ಲೀಡ್ ಮ್ಯಾಟರ್ ಸರ್, ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್.
ಇದಕ್ಕೆ ಈ ಮ್ಯಾಟರ್
ಸ್ಟೇ ಆಗಿದೆ, ಈಗ ಸಾಹೇಬ್ರೇನ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ಟೇ ನಮ್ಮ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ, ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ.
ಎಲ್ಲ ಸರ್ವ್ ಆಗಿದೆಯಾ ಎಲ್ಲ ಕಡೆ?
ಸರ್
ಸರ್ವ್ ಮಾಡಿದಿರ ಎಲ್ಲರಿಗೂ?
ಎಸ್ ಸರ್, ಎಲ್ಲ ಸರ್ವ್ ಮಾಡಿ.
This number 2, serial number 4, memo for dismissal. Memo sign ಮಾಡಿಲ್ಲ ನಿಮಿಷ ಕೊಟ್ಟು ನಾವು this number 2, 4, Anil Kumar S. M. Shivappa Associates.
ಬೆಳಿಗ್ಗೆ ಕೊಟ್ರಲ್ಲ.
ಸರ್ ಚೂರು ನೋಡ್ಬಿಡಿ ಸರ್.
Number 17,000 Basuraz Murthy. 1009 ಬನ್ನಿ ಸರ್ ಈ ಕಡೆ ಬನ್ನಿ ನೋಡಿ ನೀವು ಕೈ ಯಾವ್ದು ಅಂತ ಬಳಿ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ
ಸರ್ ಇದು ಫ್ರೆಶ್ ಫೈಲ್
ಏನ್ ನಂಬರ್ ಮೇಡಮ್ ಅದು ಇದೆ
ಯಾರು ಅವ್ರಿಗೆ ಬರೀ 11 matters
ಸರ್ 2:30ಗೆ ಮೂವ್ ಮಾಡ್ಬೋದಾ?
ಮೇಡಮ್ ನಮ್ಗೇನ್ರಿ
ಅಲ್ಲ ನಾಳೆಗೆ ಅದಕ್ಕೆ ಕೇಳಿ 2:30ಗೆ ಮೂವ್ ಮಾಡ್ಬೋದಾ ಅಂತ.
ಅಷ್ಟೇ ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿನೋ ಯಾರೋ ಬೇರೆ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಮುಗಿತು ಅಷ್ಟೇ. ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಡಿಗ್ರಿ ಕೊಡಬೇಕು. ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅದರಲ್ಲಿ ಪೋಸ್ಟ್ ಆಗ ಎಷ್ಟು ಹೆಂಗೆ ಆಗುತ್ತೆ ಸರ್ ಅದು ಕೊಡ್ಬೋದಿಲ್ಲ ಮುಂದೆ ಈಗ ಬಂದಿದೆ.
ಊಟ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ ನೀವು ನಾಳೆ ಆಗೋದಿಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಚೇಂಜ್ ಮಾಡಿಲ್ಲ ನಾನು ಮಾಡ್ತೀನಿ. ಇಲ್ಲ ಆಕ್ಚುಲಿ ಬೈ ಇದು ಅಬಂಡನ್ಸ್ ಕಾಷನ್ ಹಾಕ್ಬಿಟ್ಟೆ. ನೀವು ನಾಳೆ ನಾಳೆ ಕೊಡ್ತೀರ ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ. ಹಾ ಅದೇ ರೀಚ್ ಆಗ್ಬೇಕು ಅಷ್ಟೇ. ಸರ್ ಇದು ಬಟ್ ಮೆಮೋ ಹೋಗಿಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲಿ ಬಂದೆ.
ಕೇಳಿ 30ನೇ ತಾರೀಕು ಏನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿ ನೋಡುದು ಕೇಳಿ. ಅವರು ನಾಳೆ ಮಾತ್ರ ಬರೆದಿರ್ತಾರೆ. ನಾಡಿದ್ದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು ನಾಳೆ ಬರೀತಾರೆ, ಸಾಯಂಕಾಲ ಬರೀತಾರೆ. ಅಂದ್ರೆ ನಾಳೆ ಇದು 30ನೇ ತಾರೀಕು 28 ಬರೀತಾರೆ, ಅಲ್ಲಿ ಬರೀತಾರೆ. ಕೇಳಿ. ಹೌದು.
ಈ ಕಡೆ. ಮಾಡಿದ್ದಾರೆ ಒಬ್ರು ಓಡಾಡೋ ತರ ಮಾಡಿ ನಾಗರಾಜ್ ಸ್ವಲ್ಪ ಓಡಾಡ. ಇದು ಹಾಕಿ ಏನೋ ಹಾಕಿ ಅಂತ ಹೇಳುದು ಬೇಡ ಏನಿದ ಅದೇ ಅದು ಅದಲ್ಲ ಇದಲ್ಲ ಇದಲ್ಲ ಅದು ಇನ್ನೊಬ್ರು ಇಬ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಅವರೇ ಬಂದು ಕೇಳಲಿ ಕೋರ್ಟ್ಗೆ ನಾವು ಇದು ಮಾಡಕ್ ಬರಲ್ಲ ಸಂದೀಪ ಅವರೇ ಬರ್ಬೇಕು ಹೌದೌದು ಏನಾಗತ್ತೆ ಅವರೇ ಬಂದು ಮೂವ್ ಮಾಡಕ್ಕೆ ಏನಾಗ್ತದೆ ಅದು ಏನ್ CJ ಹತ್ರ ಹೋಗಿದಾರಂತೆ ಜುಡಿಷಿಯಲ್ ಹತ್ರ ಹೋಗಿದಾರಂತೆ ಎಲ್ಲ ಕಡೆ ಹೋಗ್ಬಿಟ್ಟು ಬಂದಿದಾರಂತೆ ಆಮೇಲೆ ನೋಡಿ ಅಂತ ಹೇಳಿದಾರಂತೆ ಅದಕ್ಕೆ ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ ಸಾಹೇಬ್ರು ಸ್ಟೇ ಕೊಟ್ಟಿರ್ತಾರೆ ಸ್ಟೇ ಅಂತ
May I make a submission? Court audio is muted.
Court audio is not audible, my lord.
Court audio is muted.
Not audible.
Yes, okay, now it is audible. Now it is audible.
I have complied with the office objections. ಅವರು
ಯಾವ್ದು?
ಇದೇನೋ ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. I have complied with the office objections. ಈಗ ಇದು with regard to 3 IAs and objections to the writ petition, it has to be heard. ಇವತ್ತು 47 ಇದೆ, ಇದು ರೀಚ್ ಆಗತ್ತೋ ಇಲ್ವೋ? Your lordship.
Who's on the other side?
Other side 130 ಇದ್ರು.
Imran.
130 ಇದ್ರು ಅವರು. ತಾವು ಇದು ಒಂದೇ ಒಂದು ಅಡ್ಜರ್ನ್ ಮಾಡಿ ಹೊರಟೋದ್ರಿ.
No, not in the absence of the other side, sir, not possible. Yes, please.
ಅಲ್ಲ ಇದೇನೋ
List number 2, serial number 1.
Lordship,
Nagaraj.
appear for the petitioner in this matter. Petition has been rendered infructuous as the lower court suit has been withdrawn. Hence, I'm filing a memo for withdrawal. I seek leave of this court to withdraw the petition.
Memo filed by learned counsel for petitioner, OS number 26129 of 2016.
Please, Your Lordship.
Was disposed of as withdrawn by order dated 21/9/2024.
Please, Your Lordship.
Yes.
2. Number 2.
OS 123 of 2012. Was dismissed on 13/9/2022. Yes.
Number 3. Panchamardi.
Withdrawing.
Memo filed by learned counsel for petitioner. OS number 1513 of 2019 was disposed of, was settled before the Lok Adalat and disposed of on 16/3/2024. Yes.
4. Anil Kumar.
Please, my lord, I complied the office objection, my lord. Petition may be dismissed, my lord.
Memo filed by learned counsel for petitioner on 2/1/2024 Execution case number 109 of 2009 was disposed of on 21/12/2023. Disposed of.
Serial number 5. VB Sidramaya.
Here for the respondent number 112.
Submission of learned counsel for respondent OS 25 of 2018 was dismissed on 12/3/2024.
6.
For respondent in this case, my lord. It's a petition filed a petition under order 21/26 that was rejected and it's stayed by the Honorable Court in writ petition. Subsequently, he filed miscellaneous petition. That miscellaneous petition also dismissed for non-prosecution. Hence, it may not survive.
The execution petition was closed on 19/9/2020.
Because of writ petition stay. Subsequently, he filed, the petition filed miscellaneous petition for setting aside the ex parte order. That miscellaneous petition also dismissed for non-prosecution. Originally, he was placed ex parte and respondent herein filed execution petition.
It says the execution case is closed.
Closed.
As settled before the Lok Adalat
Not settled. My lord.
on 19/9/2020. Execution case number 93.
As per
of
the information given
2019.
by, as per the information given by the.
This is the information available from the website.
I'll
Disposed
check
of.
up and next week kindly take it up.
Disposed of, sir. Execution case itself is disposed of. Even anyway, you are for the respondent.
I am the decree holder. Decree holder.
You are for the respondent here.
Yes, sir. my lord.
Then, yes.
Serial number 7. Rupesh Kumar S. Serial number 7.
OS 446 of 2013 was decreed on 28/2/2024.
List number 1. Serial number 13.
For petitioner, my lord. I appear for the respondent, my lord. 12th September, we have filed Kalat. Name has not been disclosed. And your lordships may please to have it after vacation. We'll secure the petition copies.
The commercial suit, my lord, they filed a suit. In the suit, they produced documents in the stage of arguments that he has partly argued. Subsequently, filed an application for production of documents. Those documents, he was in custody prior to the filing of the suit itself. That application was allowed. Again, that petition has been filed.
Yes.
The present petition has become infructuous, if your lordships may consider. The documents are already produced before the trial court and it has already marked. If your lordships may consider, we'll secure the petition copy. Your lordships may.
Yes, really.
It's a suit for recovery of money.
Yes.
After the trial, the plaintiff has argued the matter in part. After that, he filed an application seeking production of certain documents. That application was allowed.
You have cited judgments of the Supreme Court also.
No, Delhi High Court judgments.
Sir. Yes. Apex Court ಅಂತ ಹೇಳ್ತಿರಲ್ರಿ 2020.
22. In that, they have referred on apex judgment. By referring that.
Yes.
Still the learned judge says that in interest of justice, he may be permitted to produce the documents. He has assigned only.
Application was filed by the plaintiff.
Plaintiff. He has stated that.
For producing additional documents.
Additional documents.
Yes. On
And
what
still-
grounds?
He said that by oversight, he could not produce those documents. No other reasons. Because I gave.
So not within the prescribed period.
Yes, my lord.
30 days.
Yes. I'm referring to judgments. When I gave those two judgments, even that referred, he simply said that it is required, hence he may be permitted to produce those documents.
Yes.
He has not assigned any reasons, my lord.
Yes.
Simply said that by oversight, he could not produce those documents.
Which is
That
the
is not
provision?
permissible under Commercial Courts Act.
Which is the provision?
Section 11, my lord. Sorry, Order 11. That has been referred in this, my lord.
Yes.
These two judgments. Delhi High Court. my lord. Order 11, Rule 1,
Subclause 5.
subclause 1.
5.
That they say plaintiff shall file a list of all documents and photocopies of all documents in its power, possession, control or
An
custody.
amendment for the purpose of commercial code,
Commercial
sir,
code,
which
yes,
is that
my lord.
provision?
That is that order 11, Rule 1, clause 1, 1.
Huh?
Order 11, Rule 1, clause 1, clause 1. That has been referred in that judgment, my lord, itself. That has been called out, that section. That provision itself. That year 2022, Delhi, 838. Order 11, Rule 1, clause 1. Plaintiff shall file a list of all documents and photocopies of all documents in its power, possession, control, or custody pertaining to the suit, along with the plaint, including documents referred to and relied on by the plaintiff in the plaint. Document relating to any matter. And in that case, after summons, he has produced that document. That has been rejected in that case. But here in this case, he has produced at the stage of arguments.
The Supreme Court judgment of Balian. Where is that? Not the provision.
Order 11, Rule 1, Sub-Rule 4 and 5.
Where is that?
It's in amended Order 11.
That is contained in the Commercial Courts Act.
Commercial Courts Act and in any regular CPC also the amended Order 11 is there.
I'm not finding this.
This very point I argued before my.
Yes,
lawyer,
yes,
I
yes.
passed an order.
Yes, yesterday also I passed an order.
Order 11, Rule 1, Sub-Rule 4, Sub-Rule 5.
That is based on Balian, isn't it?
Yes, yes.
Sudir Kumar Balian.
That's it.
Yes. ಅದನ್ನ ಬಿಟ್ಟು ಯಾವ್ಯಾವ ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಎಲ್ಲ ಹಿಡ್ಕೊಂಡ್ ಬರ್ತಿರಲ್ರಿ ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರುವಾಗ. Yes, it is not permissible.
If your lordships may permit me.
Unless you fulfill that requirement.
Yes, my lord.
It's not possible.
My lord, the petitioner herein has not produced any documents before the trial court. The petitioner herein, the petitioner defendant has not produced any documents.
For the plaintiff, isn't it?
Yes, my lord.
Yes.
The defendant has not produced any of the documents before the trial court.
Defendant.
Petitioners, petitioner herein. I'm sorry.
Hmm.
My lord, when these documents are pertaining to the invoices which are already marked, the respondent which have ought to have sought direction from the trial court and produced the documents which are the part of the invoices, which are nothing but the placement order, purchase order placed by the petitioner herein. And the WhatsApp communication held between the petitioner and the respondent. Nowhere the petitioner has denied the transaction held between the petitioner as well as the defendant, respondent. If your lordship may permit me.
Sub-Rule 5, the plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control or custody and not disclosed along with plaint or within the extended period set out above, save and except by leave of court, and such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure along with the plaint.
Yes, my lord. My lord, the case of the petitioner herein, they never denied the transaction held between the petitioner as the respondent. My lord, they admit in their reply, if your lordship may permit me, we are in reply what they have given. We are in receipt of your legal notice dated 1/8/2022. At the outset, we deny allegation mentioned in your notice except which are specified. It is true that we have purchased hardware material. My lord, they never deny the transaction held between the
That is
petitioner
not
and
the way
respondent.
you can interpret Sub-Rule 5.
Not
possible.
My lord, These are nothing
The
but.
documents were in your possession.
No, it has the computer extracted. The petitioner herein has placed a purchase order through email money. By oversight, the respondent could not produce. before the-
Oversight alla barodilla, that is not a ground.
And it is with the purview of the 90 days, my lords.
The reasonable cause that can be shown.
Yes,
please.
I have stated that, my lord, since the said documents were confronted to the petitioner herein, he has merely denied it that he is not aware of the facts.
Yes.
He being the GP holder, my lord. Then the matter was, the burden lies on
That
the.
will not enable you, sir. That cannot be reasonable cause.
If your lordships may
And
consider.
please read out what are the.
I will come up with the citation.
What
If
are
your
the
lordships
reasons
may have it
given
on
in the
Monday,
impugned order?
I will secure the petition copy.
Barkale.
If your lordships may convene.
Learned Counsel Shri.
MHS, MHS.
Full name, sir.
Manish H. Sanghavi.
Manish.
H. Sanghavi.
Yes.
Manish H. Sanghavi.
Please write.
Please.
Undertakes to appear for the respondent.
Please.
Huh?
Yes. I have already filed wakalat on 12th of September.
Submits that he has filed wakalat for the respondent. Office to verify and show the name of the learned counsel in the cause list. Next para. Learned counsel for the petitioner submits that despite the interpretation given to the amended provisions contained in Order 11, Rule 1, Sub-Rule 5, by the Honorable Apex Court, that unless exceptional and reasonable cause is shown by the plaintiff for non-production of the documents which were in his possession, additional documents cannot be permitted to be marked on behalf of the plaintiff, the impugned order has been passed.
One submission, my lord, if your lordships.
By the trial court.
Only through GPA holder, the respondent has appeared before the trial court. If your lordships may.
It is the contention of the plaintiff that having regard to the denial of certain information by the defendant during the cross-examination, it has become incumbent for the plaintiff to produce the additional documents. Full stop. It is stated that it is, where is your application?
If your lordships.
Where is the
may-
application?
It's in page number 25, my lord.
Affidavit is page number 26.
26. Yes, only.
Oversight, due to oversight.
Oversight.
It is stated in the affidavit accompanying the application that due to oversight, the documents could not be produced. Full stop. Learned counsel submits that this cannot be a reasonable cause which could be accepted by the commercial court to permit the plaintiff to file additional documents. Full stop. Next para. Consequently, there shall be an interim order of stay of the impugned order. Dated 1/8/2024 on IAS 2-4 in commercial OS number 144 of 2024 till the next date of hearing.
Please.
Rohit Aras D.
Yes.
My lord, sir. Petitioner's application for framing of additional issues, my lords, came to be rejected by the trial court, my lord. Suit is one for partition, my lords. Petitioner is defendant number 8 before the trial court.
Yes.
Suit filed by the plaintiffs against the defendants, my lords, on the ground that the property belonged to one Chikkaya Shetty, who is the father of the plaintiff and defendants, my lords. He was the tenant of a certain part of land, my lords. On this basis, my lords, the plaintiffs claimed partition, my lords. Subsequently, my lords, trial court framed issues, my lords. And after that, my lords, defendant filed an application for framing of additional issue, my lords, only with respect to that leasehold rights of the father. My lords.
Yes.
That came to be rejected on the ground that there is no specific denial in the written statement.
Yes. Please come to page number 15, reasons.
Yes, my lord.
Yes.
May I read, my lords?
Yes.
On perusal of the suit, the suit has been filed by the plaintiffs for relief of partition by claiming shares in the suit scheduled properties. The defendant number 1, 2, 3 have also claimed for partition of suit scheduled properties in the counterclaim. Whereas defendant 4 to 8 have formally denied the claim of plaintiffs. It is no doubt in the written statement, it is stated that suit of plaintiffs is bad for partial partition, but they have not specifically stated which are the properties left out without impleading in the suit for partition. Without specific contention in the pleading, no such circumstance arose to frame the additional issues as sought by defendant number 4 to 8. As such, defendant 4 to 8 have not made out any ground to frame additional issue with respect to partial partition. Coming to the other two issues are concerned, there is no specific denial and it seems formal in nature. Even otherwise, issue number 1 already framed, which covers the said fact. Thus, IA number so and so filed by the defendant is deserves to be rejected.
Yes.
Please, my lord, sir.
What is
just, my lord, specific denial.
You have also filed a counterclaim.
I have not filed, my lords. That is defendant number 1 and 3, 1 to 3, my lords. I am defendant number 8, my lords.
Yes.
I have denied, my lords, my father's right over the property with regard to
So
occupancy.
if you are contending,
please, my lord,
it would amount to partial partition.
Partial partition with respect to other properties, my lords. That has not been.
See the other property which is left.
That has not been specifically contended.
That is what has been stated.
My lords, I would specify, my lords, only with regard to one issue, my lords, the leasehold right of the father, my lords.
Let us see. Issue notice to the respondents. The issue notice to our respondents.
Please.
The petitioner is also permitted to serve copies of the writ petition along with annexures and the learned counsel representing the respondents before the trial court. Yes.
Order, my lords.
Yes.
Matter set for, my lords, cross-examination of the plaintiff, my lords.
Yes. Next matter, please.
I appear for the petitioner in this matter.
Yes.
The suit for recovery, my lords, which has been filed by the respondent plaintiff. Lords may kindly see annexure A is which is called in question. Order 11, Rule 15 of the Commercial Court Act, which has been filed after the trial has commenced, my lords. Order 11, Rule 1, Subclause 5. Additional documents. It has been filed after a lapse of 5 months from the date. And my lords may kindly see the application which has been filed by the plaintiff.
Yes.
It's at annexure F, page 57, my lords. Affidavit is at page 50. It is at para number 3, my lords. Reasoning which has been.
Yes.
I state that at the time of filing the plaint, the documents referred in the application were not in my possession. However, these documents were held by my auditor, Mr. Mukul Singri. Prior to filing the affidavit, I requested these documents from my auditor. Unfortunately, he was unable to provide them at the time. Upon making a subsequent request, my auditor assured me via email so and so, and he would supply the annexed document within 10 days. Now the documents were handed over. This is what the reason is assigned, my lords.
Yes.
My lords may kindly turn to page, my objection which has been filed at annexure G. Annexure G, my
page number?
Page 60, my lords. I have raised 3 questions which need to be, my lords.
Yes.
The document which was called in question to produce was the ledger account for the year 2017 and 18. And my first objection which I raised before the trial court was 2017 and 18 ledger may not be assessed by the auditor at this point of time was my first question. Second, I had made a plea that the said documents which has been produced, he's relying upon is of the year 2017 and 18. And according to the Limitation Act, to file a suit for recovery, it is just 3 years, my lords. And whenever the plaintiff wants to rely upon said document, it is a time-barred claim. And I have also mentioned, my lords may kindly see.
We are not concerned about whether your contention regarding time bar. We are only concerned with the production of the document.
Production of the document was not in accordance to the Balyan judgment also as per the Lord.
Partly it appears There is complaint because he has said it was not in my possession.
That's the reason, my lords.
Yes.
The moment possession is not taken into consideration, my lords may kindly see the documents which was produced of the year 2017-18. 2017-18 ಇರೋ document ನ assessment ಗೆ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದ್ರಿ.
Please, my lords.
It doesn't mean you can you can come to conclusion, no, it was not with his auditor. ಹಂಗೆ ಹೇಳಕ್ ಬರೋದಿಲ್ಲ.
Please, my lords, I may be permitted for.
Provision says.
Please, my lords.
It would apply strictly if the document was in his possession.
He does not state that, my lords.
He has said, yes, it was not in my possession.
Please, my lords.
It was in my possession of my auditor.
Auditor,
Yes.
that is the reason which has been assigned. My lords may kindly see for a moment issues, my lord, annexure E. He has filed a summary suit, my lords, not an original suit under 7 Rule 1. He has filed under Order 37. 37 impose ಮಾಡಿದಾಗ 10 ದಿನದೊಳಗಡೆ judgment ಮಾಡಬೇಕು if I don't file a leave to defend. My lords may kindly see for a written statement which have been filed is at page 48 for a moment.
Hmm.
48 ಅಲ್ಲಿ ಕೆಳಗಡೆ I have pointed out a table, my lords. ಇದಿಷ್ಟು invoices ಗೆ amount defendant is payable ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಅವ್ರು ಯಾವ್ದಾದ್ರು ಇನ್ವಾಯ್ಸ್ ಪ್ಲೇಂಟಿಫ್ ಅಲ್ಲಿ ಏನೇನ್ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟು ಇನ್ವಾಯ್ಸ್ ಗೆ ಡೇಟ್ ಆಫ್ ಪೇಮೆಂಟ್ ಮೇಡ್ ಬೈ ದ ಡಿಫೆಂಡೆಂಟ್ ಅಂತ ಹೇಳಿ ಐ ಸೀಕ್ ಪರ್ಮಿಷನ್ ಟು ಕಂಟೆಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್ ಬಿಕಾಸ್ all the invoices which is claimed by the plaintiff is already cleared by the defendant anta. So summary suit was leave to defend was allowed and the matter was posted for trial. Since the plaintiff could not succeed all the documents which was already placed on record, he wanted to introduce a new case by filing other documents. ಅವ್ರು ಇಷ್ಟೇ ಸಹ ಹಾಕಿದ್ರು ಸ್ವಾಮಿ, ಇವತ್ತಲ್ಲ, ಆನ್ ದ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ದ ಪ್ಲೇಂಟ್ ಈ ಇನ್ವಾಯ್ಸಸ್ ಅಷ್ಟೇ ಹಾಕಿದ್ರು. ಈ ಇನ್ವಾಯ್ಸಸ್ ಪ್ರಕಾರ ನಾನು ಎಲ್ಲಾ ಸಹ ಪೇಮೆಂಟ್ ಮಾಡಿದೀನಿ, there is no payment pending between me and the plaintiff ಅಂತ ನಾನು ಹೇಳಿದೆ. ಅದಾದ ನಂತರ this application came to be filed and he is assigning a reason that it is under the auditor. Recent judgment of the Supreme Court also tells that when the matter is posted for plaintiff evidence, aad nantara they have filed this application. It is nothing but it's a delayed tactic to by the plaintiff anta. I may be permitted to rely upon said judgment for. And in fact, in the impugned order, my lords, the trial judge refers to a judgment wherein CPC is applicable under Order 8 anta.
Yes.
Please, my lords, I have produced a citation. CEC versus Supreme Court 2024 SCC online, the latest one, wherein Balyan judgment is also taken into consideration and passed the. My lords may kindly turn to para 12, my lords. I may be permitted to lead. The explanation given on behalf of the plaintiff for the necessity of filing this document is because of the defense taken in the written statement. The explanation could have been considered valid had these documents filed along with the replication on 21/9. My lords may kindly see para 14 where the observation is made. First and foremost, the nature of the controversy being the same, the plaintiffs were very aware of the defenses which had been taken by the defendants and were also aware of the documents that were required to be filed by it. To counter the defense taken in the written statement, despite when the plaintiff did not choose to file those documents along with the replication, this is more relevant because similar application for filing these documents in other civil suit. So, nan written statement file madad nantra this application has came to be filed. Evidence comments agoytu. Cross examination post madaga this application is filed because I have filed a leave to defend that was allowed. Written statement file madde. Based on that, I have also trial court has also framed an issue. To counter that, they are coming with this application, my lords. Under such circumstances, it is not permissible. My lords may kindly see
Ledger of the year
2017 and 18, my lords. 17-18 ನನ್ನ ಆಡಿಟರ್ ಹತ್ರ ಇತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. 17-18 the assessment of the
According to you, that has got nothing to do with the suit claim.
suit case, my lords. His claim is only start from the year 2019. My lords may kindly turn to the judgment which have been citation which has been produced at para number 16, last page, my lords. Further, order 11 rule 1C read with order rule 15 of the CPT under the Commercial Court Acts mandates the plaintiff shall file list of all the documents in its power, possession, control and custody along with the plaint thereof. Further, order 11 rule 1 subclause 4 CPC permits additional document to be filed by the plaintiff within the course of 30 days of filing the suit, subject to the grounds of the leave. My lords may kindly come to para 18. Further, this court on the commercial suit has no discretion whatsoever to permit taking the documents on record after 30 days of the initial filing of the plaint. In this circumstances, the application of the plaintiffs or filing the additional document is barred by the express provisions of the order 11 rule 1 CPC and cannot be allowed, has also held by the apex court in the case of Sudhir Kumar Balyan versus Vinay Kumar and Nitin Gupta Texmaxo Infrastructure Online, so on. So the application
Delhi
is
High
therefore
Delhi High Court.
Delhi High Court has also
What
considered
about sub rule 5? Sub rule 5 is not taken into consideration.
sub rule 5, my lords. My lords may kindly see the application which is being filed by
All right.
7 rule 14 saha no application hakkar Swami. Under 7 rule 14 also he files an application.
Issue notice to the respondent. The petitioner is also permitted to serve copies of the petition along with annexures on the learned counsel representing the respondent before the trial court. Full stop. Next para. Learned counsel for the petitioner submits that IA number 2 filed by the respondent plaintiff in a commercial suit invoking order 11 rule 1 bracket 5 of the Commercial Courts Act was filed by the plaintiff to produce additional documents, namely ledger statements for the financial year 2018-19, 2019-20 and 2020-21, semicolon, original invoices from 2018 to 2019, copy of the email dated 14/8/2024, and a certificate under section 65B of the Evidence Act. Full stop. Learned counsel submits that the trial court has not taken into consideration the objections filed by the petitioner where it was contended that the additional documents are of the year 2018-19, 2019-20, which were not in any way concerned with the suit claim, where the transaction is of the year 2019. Full stop. Moreover, just because the plaintiff contends that the ledger was with his auditor, that will not permit the plaintiff to claim that the document was not in his possession. Full stop. On the other hand, the documents are sought to be produced as an afterthought after the cross-examination.
After the written statement, after the evidence.
After the
evidence
of plaintiff. After written statement was filed by the, after leave
to defend and written
defend was
statement
granted by the trial court in a suit filed under order 37,
please, madam,
which is a summary suit, and after recording of the evidence on behalf of the plaintiff. Full stop. Nevertheless, there is no compliance of the requirement of sub rule 5 of rule 1 of order 11. Full stop. Next para, consequently, there shall be an ad interim order of stay of all further proceedings in commercial OS number 581 of 2024 on the file of so and so, learned so and so till the next date of hearing.
16, Mukunda appeal.
It's the partition suit, Your Lordship.
Yes,
Partition suit filed by the petition against the respondent number 1 to 4. And the respondent number 1 and 2 appear before the court is not filed the written statement. And respondent number 3 and
2016 suit.
16 suit.
Ah,
And the respondent number 3 and 4 also appear before the court and while the wakal did not file the written statement.
permission to implead the proposed
Defendant
defendant.
number 5. In the meanwhile, property item number 3 were acquired by the respondent number 5.
Huh?
Respondent 5 acquired by the item number 3. Acquire agate KIDB. Then they also issue the notice to petition and respondent number 1 to 4 in annexure E, page number 37. That 28 is annexure D is
One item of the suit schedule property was acquired
acquired
by KDB.
KIDB.
Ah.
Respondent number 5.
Ah,
And hence we are filed the IFR implemented proposed defendant number 5. Respondent 5 as a defendant number 5.
yaru?
KIDB.
KDB.
KIDB.
Ah,
That notice was served, but is not appeared before the court and court heard the argument on IA and dismissed my IA. Only stating that in page number 17, impugned order in page.
why will KDB become a necessary party?
Necessary part,
Why?
our notice issue ಮಾಡಿದ acquisition ಮಾಡಿ.
Houdre, subsequently it is notified for acquisition. All
Okay.
right, so what?
They are issued notice to us. Page number 37.
Houdu, that's a different procedure. If one of the items of the suit schedule property in a partition suit
What is
is subsequently notified for acquisition,
notify?
will that become a reason for impeding the KDB in the matter?
No. What is that? Acquisition number, plaintiff number 2. Respondent number. Property stand in name of respondent number 3.
Yardaragli country, it's a partition suit, isn't it?
Partition suit.
You are claiming these are ancestral properties and therefore you also have a share.
Share.
You are the plaintiff.
I am a plaintiff.
Yes.
Respondent number 3 and 4 is the purchaser. Purchase the suitable property. Our stand in the record as in respondent number 3 and 4.
ಆಯ್ತು.
ಅವ್ರ ಹೆಸರು ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡ್ತಂದ
Implement ಮಾಡಿದ್ದೀರಾ ನೀವು?
ಅವ್ರು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ.
ಹೌದು, ಸರಿ.
ಅವ್ರು ಇದು ಒನ್ ಆಫ್ ಪಾರ್ಟಿ ಇನ್ ದ ಪ್ರಾಪರ್ಟಿ.
You, at best you could have made an application. If compensation is determined, direct them to deposit in the court. ಅಷ್ಟೇ.
ಅದಾಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಈಸ್ ಪೆಂಡಿಂಗ್.
This is not, why do you need KDB to come as a defendant in the suit? Not necessary.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗ ಇದರಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟೆಡ್.
Issue notice to the respondents. Yes.
17.
I am for the respondent number 1. Engaged Mr. Senior Advocate Adayhoda, who's on his legs before.
ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ ಸರ್. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಸರ್ವ್ ಮಾಡಿ.
My lords, may I request a pass over.
ರೆಸ್ಪಾಂಡ್ 5 KDB ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ.
Oh, that's all right. Yes.
ಅಲ್ಲ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ.
Notice issue ಮಾಡ್ಲೇಬೇಕ್ರಿ. Yes.
17.
For the petitioner minutes.
Yes.
Where the suit for injunction was filed by respondent number 1. Application for temporary injunction was filed. The trial court method after considering the entire materials on record dismissed the application. The first appellate court has reversed it. The case of the respondent is that they
Suit for?
Suit for bare injunction. The respondent's case is that they have their predecessor in title had earlier purchased this property in an auction. There is no document forthcoming to show that the property has been purchased by the predecessor in title in auction. And our case is that we are all the residents of the area. There is a temple. Adjacent to the temple is this vacant site. It is admittedly a municipal site. According to them, it is purchased in a public auction. Now, what has happened is there is no material placed before the court below to indicate that they had at any point of time purchased the property by court auction. So under these circumstances, the trial court, after considering the entire materials on record, rejected the application for filing for temporary injunction. Well, this has been reversed by the first appellate court, mainly on the ground that it is putting burden on the defendant than on the plaintiff. Kindly see the reasoning. Apart from that, Milord, the first appellate court invokes the provisions of Article 51A of the Constitution, which has nothing to do with, according to the petition, respond number 1, they are putting up a construction for the purpose of putting a sort of a freedom fighters memorial in this property. Ultimately, Milord, they are the predecessor title of the respondent who, according to them, have purchased the property in a public auction. Subsequently, there was a partition, etc., etc. Now, those partition deeds by themselves are not the documents of title.
You are all owners of individual sites.
No, we are not the owners of the individual sites. Our specific case is, this is a vacant site belonging to municipality, which is adjacent to a temple that is already situated. And admittedly, Milord, we have produced several documents to indicate that right from the.
Why are you implicated as defendants?
Yes, Milord. They have defended me. They have filed a suit against me.
What is the allegation against you?
Their allegation is that we are interfering with their proposed construction.
Correct.
Our contention is this particular property.
You are all neighbors?
No, we are the residents of the area who have been performing pujas in the temple. And in this particular property, the jatras are being conducted right from 1932 onwards. We have produced several documents to indicate that the resolutions have been passed with the municipality, authorizing them to conduct that. On the contrary, their case is that the property was purchased in a public auction. No document is produced. Only reference is, there is a reference in the partition deed of the predecessor in type. In the absence of any document to indicate that there was at any point of time any auction as such held by them, there is no document of title as such, Milord. And it's a bare suit for injunction, wherein we have denied the title. So in that background, suit itself was not maintainable is one aspect of the matter.
Mere deny of title will not take you anywhere.
But we have specifically said it's a municipal property. So when it's a municipal property, that is an admitted fact. Ultimately, what is admitted is itself that it's the municipal site. It is also admitted that
how did they become owners of the property?
They claim that they have purchased the predecessor in title of the property from whom they are deriving title, one Lakshya Sethi. He has purchased this property in a public auction from municipality. For that, no document is placed.
All right.
And
when did they purchase?
They have not purchased the property. What has happened is this, subsequent to alleged purchase by Lakshya Sethi in I don't know when they have purchased because they don't even mention the date. In 1968, there was a partition among the sons of Lakshya Sethi. The property was allotted to one Ramchandra Sethi. Ramchandra Sethi again, there was again, he had about 6 sons. There was a partition according to them in 1976. Property is allotted to two of the sons of this Ramchandra Sethi, who according to the plaintiff has gifted this property to this particular trust. Respond number 1 is a trust. But ultimately, our contention was, in fact, what had happened was we had produced materials before the court below to indicate that the predecessor in title, that is the persons from whom they have obtained the property under the gift deed, they wanted to put up a construction in the property. When they wanted to put up a construction in the property, they sought for a license also. When we objected, municipality asked them to produce the documents to indicate as to whether they have any title prior to 1976. They did not produce it. License was cancelled. When they could not do all these things, Milord, they have gone to the extent of gifting this property to this trust. And the trust is now trying to put up a construction in the property. And it's a vacant site where admittedly, Milord, we have produced several documents. In fact, Milord, the documents filed before the trial court also are available with me, Milord. I can file them. My only anxiety is, Milord, because it's a divergent finding. I am ready for a detailed argument. In the meanwhile, what has happened for the first time after the disposal of the miscellaneous appeal before the first appellate court, Milord, they have started putting up construction. Right from 2022 to 2024, admittedly, it is a vacant site. Now, what is happening is they are putting up a zinc sheets all around the property. Just 2 days back. My submission is, let the matter be heard. We are ready. Any date.
You are saying, where is the temple?
Temple is just adjacent to this land. Adjacent to this property, a temple is there. That is not in dispute.
Does the suit schedule property include the temple?
No.
Then
it is a site adjacent to the temple.
You are devotees of the temple.
Correct.
How are you concerned with the other property?
That's what I am trying to submit. Your Lordship may kindly bear with me. What is happening is, this particular property, there is material space.
Admittedly, you have no title. I
have no title. But at the same time, Milord, we have denied that title.
Yes.
But what we have contended is, this particular site is being permitted by the municipality to conduct jatras right from 1930. The resolutions are produced. The order passed by the municipality withdrawing the license is produced to the private vendors. These people, on the basis of an alleged gift deed from persons who have themselves don't have title.
The temple belongs to whom?
Yes, Milord.
Temple
is a public temple. It's a very old temple of more than 150 years old temple.
There is no managing committee?
My lord, managing committee, I am not sure about. I have to verify.
ಅವ್ರಿಗೆ ತೊಂದರೆ ಇದೆ ಬರ್ತಾರ.
My submission is this, my lord. We have not, lordship may kindly see, it is not a case where we have filed the suit against the plaintiffs. It is the plaintiffs who have chosen to file a suit against us, claiming that we are interfering.
Yes.
My lord, if
Because
they had
you are
filed,
causing interference,
Allah,
they have filed a suit
in that
against.
background only, we have,
Not having any title.
you know,
want to
even
come
though
and
we have
disturb
no
their
title,
possession.
even though we are not claiming any
Against.
title, my lord, it's a case where the
How
property.
can you say there is no title with them, sir? There's a gift deed.
That's
Registered
what
gift deed.
gift deed, with the law is, on that, there are certain judgments also. The honorable court also has held, saying that a deed of partition, your lordship may kindly see, they are claiming their title from their predecessors,
Yes,
who have got a deed of partition.
yes.
So deed of partition by itself is not a document of title. That is well settled. So it has to be preceded by an antecedent document.
How can you raise all this?
Because we are using this property.
See, you are
Public
admittedly not the
property.
owner of the property.
Well, I am not the
You
owner.
have no title.
Well, it is
You
the-
say there is a temple adjacent to this property.
And it is being
You are
used.
devotees of that temple.
May I pass on the documents for a moment? Kindly see the document. Right from 1930 onwards, the resolutions are passed. The trial court order, your lordship may kindly see for a moment. Trial court order.
Learned counsel Sri P. Chinnappa has entered appearance for respondent number 1. Who is this respondent number 2?
Respondent number 2 is one of the
One of the
co-defendants.
dependents who has
One of
not
the-
come.
He has not approached this court. Your lordship may dispense notices with him.
Learned counsel for the petitioner submits that respondent number 2 is a co-defendant along with the petitioners, and no relief is claimed against respondent number 2. Full stop. Therefore, notice to respondent number 2 is dispensed with. Full stop. 2 weeks' time is granted to the respondent number 1 to file statement of objection.
In the meanwhile, let them not stay. Put up
Yes.
any construction, Miller. What is happening, the lordship may kindly see
No,
the
no.
admitted fact. It is a divergent finding, Miller.
Yes,
Till from 2022 to 24, no construction has taken place.
yes, yes.
Now, for the first time, Miller, on the basis of this order, they are doing it, Miller. Let them not precipitate the matter, Miller.
Yes, yes, 2 weeks' time, sir. Yes.
Number 18, K. Narasimhan.
The plaintiff, my lord, is in petition against the divergent finding of facts.
Yes.
My lord, the temporary injunction application filed by him, my lord, had been allowed by the trial court.
Yes.
And it has been set aside by the first appellate court. This is where, my lord, the writ petition comes. My lord,
You are the plaintiff.
I am the plaintiff. My lord, land in survey number 30/2, measuring 2 acre 22 guntas, my lord, is the subject matter of the suit. My lord, this property have been purchased by the petitioner under a registered sale deed from her vendor. RTC stands in his name. My lord,
Agricultural land.
Agricultural land. RTC stands in his name. My lord, survey number 30 has got 3 ports. My lord, the sketch is at page number 30, annexure C. My lord, survey number 30, totally measuring 5 acres 6 guntas, is bifurcated into port 1, 2, and 3. My lord, I am concerned with 30/2. On the right hand side, my lord will see it stood in the name of Lakshmamma, that is 2 acre 22 guntas. Lakshmamma, my lord, gifts the property in favor of her daughter, and her daughter sells the property in my favor. This is how I claim right over the property. My lord, after the property is sold in my favor, the defendant herein, my lord, would file a suit against me, seeking preemption, saying that he is a neighboring landowner and he has got a preferential right over the property to get the sale deed in his favor first. My lord, that plaint, my lord, is at annexure V, page number 205. The prior is at page number 214. He says that he must be declared that he has got a preferential right to hold, purchase, and acquire the suit schedule property by paying the sale consideration amount as already fixed by the defendants under sale deed dated 16/6/2021. 16/6/2021 is a sale deed in my favor. Now the neighboring landholder, who is the defendant, claims that he must be given the preemptive rights.
That is all. No other prayer.
Then, my lord, he has said that the sale deed in my favor must be held to be null and void.
Yes.
And there should be a sale deed execution in his favor.
Yes.
This is what he says. This is one suit that he files. there is another partition and separate possession suit, my lord, that he has filed, wherein, my lord, he claims right over all other properties except this 30/2. He files the suit in this fashion and says that there was already a prior partition in my family, and in that prior partition, certain properties has fallen to my share. And he includes 30/1 and 30/3 there. 30/2 is not included. Seeks declaration of his title over that property. Alternatively, he says, if at all the partition is not held to be proved, then grant me share in all the properties. There, my lord, this 30/2 is included by him. Now, the partition is entered into, it is acted upon, khatas have been changed, podis have been made, sales have taken place, all these things have happened. In none of those suits, my lord, he doesn't have any interim order. Now, my lord, my possession was sought to be interfered with. And hence, I filed the suit for permanent injunction based on the sale deed. At the first juncture, my lord, the trial court decreed, allowed the application and granted me an injunction. Then he took a contention that the boundaries mentioned to the property is not correct. My lord, in the written statement itself, my lord, that is the only contention that he took, apart from saying that he has filed other suits. My lord, on he filing the said written statement, my lord, I got the amendment of the plaint accordingly, and it tallies with the case that has been set up by the defendant himself. He challenged that amendment application before this honorable court. It was dismissed. Now, and hence to consider, my lord, my application on the amended plaint, the MA court, my lord, remanded the matter to the trial court. My lord, I gave up that IA1, and I filed a fresh IA, my lord, in IA number 14, with the amended schedule as per the saying of the defendant himself. And also by the survey sketch, my lord, it is fortified. Trial court grants me the interim order. Now, the matter goes before the first appellate court. First appellate court, my lord, passes the impugned order at Annexure T, says that there are partition suits, they all would be entitled to have a joint possession over the property, and hence there cannot be an injunction granted in my favor. And also boundary, my lord, is a thing that it speaks about. My lord, now, when he himself has filed a suit for preemption and says that he wants the cancellation of my sale deed, and my sale deed still holds the field, then, my lord, this order passed by the trial court is.
Where is that suit?
My lord, two suits, my lord. One is OS 54 of 2021, Annexure V, page number 205.
Page 205.
Please, my lord. Narsimurthy. My lord, Narsimurthy referred to therein is the first defendant.
When this is your prayer in the other suit that you have filed, declare that the plaintiff has preferential right to hold, purchase, acquire the suit schedule property, and you have also sought for a declaration in respect of the sale deed executed in favor of this person.
Yes. Additionally, my lord, one more suit has been filed by the defendants for partition and separate position in respect
regarding his ownership. There is an admission in your suit.
Yes, my lord. Yeah.
Therefore, as long as he is the owner of the property, why should not there be an order of temporary injunction restraining you from interfering with the suit schedule property?
My lord, initially, my contention in my written statement, my lord, the suit schedule property is ancestral and joint family properties.
Irbodu, sir. You also admit there was a partition, and in that partition, you have got some property in your favor.
My sincere apologies, my lord.
Yes.
That suit is at Annexure W, page number 238. The other partition and the declaratory 238. Lord, will kindly see the prior there. Lord, it is at page number 254. The prior, my lord, in that suit. To declare that as per the Paluparikat dated 15/4/1974, item number 1 to 11 properties shown in the suit schedule B properties are fallen to the plaintiff's share jointly through late Hanumantaya, son of Melagowda. My lord, that B schedule.
That as per Palupatti.
Palupatti. Please see the B schedule property, my lord, page number 260. Item number 10 and 11. It is survey number 30/1 and 30/3. 30/2 he doesn't include.
That is not the subject matter of the suit.
No, but what he said is alternatively, since he says that if Parukat is not proved, then grant me injunction. For that purpose, my lord, he makes a mention of other survey number 30/P is what he says, and mentions it in page number 258, my lord, item number 10. He doesn't say 30/2. He only says as 30/P. So his case itself is that there was a partition and he got this property under the partition.
ಇದರಲ್ಲೂ ಇದೆ ಪ್ರಿಫರೆನ್ಷಿಯಲ್ ರೈಟ್ ಬಗ್ಗೆ.
ಹೌದು.
That suit also,
Yes,
where
sir.
this alternative prayer?
There itself, page 254, my lord. First A ನಲ್ಲಿ to declare that as per Palu Parikat ಆದ್ಮೇಲೆ, in the alternative, the honorable court comes to conclusion that Parikat dated 15/4/1974 is not recognized as partition deed in the eye of law. Then to pass judgment and decree for partition and separate possession of the plaintiff's legitimate share by meats and bones. ಅಲ್ಲಿ schedule A property ಅದಕ್ಕೋಸ್ಕರ.
Yes, sir.
My lord, in my respectful submission, in a suit filed by the plaintiff, who is the petitioner, which is a bare injunction suit. It is not a declaratory suit. With uncertain boundaries, they went ahead with the filing of the suit and sought an interim order. Thereafter, when it was resisted and in the first round, it was taken up in MEA before the senior civil judge, and in the second round,
It is corrected.
it is corrected.
Yes.
And page number 180, Annex T is the order. To make out a prima facie case, my lord will be testing this order for the present. Whatever the contentions, I am on caveat. I may have to file detailed statement of objections on what kind of contentions are taken. Broadly speaking, considering the limitation of time, what is happened is that it's a common practice to make a gift deed between the parties to create a parental document when there is none. In this case also it has happened. This Lakshmamma, who happens to be the wife of Chandrasekhar. I made a genealogical tree, my lord, even though in a writ petition genealogical tree is not required. It partakes the character of a partition. A joint family property.
Has purchased the property.
No, Lakshmamma gets the property by virtue of a Pavati Kata.
ಅದಲ್ಲ ಸರ್.
ಅಲ್ಲ ಆಮೇಲೆ ಇವ್ರು ಪರ್ಚೇಸ್ ಅದಕ್ಕೆ ಆ ಸ್ಟೇಜಿಗೆ ಬರ್ತೇನೆ ನಾನು. Lakshmamma's husband is Chandrasekhar, who held a joint interest in the property along with the defendant number 2. That property is not partitioned as such. There is a partition suit which in fact my learned friend cannot draw any sustenance from the subsequent suit and pleadings. As on the date of filing of the suit, what was the position? Lakshmamma, wife of Chandrasekhar, had gifted the property to Sunita. Sunita sold the property to Ravi Kumar. Ravi Kumar filed the suit with a very erroneous description of the property, which was resisted by the defendant. Now the question which did fall for consideration by the trial court was that whether a prima facie case is made out by the plaintiff insofar as the possession is concerned. If the plaintiff were to file a suit with particular ABCD boundary, then goes for amendment, that amendment goes for rectification of the sale deed of Ravi Kumar without rectifying the gift deed of Lakshmamma in favor of Sunita. In fact, I'm sorry, my lord, the senior civil judge has dealt with all the aspects. I will take my lord through only relevant paragraphs as bullet points. I will not trouble since it is a detailed order. Whatever the contentions which have been taken, I will just draw my lord's attention to maybe at random, I will tell the page number so that I have marked it rather than taking my lord through the entire. Kindly see page number 190. Unnumbered para 3, internal page number 11. The defendant 2 and his family members have filed suit for partition and separate possession by meets and bound before the Honorable Principal Senior Civil Court in OS number 65 of 2021 against the respondent and his vendor and their joint family members only subsequent to execution of another sale deed dated 11/10/2021 and agreement of sale dated 11/10/2021, where it is clear that the suit schedule property is unable to be identified through meets and bounds, and it includes the other properties of defendants. This is one paragraph. The second paragraph, which supports the reasoning,
This is
para
the
15. Para 15.
This is the contention. 190, page 190 is the contention.
No, no.
that has been- how-
No,
Reasoning start agado from page number 194.
yes, my lord. I only brought to I didn't call it as findings to the extent, yes, I stand corrected, my friend. Reasons, my lord. Para 15. That is also again reasons. Findings will come. Para 17. Para 17, page number 197. In this case, the plaintiff sought for the relief only perpetual injunction against the defendant. In the nature of that relief, the plaintiff is burdened to establish his possession and enjoyment and interference from the defendants over the suit schedule property. According to plaintiff, the suit property is originally belongs to father of his vendor. Then Khata was mutated in the name of the vendor, mother of the vendor. Subsequently, the mother of the vendor and his sister executed the registered gift deed on 6/7/2019. As per the gift deed, these are the boundaries. Thereafter, the vendor of the plaintiff, Sunita, was executed a registered sale deed in favor of the plaintiff on 16/6/2021 in the sale deed bearing number so and so. As per the above said two documents, boundaries are one and the same. As per the plaintiff, and my lord, I will take my lord to the next para. When the defendant seriously disputing the said boundaries, the vendor of the plaintiff executed an amended sale deed dated 21/5/2022 and insert the correct boundary. Thereafter, para 22. I will read para 22, 23, and thereafter rest my case. The case of the plaintiff is that he has bona fide purchaser and he is in possession and enjoyment of the suit.
ಏನಂತ correct ಮಾಡಿದ್ದಾರೆ boundary?
ಅಲ್ಲ ಅವ್ರು ಎಲ್ಲ ಕರೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ರು, ನಾವು ಯಾವಾಗ
What is?
ಅಲ್ಲಿದೆ ಅಮೆಂಡೆಡ್ ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅವ್ರು
Yes.
ಅದನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಹೇಳಿದ್ದಾರೆ ಅವರು. ಐ ವಿಲ್ ಕರೆಕ್ಟ್. ರಿಟ್ ಪಿಟಿಷನ್ ಪ್ಯಾರಾ, ಇನ್ಫ್ಯಾಕ್ಟ್ ದ ರಿಟ್ ಪಿಟಿಷನ್ ಸ್ಟಾರ್ಟ್ಸ್ ಅಟ್ ಪ್ಯಾರಾ 2. The entire nature of the property in a correction change ಆಗುತ್ತೆ ಇದರಿಂದ. The plain schedule originally described was all that piece and parcel of the landed property.
Para 2?
Para 2 of the memorandum of writ petition at page number 4, as stated by the petitioner. The plain schedule originally described was all that piece and parcel of the land property in survey number 30/2 measuring 2 acres 22 guntas situated at Veerasandra village, Kasba Hubli, bounded by east Gomala, west land of Hanumantaya road, land of others and the land of Hanumantaya road and others land anta madadu. It was contended by the defendant respondent in the written statement the boundary to the suit property is not correct and the correct boundary is same east as 30 bar east correct. Now east property by survey number 30/3 and Gomala, west by property bearings number survey number 30/1 and road north. All the directions are changed. Now, when they filed the plaint with this description of the property, which is nothing but a derivative description from the sale deed, undoubtedly they cannot file a suit for injunction contrary to the boundaries which are fixed in the sale deed. The sale deed was consistent with the gift deed. After filing the suit and as defendant, I pointed out that this boundary is not the correct one and this does not pertain to the property which I am in possession. They realized the mistake, went and corrected the sale deed.
Sir, you are not contending that he is trying to come and interfere in your property.
So am I
He is protecting his property.
No, my written statement says he is in.
He has purchased under a registered sale deed.
Yes, Mullah.
You have also filed a suit for partition.
Yes.
In fact, you have filed 2 suits.
Yes, Mullah. One for preemption, one for
In
partition.
one,
Yes, Mullah.
you are trying to challenge the sale deed.
Yes, Mullah.
And you admit that one of your family members has sold it to him.
Not to him, to his predecessor in time. Not to him. No.
T. Sunita is who?
No. Sunita were to be a family member, she would have got. No, Sunita is the daughter of Lakshmama.
Therefore,
Yes, Mullah.
she is also a relative of his.
Maybe, yes, Mullah.
Isn't-
Yes, Mullah. Yes,
Then-
Mullah. Yes, Mullah. No,
Okay.
it is not a co-personary or a joint, my lord. What has happened in the whole case is that to summarize it.
Sir, you have admitted that there is a sale deed executed in his favor. Maybe there is a small
No, I have not
discrepancy.
admitted. I have not admitted.
You have filed a suit, sir.
No, my suit for preemption.
Please read the prayer.
Yes, Mullah. Yes,
Please read the prayer.
yes, Mullah. Put it towards the- Preemption. If my lord is referring to the preemption suit, my lord.
ಎರಡೂ ಅಷ್ಟೇ.
ಅಲ್ಲ, not binding ಅಂತ ಕೇಳಿದಾಗ ಅದು admission ಆಗಲ್ಲ. Let me put it in the perspective. My lord, if I admit a particular document, only if I seek a declaration that it is not binding, then to that extent, I don't admit the document. My lord will see this. To declare the plaintiff has preferential right to hold, purchase and acquire by the, under sale deed dated 16/6/2022. My lord, here the whole controversy has arisen.
You are seeking a declaration that sale deed dated 16/6/2021 executed by defendant 1 in favor of defendant number 2.
Yes.
The nullity.
Yes, ma'am. May I just clarify this position? Because I sorry for, if at all there is some repetition, kindly permit me. If at all I repeat it. My lord, a particular document.
As long as there is a sale deed in his favor.
My lord, sale deed.
Unless and until.
Yes, ma'am.
It is got declared.
Yes,
as a void document.
Would my lord endorse his possession? My lord, is the question I am posing it to myself. So long as the sale deed is in his favor.
Also filed a suit for partition, sir.
Here what has happened? My lord, partition.
You cannot claim exclusive right over that property.
A stranger
could also a member of the family.
My lord, a stranger is claiming here. Third party is claiming. It is not Sunita who is the plaintiff.
Sir, one of your family members has sold the property to him. That is an admitted position.
No, my lord, please kindly appreciate, my lord. May I submit, my lord? May I submit? If the assumption is that one of my family members have sold, the case takes a very different character than what I am projecting. I totally am in what I would say. I have to fall in line with what my lord. I mean, in any case, I am bound by what my lord is going to say. But I have to fall in line.
ಎರಡು ಕೇಸು suit file ಮಾಡಿ prayer ಮಾಡಿರೋದ್ರಿಂದ it is very clear.
That clear ಇರೋದು to remove the shadow on my title.
Correct. So long as that document remains and it is not set aside in a manner known to law. He is bound to protect his.
May I consider one? May I suggest one? May I suggest one aspect of the matter? In the written statement, I have taken a specific contention that he is interfering with my possession. I have taken a stand. It is not that what came out from my lord's mouth and I am improving the case. In the written statement. In the written statement, I have taken a specific stand that it is not me who is interfering with his possession. It is he, the plaintiff, who is interfering with the possession. Now, I would say that this matter may be kindly be taken up after the vacation. Till then, the status quo. If they are in possession, I will not interfere. If I am in possession, they shall not interfere. As an interim arrangement, which may not be to satisfy the conscience of the honorable court, and this may require detailed submissions, and my lord will dispose of the writ petition in whatever way it is found appropriate. I have taken a specific stand that he has interfered. Kindly see what page number. Page number. Written statement. Page number. Written statement. My lord, I have taken when I have taken a specific stand, what I would request the honorable court is that let the parties lay off their hands insofar as this property is concerned, because the snowball effect is that they go to station, trial court gives a police protection, and several things are happening on the ground. Now, in the written statement,
Yeah,
my lord,
what are you doing on
My
the
lord,
ground?
it is put under ragi cultivation.
Ragi.
I am cultivating ragi. He says, and my ragi, he comes and cuts it by saying that it is his ragi. Then it will become difficult.
No, the RTCs are there. It is standing in the
My lord, in
top
the-
of details is shown. They have got the presumptive value.
Petition only help it.
And that 30
Page number 17 may kindly be seen.
they have got the
My lord.
RTCs in their name. And long-standing katas, my lord. Even my vendor had the kata with him.
My lord, insofar as the property is concerned, they went on a speculative litigation that is subject to on the correct extent and boundary. As a responsible officer of the court, I would only suggestion to this honorable court is that whoever is in possession, let them remain in possession. We will file our objections, and if ultimately, if my lord were to hold that I cannot interfere in his possession, my lord, I will bow down for that. But the interim arrangement, we would be otherwise, if anything were to be decided in their favor, a person who is not in possession, in fact, they have filed, if they were to be in possession, they take police protection, my lord, before the trial court to gain entry into my property. In fact, they are there. When is the date? Date of birth. That was listed today. A person who is in peaceful possession will not take police protection. So kindly consider this limited indulgence, and we will argue the matter, file the objections, and whatever my lord decides will. Because any interim protection will be, stakeholders may misuse that. The status quo, as if I am in possession, I will remain. And if they are in, let them remain.
When was the temporary injunction granted by the trial court?
Lord, for the second time on 19th June 2024.
not too far.
Initially, my lord, for the first time, it was granted, my lord, on 29th October 2021.
21.
Please, that was in force, my lord, till the disposal of miscellaneous appeal, when it was remanded. Then on remand, my lord, the order was passed in the year 2020.
From 21 to 24. Sir.
No, there is a police protection IA between the two. My lord, there's a police protection IA between the two.
Learned Counsel Sri H.K. Onnegoda has entered appearance for response number 1 and 2. For both the respondents. Next para. Learned Counsel for the petitioner submits that having regard to the document of title in favor of the petitioner plaintiff, namely sale deed dated 16/6/2021. The trial court initially granted an ad interim ex parte order of temporary injunction on
29/10/2021.
29/10/2021.
Please, ma'am.
Full stop. The same was confirmed by allowing IA number 1.
Please.
Filed on order 39 rule 1 and 2 by order dated.
No, the order dated on IA number 1 is 29/10/2020. Originally, my lord, I do not know.
What is that?
No, IA 1 was granted and allowed on 29/10/2020.
But that was challenged before the
PMA court.
Ad interim alla. Passed an order on IA number 1. Filed under order 39 rule 1 and 2 by order dated so and so. Full stop. However, the appellate court passed the impugned order.
Thereafter, my lord, an order of remand was passed.
Intervening
Thereafter,
circumstances by
MA 13 of 2021 remanded the matter in view of the amendment of the plaint.
By what or which order?
My lord, Annexure M, my lord, page number 118. It is order dated 19/1/2023.
Page number 118.
118, please.
However, by order dated 19th of January 2023, the appellate court in MA number 13 of 2021 remanded the matter back to the trial court.
Please.
To reconsider IA number 1 and give fresh findings. Full stop. In the meanwhile, the petitioner plaintiff filed an application
IA 14
seeking amendment of the
plaint schedule. And the same was allowed. Please.
And accordingly, the suit schedule was amended. Full stop. Thereafter, the trial court once again passed an order.
No, my lord.
On IA 14, I filed a fresh IA because, my lord, even to IA number 1, I had to carry out the amendment. And hence I choose to file another application.
The petitioner plaintiff chose to file a fresh application under order 39 rule 1 and 2.
IA 14.
In IA 14.
It was resisted.
The trial court passed an order on 19/6/2024 allowing the application and restraining the defendants from interfering with the suit schedule property during the pendency of the suit. Full stop. The defendants approached the appellate court in MA number
5 of 24.
5 of 2024. And the appellate court has passed the impugned order on 20th of August 2024. Setting aside the order of the trial court and also dismissed IA number 14. ಎಲ್ರಿ dismiss ಮಾಡಿಲ್ವಲ್ರಿ?
That is done.
ಅಲ್ಲ, IA number 14, dismiss the IA number 14, allowed the MA.
Page 204, my lord. 204. MA
ಮಾಡಿಲ್ಲ.
allowed.
The miscellaneous appeal filed by the appellant are hereby allowed. The order of trial court on IA number 1 of order 39. Further, the trial court is there to reconsider. That is the original order.
ಹಾ?
ಇದು ತಗೊಳ್ರಿ.
ಈಗ
Issued order.
204, my lord. Page 204.
180.
Again it was sent back, is it?
Yes,
No,
ma'am.
no, only once it was sent.
What is this? Page number 204?
204, miscellaneous appeal is allowed. The order of
Send
trial
back the
court on
trial
number-
court records.
1 minute, please. The order of trial
Okay.
court on IA number 14 dated is
It has not dismissed the application.
ಇಲ್ಲ, only send back the trial court record.
Correct, correct. It has not dismissed the application.
no, it set aside the order on the application. It set aside the order on the application. And send back the trial court, the operative portion is 204.
What happened to the application?
ಅಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಇವಾಗ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಆದ್ಮೇಲೆ ಅದು ಅಲ್ಲಿಗೆ ಮುಗ್ದೋಗುತ್ತೆ ಅದು. ಅವ್ರ IA 14 ಏನು ಇರೋದಿಲ್ಲ. IA 14 ಇರೋದೇ ಇಲ್ಲ.
No. The appellate court was required to dismiss the application.
Yes, ma'am. Yes, ma'am.
ಅದು ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಅದು ಅವರು my appeal came to be allowed. My appeal came to be allowed.
All right, all right. We'll come to it. We'll come to it. ಏನ್ ಹೇಳಿದೆ? Setting aside the order passed by the trial court. Full stop. Learned counsel submits at this juncture that the appellate court has chosen not to pass any orders in respect of the IA expressly. Full stop. Even otherwise, comma, the learned counsel would further draw the attention of this court to Annexure B, which is a suit in OS number 54 of 2021, filed by the second respondent herein. Where the prayer is to declare that the plaintiff has preferential right to hold, purchase and acquire the suit schedule property by paying sale consideration amount already fixed in the sale deed dated 16/6/2021, which is nothing but the sale deed of the petitioner herein. Full stop. The second respondent, plaintiff, has also sought for a declaration that the sale deed dated 16/6/2021 executed in favor of the petitioner herein is a nullity in the eye of law and not binding on the preferential right of the plaintiff. Full stop. The second respondent has filed one more suit in OS number
65 of 2021.
65 of 2021, along with other members of the family, of his family, seeking partition and separate possession, seeking a declaration that as per Palu Parikat dated 15/4/1974, the two items number 1 to 11 in Schedule B property have fallen to the share of the plaintiffs, or in the alternative that the court should come to a conclusion that the Palu Parikat dated 15/4/1974 is not recognized as partition deed in the eye of law, and therefore, as a consequence, to pass a judgment and decree for partition and separate possession of the plaintiff's legitimate share in respect of item number 1 to 11 of Schedule B property. Full stop. There are several other prayers also made by the second respondent along with his family members. Full stop. Learned counsel would therefore submit that the very fact that in both the sale deeds, in both the suits filed at the hands of respondent number 2 herein, there is a clear admission that the petitioner has purchased the suit schedule property under sale deed dated 16/6/2021.
21. In its unamended form, my lords. In its unamended form, not in the form in which the, I'm sorry.
We have not still come to the question of the boundaries.
Yes.
That is not the issue. Full stop. That being the position, comma, the appellate court has erred in not taking into consideration these relevant aspects, and when there is a clear admission on the part of the defendants that the petitioner plaintiff claims title over the suit schedule property under registered sale deed dated 16/6/2021, and by law possession follows title, comma, the appellate court could not have set aside the order passed by the trial court. Full stop. Next para. Per contra, learned senior counsel Shri Shankar Narayan Rao, appearing for the respondent defendants, submits that admittedly the plaintiff has, during the course of the proceedings, amended the suit schedule property. Full stop. The appellate court has therefore taken note of the fact that the plaintiff amended the suit schedule property after filing the same and after the trial court had granted an order of temporary injunction based on the said boundaries shown in the suit schedule. Full stop. The learned senior counsel would therefore submit that the appellate court is right in its finding that there was a discrepancy in the boundaries and identification of the suit schedule property. Full stop. It is therefore submitted that the appellate court has rightly taken into consideration all these aspects, and since it found that prima facie case was not made out by the plaintiff, comma, the impugned order has been passed. Full stop. The learned senior counsel would also submit that since there are disputed questions, this court may direct the parties to maintain status quo till the matter till this writ petition is decided. Full stop. Next para. Having heard the learned counsel for petitioner and the learned counsel or senior counsel for the respondents, and on perusing the petition papers, comma, this court finds that the appellate court has given unnecessary weightage to the fact that the suit schedule property was amended during the course of the proceedings. Full stop. In the considered opinion of this court, merely because the suit schedule was amended after the trial court had granted the order of temporary injunction in favor of the plaintiff, comma, by itself will not disable the plaintiff to seek an order of temporary injunction after the amendment of the suit schedule. Full stop. At any rate, there is a clear admission on the part of the respondents, having filed two subsequent suits where a declaration is sought in respect of the sale deed dated 16/6/2021 got executed by the petitioner plaintiff. Full stop. Therefore, comma, in law, comma, as rightly submitted by the learned counsel for petitioner, comma, the petitioner having acquired right title and interest over the suit schedule property under registered sale deed, comma, is entitled to protect his possession. Full stop. In that view of the matter, comma, this court finds that the appellate court has erred in setting aside the order passed by the trial court. Full stop. Next para. Consequently, the writ petition is allowed. The impugned order dated
28/2024.
passed in MA number
5 of 2024.
is hereby passed and set aside. Full stop. The order passed by the trial court on IA number 14
please.
stands confirmed.
Great.
Yes.
Expeditious disposal of the suit, at least, my lord. That is the last. I never knew, I never knew that the honorable court will be quick enough to dispose of the very writ petition. I was only trying to work out an interim arrangement. Now
ಯಾವ
it-
ವರ್ಷದ ಸೂಟು
21.
2021
ಅಲ್ಲ ಒಂದು ಅದನ್ನ ಯಾಕೆ ಅಂತಂದ್ರೆ ನಾವು since the after the dictation is complete, I am not expected to argue the matter. I was only saying that without amending the mother document, they went ahead with it. But they went ahead. All those things I will not press now. Now at least kindly consider the some time bound direction.
ಎರಡು ಸೂಟ್ ಬೇರೆ ಫೈಲ್ ಮಾಡಿದ್ರಲ್ಲ ನೀವು
ಅಲ್ಲ ಅದಷ್ಟು ಅದು ನಡೆಯುತ್ತೆ
ಏನ್ ಮಾಡೋದು? That
ಅಲ್ಲ
is also pertaining to the same
ಅಲ್ಲ ಇದು ಇವ್ರ ಸೂಟ್ ಆಗ್ಲಿ ಇವ್ರ ಸೂಟ್ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ. ಆ ಸೂಟ್ ಅಲ್ಲಿ ಈಗ ತಾವು ಕನ್ಫರ್ಮ್ ಮಾಡಿದೀರಾ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ನ.
ಅಲ್ಲ,
ಇದು ಪರ್ಪೆಚುಟಿ ಆಗೋಗುತ್ತೆ ಇದು.
I don't know, you should think whether you want this suit to be disposed much before that suit.
ಅಲ್ಲ ಯಾವ್ದನ್ನ
Because you are seeking a declaration there.
ಅಲ್ಲ ಒಂದು ಇಂಜಂಕ್ಷನ್ ಆಯ್ತು I leave it.
Yes.
ಅಲ್ಲ ಅದು ಒಂದು ಇನ್ನೊಂದಿದೆ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಬೇರೆ ಆಗಿದೆ ಅಲ್ಲಿ, ಅದು ಸೆಪರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂತ ತಾವು ಹೇಳ್ತೀರಾ ಅದನ್ನ. ಆಯ್ತಾ ಮೊಬಿಲೈಸ್.
Yes, great, yes.
Number 19.
Plaintiff's petition. Plaintiffs are owners of A schedule property. B and C schedule property are encroached by defendants number 1 and 2. Lord, the suit is for declaration of title, for
And possession.
possession and for removal of encroachment. Lord, suit was dismissed, an appeal was filed. In the appeal, the matter was remanded, and the appellate court at the time of remand gave a clear direction that there must be a commissioner appointed who must mark the encroachment. My lords may kindly see that order, my lord, is at page 86. The matter is remanded back to the trial court. Trial court is directed to appoint ADLR as court commissioner to survey the suit survey number and property of both defendant and to know the encroachment. My lord, a report was called for by the trial court again. That report again was set aside. It was rejected by the trial court on the ground that he has not shown where the encroachment is, especially where the building is. It was not demarcated. So again, the same ADLR was asked to file. Second time when he files a report, that has been accepted. That order, I have question before this honorable court. My lords may kindly see, my lord, the commissioner's report is at page 100. Again, my lord, he does not show the building. Admittedly, my lord, the defendant's contention is that they have encroached property in the neighborhood of the property of the plaintiff. It is not their case that they own any property. In the written statement.
You are the plaintiff.
I am the plaintiff. In the written statement, they clearly say, page 37. They clearly say that it is an encroachment. My lord, page 37, paragraph 8 is the written statement about I am permitted to read, that the predecessors of defendant number 1 were also tenant for an extent of 10 guntas of land in survey number 192/2 of Javali village under 1 BL Ramadas Gowda, and the said BL Ramadas Gowda has given an extent of 10 guntas in favor of defendant number 1. But khata of the land was given to defendant number 1, which was given to defendant number 1 still in the name of BL Ramlinga Gowda. The defendant number 1 encroached an extent of 6 guntas of land in survey number 30 of Javali village, and he is in possession. That is the case of first defendant. Second defendant, my lord, paragraph 9, that the predecessors of defendant number 2 were in possession, occupation and enjoyment of an extent of 8 by 10 meters of land situate in survey number 30 of Javali village. The Gram Panchayati Khata has been mutated by defendant in the name to the name of the defendant number 2. It is not their case, my lord, that they have title to the property. So my only grievance, my lord, is if the commissioner were to put the building on the map itself, it is clear whether there is encroachment. Illa ತೋರಿಸಿದ್ದಾರೆ. That is the only grievance.
ಮನೆ ಜಾಗ ತೋರಿಸಿದಾರಲ್ಲ ಇದು
Page 100. ಅವರು ಬರೀ ಇದನ್ನ ಇವ್ರ ಜಾಗ ಅವ್ರ ಜಾಗ ಅಂತ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. 30 ಬರುತ್ತೆ.
ಮನೆ ಜಾಗ ಅಂತ ಡಿಲಿನೇಟ್ ಮಾಡಿ ತೋರಿಸಿದಾರಲ್ಲ. ಮೂರ್ ಪೋರ್ಷನ್ ತೋರಿಸಿದ್ದಾರೆ.
ಅದೇ ಮನೆ 3 ಜನದ್ದು ಮನೆ ಇದೆ, ನಮ್ದು ಮನೆ ಇದೆ, ಅವ್ರದ್ದು ಮನೆ ಇದೆ. ಇದು ನೋಡಿ, if he demarcates the house,
ಯಾರ್ದು ಯಾವ್ದು ಅಂತ ತೋರಿಸಿಲ್ಲ ಅಂತ.
ಯಾವ್ದು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. And if he demarcates it on the sketch, it is over, my lord. It will become a clear thing. There is nothing stopping him from demarcating it. According to this survey, my lord, the defendants themselves don't claim this.
Please come to this ಕೆಳಗಡೆ ಶರಲ್ಲಿ
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ ಇದರಲ್ಲಿ ಅವ್ರ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ, ಅವ್ರ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ.
ಹೌದೌದು.
My lord, the question is, my lords may kindly see the plaint, the schedule in the plaint. I have clearly stated the boundaries of B and C schedule property along with measurement. ಅಷ್ಟ್ರಲ್ಲಿ ಅವ್ರ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅದನ್ನ ತೋರಿಸ್ಬಿಟ್ರೆ ಆಗುತ್ತೆ. ನಮ್ದ್ರಲ್ಲಿ ಇಲ್ದೆ ಹೋದ್ರೆ ಆಗ್ಬೋದು, ನಮ್ದ್ರಲ್ಲೇ ಬಂದ್ರೆ
ಅಲ್ಲ. ಇವಾಗ
ಅವ್ರದ್ದೇನಾಗಿದೆ,
ಚರಾದಲ್ಲಿ 1 ನಲ್ಲಿ he has given the identification saying ABCD JH
ಅದರಲ್ಲೂ
ಎಂಬುದಾಗಿ ನಕ್ಷೆಯಲ್ಲಿ ಗುರುತಿಸಿರುವ ಪ್ರದೇಶವು ಸರ್ವೆ ನಂಬರ್ 30 ಪೈಕಿ 3 ಗುಂಟೆ ಅಲ್ಲ 0.03 ಗುಂಟೆ ಇದ್ದು ಅದರಲ್ಲಿ ವಾದಿಯು ಅನುಭವದಲ್ಲಿ ಇರುತ್ತಾರೆ. ಅದೇ ತರ ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ 1ನೇ ಪ್ರತಿವಾದಿ ಅನುಭವದಲ್ಲಿ ಇರುತ್ತಾರೆ, 3ನೇದು 2ನೇ ಪ್ರತಿವಾದಿ ಅನುಭವದಲ್ಲಿ ಇರುತ್ತಾರೆ.
What happens, my lord? A schedule property is 10 guntas of land that is belonging to me.
ಆಯ್ತು.
If he shows where these buildings are there on A schedule property, ಅದೇ 1ನೇ ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಇದರಲ್ಲಿ ಇದು ಮಾಡಿದ್ದಾರೆ, ಡಿಮಾರ್ಕೇಟ್ ಮಾಡಿದ್ದಾರೆ, HJDEFGH ಎಂಬುದಾಗಿ ಗುರುತಿಸುವ ಇದರಲ್ಲಿ. If he shows where the land is on the sketch, my lord, what happens is
he is also given the extent.
Building, my lord, is can be demolished and reconstructed, can be done. It is a suit for declaration of my title, and I am seeking possession of that particular area in my land.
ಹೌದು.
Now, my lord, if he demarcates
if this marked portion showing the possession of defendants number 1 and 2 is within your property.
That is all, my lord. If he shows my building and their building separately in each of those areas where he shows.
ಮಾಡಿದ್ದಾರೆ, ತೋರಿಸಿದ್ದಾರೆ.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ, ಅದರಲ್ಲಿ ಓನ್ಲಿ ಲ್ಯಾಂಡ್ ಶೇಡ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ, ಆ ಜಾಗ ಮಾತ್ರ ತೋರಿಸಿದ್ದಾರೆ.
You please see properly. ಆ ABCDH ಅನ್ನೋದು ಮಧ್ಯದಲ್ಲಿರೋದು, ಅದು ನಿಮ್ ಪರ್ಸನ್ ಇರೋದು.
ಅಲ್ಲ, ಅದೇ ಅವರು ಮನೆ ಜಾಗ ಅನ್ಬಿಡ್ತಾರೆ ಅಷ್ಟೇ. ಅವರು ಇಫ್ ಹಿ ಕ್ಯಾನ್ ಶೋ ಯಾವ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ, the boundaries of this thing, how, then it will be clear. In fact, my lord, what he gives, adaralli ond gray area ide, where all 3 people are claiming that piece of land. ಅವ್ರ ಮನೆಯನ್ನು ಮಾರ್ಕ್ ಮಾಡ್ಬಿಟ್ರೆ ಸ್ಕೆಚ್ ಮೇಲೆ ಅಷ್ಟೇನಾ?
ನಿಮ್ದು ಸರ್ವೆ ನಂಬರ್ 30 ನಾ ನಿಮ್ದು?
ನಮ್ದು ಸರ್ವೆ ನಂಬರ್ 192/2.
192.
ಅವ್ರದ್ದು 30 is government land. ಅವ್ರು ಹೇಳೋದು ನಾವು ಅದನ್ನ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಂಡು ನಾವು ಅಲ್ಲಿ ಅದ್ರ ಮೇಲೆ ಕಟ್ಟಿದೀವಿ ಅಂತ. Admittedly, they are encroaches, they are not this thing.
192/2 ಅಲ್ಲಿ ನಿಮ್ದೇ ಮನೆ ಇರೋದು, ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಭಾಗ ವೇಕೆಂಟ್ ಇದೆ.
ಹೌದು. ಅವ್ರ 3 ಮನೆನೂ ಡಿಮಾರ್ಕೇಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಮೆಲಾರ್ಡ್ ಇನ್ಫ್ಯಾಕ್ಟ್
ರೋಡ್ ಇಂದ ಆ ಕಡೆಗೆ ಇದೆಯಲ್ರಿ,
he has been cross examined ಲಾರ್ಡ್.
ರೋಡ್ ಇಂದ ಆ ಸೈಡ್ ಇದೆ ಅವ್ರದ್ದು ಇನ್ನೊಬ್ಬರದ್ದು ಮನೆ.
ಅದೇ ತಪ್ಪು ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ರೋಡ್ ಇಂದ ಈ ಕಡೆಗೆ ಅವ್ರ ಬೌಂಡ್ರಿ ಇದೆ. ಇನ್ ಹಿಸ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಲಾರ್ಡ್ he shows his boundary. ಅದರಲ್ಲಿ 3 ರೋಡ್ ಬರುತ್ತೆ. Lord, at page 38.
You were allowed to cross-examine the.
He has admitted, my lord, that he has not demarcated those areas. My lord, the remand order clearly says he must demarcate encroachment. If he demarcates the building, that is the encroachment. He does not demarcate the building. Sketch alli our building ಎಲ್ಲಿ ಬರುತ್ತೆ 3 building ಅಂತ ತೋರಿಸ್ಬಿಟ್ರೆ. In fact, the first report, my lord, has been rejected on that ground itself. That also I have filed, my lord.
Where is that sketch?
There he didn't prepare a sketch also. But there he filed a report to the court where the court said, what is the purport of the whole report?
What is the extent of the suitable property?
10 guntas.
10 guntas.
A schedule is 10 guntas, B schedule is 2000 square feet, C schedule is 4800 square feet, which 6800 square feet has been encroached out of 10 guntas. The earlier report, page 97, ink page 97, which has been rejected by the trial court.
Issue notice to the respondents. The petitioners are also permitted to serve copies of the petition along with annexures on the learned counsels representing the respondent before the trial court. Full stop. Next paragraph. Learned counsel for the petitioner submits while drawing the attention of this court to the sketch submitted by the court commissioner, namely
ADLR Mudigere,
Assistant Director of Land Records, Mudigere, that in spite of the rejection of the earlier report for want of clarity regarding the exact place where the constructions were put up by the defendants, similar type of a report has been filed by the ADLR. Full stop. It was pointed out from the Shara found along with the report that although the ADLR is of the opinion that he has delineated the portion of 0.03 guntas of land in survey number 30 showing the possession of the petitioner plaintiff, comma, nevertheless, in respect of defendant number 1 also, it is stated that he is in possession of the portion marked as A, H, K,
AH1.
AH1, K, L, M, A in survey number 30. But it does not specify the extent of construction. Full stop. It was also pointed out that the suit schedule property claimed by the plaintiff is survey number 192/2 and not survey number 30 as mentioned in the report. Full stop. Learned Counsel submits that in spite of these discrepancies, the report has been accepted by the trial court. Full stop. Next para. Consequently, there should be an ad interim order of stay of all further proceedings. In OS number 51 of 2015, on the file of the Principal Senior Civil Judge and JMFC, Moody Gare till the next date of hearing.
Great.
20, scene number 20, MB Chandrakudu.
Defendant revision petition. Suit for specific performance have been filed before the trial court.
You are the defendant.
And the defendant. On 16/1/2018, the suit was filed. I was not served with the summons. A report has been submitted by the process server. It was tendered to me. I refused the receiver the summons is concerned. Based on the report of the process server, the suit has been decreed. Then an execution came to be filed within 3 months before the trial court. Your Lordship may kindly take the execution proceedings at page 104. Typed copy of the page 123. Without issuing a notice in an execution petition filed by the decree holder, sale deed came to be executed. Lordship may kindly take page 123. Page 123. Dated 24/6/2019. Case card. The decree is not more than 2 years old. Hence, call on for draft sale deed. Not even a notice has been ordered to me. Draft sale deed, the sale deed came to be executed. First date of order sheet itself. Page 124, sale deed came to be executed on 21/12/2019 by the court commission. Thereafter, there was no decree for possession is concerned, so in the specific performance. An application was moved by the decree holder for possession is concerned. Then the notice came to be issued to me. I appeared before the trial court and filed my objections. My objections were overruled. The delivery warrant came to be issued. Then when I came to know about the ex parte decree, I filed a petition under 9 Rule 13 before the trial court. The trial court dismissed the application holding that since I refused the summons, there cannot be a decree for setting as an ex parte decree is concerned. So far as the refusal is concerned, may I request your Lordship kindly take Order 5 Rule 17. The procedure itself has not been followed by the trial court. Order 5, Rule 17. Procedure when the defendant refuses to accept the notice or cannot be found. Where a defendant or his agent or such another person, as aforesaid, refuses to sign the acknowledgement, or where the serving officer, after using all due reasonable diligence, cannot find the defendant, who is absent from his residence at the time when the service is not to be effected on him at his residence, and there is no likelihood of his being found at the residence within the reasonable time, and there is no agent empowered to accept the service of someone on his behalf or any other person on whom the service can be made, the serving officer shall affix a copy of the summons on the outer door of or some other conspicuous part of the house in which the defendant ordinarily resides or carries on the business or personally works for gain, and shall then return the original to the court from which it was issued with a report endorsed thereon or annexed thereto stating that he has also affixed a copy annexed thereto stating that he has so affixed the copy, the circumstance under which he did so, the same address of the person, if any, so affixed so and so. Then you will ask me kindly take Karnataka Amendment, Rule 19. Rule 19. Examination of a serving officer, where a summons is written under Rule 17. The court shall, if the written under the rule has not been verified by the affidavit or the serving officer, and that may, if it has been so verified, examine the serving officer on oath, or cause him to be so examined by another court, touching his proceedings, and may make further inquiry in the matter, so and so. So my submission is, the summons has been returned without there being an affidavit supported by the process server, is accepted by the trial court, granting a degree of specific performance. May I pass on the endorsement by the process server before the court? That is the only ground on which my application to Order 9, Rule 13 has been rejected by the trial court. There is no affidavit, there is no witness to show that that summons was tendered to me, I refused it. No witness has affixed a signature to the summons, and there is no affidavit filed by the process server. And that being the case, the examination of the process server is mandatory.
ಕೊಡಿ ಅದು ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೊಡಿ, ಅದರಲ್ಲಿ ಕೊಡಿ. Order 5, Rule 17. What are you challenging here?
I am challenging the order passed by the trial court under Order 9, Rule 17, miscellaneous petition, and an appeal filed by me before the appellate court, as well as the execution proceedings. The trial court refers to I refuse to receive the summons. In miscellaneous petition also, very same finding has been recorded. Even the appellate court also done the same thing.
ಏನು ಅಮೆಂಡ್ಮೆಂಟ್ ಏನೋ ಓದಿದ್ರಲ್ಲ ನೀವು, ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್
Rule 19. 19.
19.
ಹೌದು. Examination of a serving officer. Where a summons is returned under Rule 17, that is Rule 17 I read out. The court shall, if the return under the rules has not been verified by an affidavit of the serving officer, and may, if it has been so verified, examine the serving officer on oath, or cause him to be examined by another court, touching his proceedings, and may make further inquiry in the matter as it thinks fit, and shall declare that the summons has been duly served or order service as it thinks fit. This exercise has not been done by the trial court passing the decree. Even before the miscellaneous petition also, I have taken specific contention. Kindly take paragraph number 3 of the judgment of the trial court, page 920. Page 920, paragraph number 3, judgment of the trial court in OS 66 of 18. The summons issued to the defendant by this court as returned as refused. Therefore, the defendant was placed ex parte. ಇಷ್ಟೇ ಮಾಡೋದು. ಅಪ್ಪ ಇದು ಮಿಸ್ಲೇನಿಯಸ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಪೇಜ್ 52.
ಬರ್ಕೊಳ್ಳಿ. Issue notice to the respondent. The petitioner is also permitted to serve copy of the petition along with annexures on the learned counsel representing the respondent before the executing court. Next para. Learned counsel for the petitioner submits that although it is true that the petitioner, defendant in the suit refused to receive the summons nevertheless Rule 19 of Order 5 mandates that under such circumstances the court shall, if the return under the rule has not been verified by the affidavit of the serving officer, examine the serving officer on oath or cause him to be so examined by another court touching his proceedings, and may make such further inquiry in the matter as it thinks fit, and shall either declare that the summons has been duly served or order such service as it thinks fit. Full stop. While drawing the attention of this court to the report submitted by the process server, learned counsel submitted that it does not disclose an affidavit being filed as required by law. Full stop. Therefore, the presiding officer of the court was required to follow the procedure contemplated in Rule 19. Full stop. Despite these aspects being brought to the notice of in the miscellaneous petition filed at the hands of the petitioner, the petition has been rejected. Further, it is pointed out that the executing court has also erred in proceeding to call upon the decree holder to pay the balance sale consideration and proceeded to execute the sale deed, without even issuing notice to the judgment debtor. Full stop. Copy of the order sheet maintained in execution case number 34 of 2019 has been furnished at annexure L. Full stop. Learned counsel submits that the executing court has issued warrant to the court commissioner.
Delivery warrant.
Has issued delivery warrant.
180 ಆಗಿದ್ದು reissue ಮಾಡಿ 19th issue ಮಾಡಿ.
Full stop. Next para. Consequently, there shall be an ad interim order of stay of all further proceedings. In execution case number
Execution case number 34 of 20. 34 of 19, sorry.
34 of 2019 on the file of the additional senior civil judge and JMFC, KGF till the next date of hearing.
Not for hand delivery.
Order serial number 21, DM Manjunath.
Two weeks' time is granted to the petitioners to take steps for service of notice on the unserved respondents.
Serial number 22, YK Narayan Sharma.
For petitioner, this week's time, Lord. Look into, there is an objection.
A week's time is granted at the request of learned counsel for petitioners for complaints of office objections raised on IAS.
Yes.
Serial number 23, Omkara
My lord.
KB.
Appearing for petition, my lord. My lord, they have filed objection, my lord, compliance affidavit. We have to file objection, my lord, seeking 2 weeks time to file objection.
It can be disposed of. I have no objection for allowing the writ petition. But what
My
is
lord,
challenged is, what is challenged is,
detailed hearing is required, my lord, in this case. They have filed. Need to
it
file
may be
a.
allowed, I am saying.
The other side is saying allow the petition.
The
No, my lord, kindly hear the matter, my lord, before allowing this, my lord.
I'm conceding. Writ petition is filed challenging the compromise decree entered before the Lok Adalat on the ground that I obtained the power of attorney of defendant number 1 to 27. I was defendant number 28. I obtained the power of attorney.
Connected case also, my lord, in this case. My lord, connected case also in this
My
case.
friend may kindly
Pleading
permit.
application is also filed without hearing all the parties.
Nothing is required. Some busy bodies
It is
want to
required.
enter
It
appearance.
is
There is
required,
no private
sir. That is the reason why they are seeking for disposal, my lord. We have to bring so many things to before this honorable court.
They are not.
There is one more writ petition connected to this case. Senior counsel has appeared, my lord, last date of hearing.
There is something I really do not understand. The allegation is defendant number 28 obtained the power of attorney of defendant number 1 to 27 and represented them before the Lok Adalat. The plaintiff played a fraud and I played a fraud. Now, the power of attorney fraud and all, my lord, there is a judgment of this court, they have to file a civil suit. I am not even saying that. The only contention is defendant number 1 to 27, they could not appear before the Lok Adalat because they were represented by me on the basis of a alleged power of attorney. What I am saying is let the matter go back to the civil court. If all of them want to enter appearance before the Lok Adalat in a fresh compromise, let them do it. That's all I am saying. On that ground, it may be allowed.
Another connected matter, they have challenged very.
That's a KLR matter. It has to be de-linked. It has nothing to do with
Yes,
this
my lord.
matter. Some public interest litigation is filed saying that I have encroached the government land. They filed a representation to the government and the action has to be. That's a PIL filed by neighborers.
You are appearing in the connected matter.
Petitioners for the connected matter, my lord. My lord, senior counsel is on his legs.
That may be
You are dealing that matter.
That's a KLR matter. It has nothing to do with this.
I'm okay with this. Kindly, 2 weeks time, my lord, after have it on after.
Learned senior counsel Sri Basuraj appearing for the respondents. A particular respondent say yaru?
Respondent number
8C.
8C.
8C. After who is that defendant number 28?
Defendant number 28.
Nivena?
Yes, yes.
8C.
8C.
8C, my lord.
Let kindly see the allegations in paragraph.
Who was that original
Kindly see
defendant
the
number
paragraph
28?
17. Paragraph 17. Paragraph 17 of the writ petition. This is the only allegation. It is relevant to mention that Ramesh Raju, that is myself,
Yado?
Paragraph 17. my lord.
Paragraph 17.
Yes, my lord. The Ramesh Raju, that is myself, who was defendant number 2C before the trial court, I think, fabricating the special power of attorney, therefore filing the compromise petition, has filed interlocutory application seeking to reject the plain so and so, so and so. The allegation is that I obtained the power of attorney.
The allegation is against you only. 8C. 8C.
Yes.
Hearing for the contesting respondent number 8C, namely Ramesh Raju.
Yes, ma'am.
Submits that the petition may be allowed. Full stop. The allegation is against the said respondent number 8C.
Yes, ma'am. But in
Ramesh
that,
Raju.
my lord, only one sentence in paragraph 6 at page.
That
Paragraph 6 at
Yes.
page 16. ma'am.
fabricated a special power of attorney and represented defendants number 1 to 27
Yes, ma'am. Paragraph 6 at page 16.
before the Lok Adalat
Yes.
and entered into a compromise with the plaintiff,
Yes.
thereby defeating the rights of the other defendants.
Yes.
Full stop. Learned senior counsel submits that without going into any other contention, the writ petition may be allowed while setting aside the compromise decree.
On the ground, they were not represented. They did not appear before the Lok Adalat. That's all.
So that the matter may be relisted before the trial court.
Yes.
And if all the parties thereafter want to enter into a compromise, they may be permitted to do so. Full stop. Next para. Learned counsel for the petitioners submits that if the contesting respondent, defendant number, respondent number 8C, makes such a submission to set aside the compromise decree, then the petitioners will have no grievance. Full stop. Next para. Accordingly, the writ petition is allowed.
My lord, may make a submission.
Prayer.
The impugned judgment and decree
Annexure A. ma'am.
passed by the learned senior civil judge and JMFC Kunigal in OS number 52 of 2021 on 3/1/2022 is hereby quashed and set aside. Full stop. The original suit in OS number 52 of 2021 is restored to the original file of the learned senior civil judge and JMFC, Kunigal for fresh consideration. Full stop.
Well,
Ordered accordingly.
My lord, the interim order, because my lord, there may
have to.
every possibility that they may change the nature.
Compromise decree is set aside.
Everything is gone.
In then the
There is
interim
no
order may
decree only now. There is no decree. It is gone now.
true, my lord. But there is every chance that, my lord, they will send sell the entire suitable property, my lord. Till then, the interim order may be this thing.
How
my lord.
can they
Interim-
sell it now, sir, after the decree
Everything
is
is
set aside?
gone. Everything is gone.
They have made alienation of the suitable property, my lord.
Starting
That's
with
what they have challenged in another repetition.
WP number 19344 of 2023 stands dealing from this matter. You know, they have already sold the property now.
Yes, my lord. That's
No,
what
no,
they have,
no. You have
they have,
not
my lord, they have made alienation in the year 2014 itself, my lord. That's what challenged in another repetition. By virtue of this, my lord, they have already sold so many suitable properties, my lord.
You are concerned with the judgment and decree.
True, my lord. But till then, my lord, it takes some time, my lord. There is every possibility that they will.
But there was no interim order.
3/1/2022, sir.
But alienation was done in the year 2014 itself, my lord.
What interim order, sir?
My lord, they should be
What
prohibited
interim order was granted by this court?
changing the nature of the social property, my lord, at least.
Huh?
Last date of
What they did is,
last date of hearing, this
they
honorable
ma-
court
they
had issued
made a
some-
wrong submission that based on the compromise, I have converted the land. The conversion took place much earlier. A wrong submission
that
was
was,
made.
my lord, that
Based on
shows
that,
that
this court
they
said,
are playing
this is
fraud,
status
my
quo. They let them go appear before the trial court. and
That shows that they have played a fraud even before partition suit was filed.
Yes.
Appeal number 24. Kam Prashanta S.
Petitioner, and summons served on the respondents. And summons served on the respondents.
And summons was issued.
Serve ಮಾಡಿದೀವಿ ಅದು.
And summons was issued by this court.
Issued that was served. Respond number 4, 2, 4 and 5 minutes.
And summons was issued to whom?
Respondent number 1,
Unserved respondents.
yes, 1, 2, 3 and 5.
Learned counsel for the petitioner has filed memo dated 14/9/2024 along with the hand summons issued to response number 1, 2, 3 and 5. Full stop. As could be seen, the concerned respondents have received the hand summons. Nevertheless, there is no representation. Hearing?
For 2, 4 and 5 minutes.
For
2, 4 and 5. We are on the
2, 4 and 5.
5.
However, ಅಂತಿದೆ ಅದು ತೆಗೆದಾಕ್ಬಿಡಿ. Learned counsel Shri. Next para, learned counsel Shri.
M. Prakash. M. Prakash.
Ivura.
My colleague. Shyam Prashant.
M. Prakash.
Yes.
You only want to appear.
No, I already on record, my lords. Wakalat is filed. That is where that.
ಅಲ್ಲ ಈಗ 2, 4, 5 ಗೆ.
The wakalat is already filed. We are on record.
2, 4, 5.
How's? That is where I told.
After this hand summons was served, you have come, you
Yes.
appeared.
Yes, I appeared and filed wakalat.
Learned counsel Shri. Shyam Prashanta.
I'm for petitioner. They are the Shyam Prakash.
Sorry. Mr. G. Manivannan
G. Manivannan and M. Prakash, both colleagues.
has entered appearance for response number 2, 4 and 5.
Please.
Stop. Response number 1
And 3.
1 and 3 are placed ex parte. Yes.
Agency matter may be listed on Friday.
5.
Yes.
Akash VT.
This matter requires 10 to 15 minutes of hearing minutes.
Huh?
They're ready. 10 to 15 minutes of hearing it may require.
So ಆಗಲ್ಲಮ್ಮ. Not possible.
ಪ್ರಾಬ್ಲಮ್ ಏನಂತಂದ್ರೆ ಅಲ್ಲ ಐ ಅಗ್ರಿ ಅಲ್ಲಿ FDP ನಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ ಅವ್ರ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ವರ್ಗು ಬಂದ್ಬಿಟ್ಟಿದೆ. ನಮ್ದು ಸೂಟ್ ವಾಸ್
ಅಲ್ಲ ಆಯ್ತು ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನ.
ಮತ್ತೆ ಏನ್ ಮಾಡೋದು?
Suit was decreed ex parte, we challenge.
Cannot be taken up at that.
ಅಲ್ಲ ಅಷ್ಟು ಬೇಗ ತಗೊಳಕ್ ಆಗಲ್ಲ.
Orders.
27th ತಗೊಳಕ್ ಆಗದ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ತಾವೇನಾದ್ರು ನಾಳೆ ಮಧ್ಯಾಹ್ನನೋ ಅಥವಾ ನಾಳೆ ಮಧ್ಯಾಹ್ನ 2:30ಗೋ ಅಥವಾ 27th ತಗೊಂಡ್ರೆ
ಅವತ್ತು ಆಗಲ್ಲ, ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ ಅಲ್ಲ 27th ಲಾಸ್ಟ್.
ಏನು ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ?
ಅವರು FDP ಅವ್ರದ್ದೇನಿಲ್ಲ ಟು ಅಕ್ಸೆಪ್ಟ್ ದಿ FDP ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಅಂತ ಇರೋದು. ಅದನ್ನ ಅವ್ರೇನಾದ್ರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ನಮ್ದು ಇದಿಷ್ಟುನು ಬಿದ್ದೋಗ್ಬಿಡುತ್ತೆ. ಅದಕ್ಕೆ
ಇಲ್ಲ, ಇನ್ನು ಸ್ಟೇಜ್ ನಲ್ಲಿ ಇದೆ.
ಚಾಲೆಂಜ್ ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ
21-10 ಇದೆ ಅದು.
No, accept ಮಾಡಿದ್ರು you can definitely challenge it.
ಅಲ್ಲ ಅವಾಗ ಆರ್ಯಾಗ ಬರಕ್ಕಾಗುತ್ತೆ ನಾವು. ಆಫ್ಟರ್ ದಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಕಮ್.
ಹೌದು.
ಬರೋದಕ್ಕೆ ನಮ್ಗೆ ಡಿಗ್ರಿನೇ ನಾವು ಇಲ್ಲಿ ದ ಕ್ವಶನ್ ಈಸ್ ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಇನ್ ಕ್ವಶನ್ ಹಿಯರ್ ಬಿಕಾಸ್ ದ ಕ್ವಶನ್ ಈಸ್ ನಾಟ್ ದಟ್ ಆಗ ನಮ್ಮ FDP ಮೇಲೆ ನಾವು ಬರ್ಬೇಕಾಗುತ್ತೆ. ಬಟ್ ದ ಕ್ವಶನ್ ಹಿಯರ್ ಇಸ್
ಸ್ವಾಮಿ ಮಂಡೇ
ಎಕ್ಸ್ಪರ್ಟೆಡ್
21-10 ಇದೆ.
Exported decree was passed by the trial court. That was challenged by us by filing a mispetition. That was dismissed. Mispetition dismiss ಆದ್ಮೇಲೆ ನಾವು MA ಹಾಕೊಂಡ್ವಿ. MA ನು dismiss ಆಯ್ತು. ತಾವ್ ಈಗ ಸ್ವಲ್ಪ ಹೊತ್ತಿಗೆ ಮುಂಚೆ ಒಂದು ಕೇಸ್ ಮಾಡಿ. So we are before your lordship now. ನಾವು ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಒಂದ್ ವೇಳೆ FDP ಆಯ್ತು ಅಂತಂದ್ರೆ ಅದ್ರ ಮೇಲೆ RA ಈ ಪ್ರಶ್ನೆಗಳನ್ನ ಅಲ್ಲಿ ತಗೊಳಕ್ ಆಗಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ. That is the problem.
No, you take a chance, we will see.
ಮಂಡೇ ಇರ್ಲಿ ಸ್ವಾಮಿ, ಮಂಡೇ 30ನೇ ತಾರೀಕು.
Release this matter on 30th of September.
2:30 minutes.
Number 26.
Yes.
Kindly have it after writing.
Number 26.
At the request of learned counsel for petitioner, release this matter after Dasra vacations 2024. Full stop. In the meanwhile, office objections will be complied with.
My lord, office objection, my lord, Hirama, wife of Karibasap was party in the MA number. But she was died during pendency of the MA, my lord. For that,
ಅದ್ ಏನ್ ಹೇಳ್ಬೇಕು ನೋಟ್ ಕೊಡಬೇಕು ನೋಟ್ ಹಾಕ್ರಿ.
please,
Yes.
Number 27. D. Gangadhara.
Please, for the petitioner in this matter.
Huh?
And for the petitioner in this matter.
Huh.
Lord, it is already served the copy to the other side. That is only the objection.
ಯಾವ್ದ್ರ ಮೇಲೆ?
That an application filed by me.
IA number 1.
ಹೌದು. ಅದರಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂತ.
24.
ಹೌದು.
Complied.
Complied.
You have received copy.
Complied, yes.
Please, please.
Learned counsel Shri Amresh A. Angadi appearing for the respondent submits that he has received copy of IA number 1 and 2 of 2024.
Please, and I will permit you to say about this interim order ಇದೆ. ಹಾಗಾಗಿ.
No, sir, no, sir. Not now. Yes.
Monday it may be have it.
Number
Lord,
28.
urgency that the interim order has to be extended and clarified.
Preliminary hearing ಒಂದ್ಸರಿ ಬಂದ್ ಹೋಗಿದ್ಯಾ?
ಬಂದಿದೆ.
ಮತ್ತೆ
ಅದಕ್ಕೆ ನಾನು
ಎರಡನೇ ಸರಿ ಆಗೋದಿಲ್ಲ ಸರ್. Yes.
That is why it may be have it on Monday or that is on first at least.
Interim order ಇದೆಯಲ್ಲ ಅದು he has filed an application for
ಅಲ್ಲೇನಾಗಿದೆ some clarification ಗೋಸ್ಕರ extend ಆಗಿಲ್ಲ.
extend ಆಗಿಲ್ಲ ಅಂತ.
June ಇಂದ ಆಗಿಲ್ಲ filed application.
June ಇಂದ ಆಗಿಲ್ಲ. June ಇಂದ ಆಗಿಲ್ಲ.
ಇಲ್ಲ subsequently it has been extended.
Was it declined to be extended?
ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಲ್ಲ ಕೋರ್ಟ್ನವರು.
No.
Was there any reason for not extending, sir?
ಅವ್ರು ಕೇಳಿಲ್ಲ, ಅದು ಕೋರ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ.
ಅದೇ ಆಗಿರೋದು.
ಹೌದು.
ಅಲ್ಲೇನಾಗಿದೆ.
So now we'll have to extend.
The regular court was not there. That is why in-charge court has taken.
ಯಾವ್ದದು? Which is that application?
And that is an IA number.
1 of 2024.
Please.
Huh?
And that is why I made an application for amendment and clarification also. Extension of the interim order.
Suit for eviction, my lord.
Order on IA number 1 of 2024. This application is filed by the petitioner seeking extension of the interim order that was granted on
Earlier.
Kodri. Order sheet.
18/4.
18/4/2024. Full stop. Learned counsel submits that the matter was listed thereafter.
2 times it has been extended.
On 3/6/2024,
3/6 been extended. Subsequently, 1 time it was not due to the.
3/6 extend ಆಗಿಲ್ಲ.
3/6 ನಿಂದ ಮಾಡಿ.
It was due to the.
Order sheet 3/6.
In-charge court was.
3/6 ಇಂದ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ.
But by inadvertence, the learned counsel did not submit, that did not seek extension of the interim order.
Yes.
Full stop. Thereafter, on 8/7/2024, the matter was referred to the Bangalore Mediation Center.
Please.
Full stop. In this regard, the learned counsel submits that due to the bona fide mistake of the learned counsel, the interim order was not extended. Full stop. Next para, accepting the submission of the learned counsel for petitioner, the interim order granted earlier on so and so stands extended till the next date of hearing. IA number 1 of 2024 is accordingly disposed of.
And my application pending or vacating.
You consider.
It may be have it on first. First.
After occasion, immediately after occasion.
After
At
vacation,
least date.
Immediately after occasion.
no date, sir. Yes.
Immediately after occasion, my lord.
ಬರುತ್ತೆ ನಾನು ಅದನ್ನ ಹೇಳೋದ್ ಬೇಕಿಲ್ಲ. Yes.
Date Mithun SK.
For the petitioners in this case.
2 weeks.
Notes. Here notes, the notice to other respondents will not be necessary because it's about the relation between
Yes,
me
I'll
and
take
the other
steps,
side.
Lord. I'll take steps, sir.
But they are
First-
producing not,
They are not.
they are not necessary for this list. Minutes, point is about rejection, minutes, rejection of an application to file written statement beyond 120 days, commercial suit. 120 days is passed out. Minutes. They did not file their.
I can't hear you now, sir. Not.
I understand. That is why not, it has to be
Learned
taken upon
counsel
its own.
For the respondent submits that response number 3 and 4 are formal parties and no relief is sought against them in the writ petition.
Please.
Full stop. Therefore, learned counsel submits that notice to respond number 3 and 4 may be dispensed with. Full stop. Learned counsel submits that respondents number 1 and 2 are the contesting respondents. Full stop. Next para. Accordingly, notice to response number 3 and 4 is dispensed with.
Monday, my lords, because
Inter-
there's a stay
intermodal
operating
eviction.
commercial suit, my lords, recovery suit, it's been stalled from
Intermodal
two thousand
eviction.
nineteen.
Yes, yes.
2000, my lords, at the end of the judgment, my lords, they filed this application. That
Not
is why.
possible now, sir.
My lord,
Let us-
intermodal
Monday,
eviction.
my lords, if it is possible.
Order granted earlier stands
My lords,
extended.
any date, my lords, because the suit is stalled. Commercial suit. my lords.
Serial number 29.
29, M. Shiv Prakash.
In 29,
Ah.
the last act hearing, my lord passed another 9/9/24 to secure the records. Now secure records are secured. I meticulously examined all the papers. Now
Not possible this
no,
side
no.
of the vacation, sir.
My lord,
You'll have to wait
only one
after vacation.
submission, my lord. Now,
This matter after vacations. Yes.
my lord, the shortest point is
Kagadilla, sir, not.
interim order is to be continued.
Interim order granted earlier stands extended.
30, Srinivas V.
I'm for responding. Waiting. We are filing a compromise petition. Are present before the court now.
Perfect. The petitioners and respondents have entered into a compromise petition and have accordingly filed the petition under order 23 rule 3 of the Code of Civil Procedure. Stop. Learned counsels on both the sides submit that the parties have agreed to extend the terms of the joint development agreement dated 24/4/2013 and 18/1/2016 in terms of the compromise petition. Full stop. The entitlement of the parties have also been resettled in the compromise petition. Please, ma'am. Stating that 65% of the developed sites shall be the entitlement of the plaintiffs, landowners, and 35% will be retained by the defendant developer. Full stop. The parties have agreed that the developer shall develop the layout within 6 months from the date of issuance of release of layout plan. From 6 months after obtaining the layout plan and work order at the hands of the Mysore Urban Development Authority, and also permission from Forest Department to cut and remove the teak wood trees. Full stop. Next para. All the parties are here?
Please, ma'am, all the parties.
You have explained to them. ಗೊತ್ತಾಗುತ್ತಲ್ಲ? The terms of compromise petition has been read over and the parties have submitted that they have understood the terms of the compromise petition. Full stop. Next para. Accordingly, the original suit in OS number 463 of 2022 on the file of the principal senior civil judge in CJM, Mysore stands disposed of in terms of the compromise petition. Full stop. Decree shall accordingly be drawn. Please. Much obliged.
Number 31, TP Mutana.
The last repeat, sir, my lord.
MS.
President second appeal, my memo has already been filed.
Yes.
Serial number 32, Bayaradian, awaiting.
I have showed copy of the respondent counsel also.
You are appearing.
For respondent.
Huh?
For respondent in this.
Agla. Who else?
Jagdish Mundragi, man.
Already, why notice was issued when you have filed caveat? You have filed caveat, huh?
Please, man.
Then why notice was issued?
Last time, the last told me to show copy on the other side. Now the.
Already caveat file ಮಾಡಿದ್ರಲ್ರ ಅವರು caveat file ಮಾಡಿದ್ರ ಇಲ್ವಾ?
ಮಾಡಿದ್ವಿ.
Learned counsel Shri Jagdish Mundargi has entered appearance for the respondent.
Please, man.
You have got a copy of the writ petition?
Please, man.
Yes. Yes, next matter, please.
Serial number 33.
Interim order.
For evidence.
In the trial.
Interim order extend ಆಗ್ಬೇಕಾ?
ಇಂಟಿ ಮಾಡೇ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ, ನಾನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಇವಾಗ.
Last time.
ಈಗಲ್ಲ, not now. Yes.
33.
Appear for R5 million. Undertake to file wakalat on it.
Second time.
Appear for R5 million. Undertake, we have not.
From this side. Learned counsel Shri. Learned counsel Shri.
Rakshit million. Rakshit million.
Rakshit.
You have to undertake wakalat million. We have not filed wakalat yet.
Undertakes to appear for respondent number 5.
Yes, million.
A week's time is granted to the learned counsel to file power. We'll stop. Next para. 2 weeks time is granted to the petitioner to take steps for service of notice on the unserved respondents. Yes.
34. M. Maltesh.
For the petitioner, copy to the respondent, counsel will be served. And Milord, through RPD also it is sent, and Milord, through WhatsApp also Milord, it is informed.
ಯಾವುದು?
Serial number 34.
ಅಲ್ಲ.
For
Mr. Srinivas Gowda.
Serial number 34.
it is Milord for
IA number 1 of 2024.
extension of the
Copy
interim.
is not served ಅಂತನಾ?
ಅದು ಅಂತ ಬಂದಿದೆ. Copy served. It is served through WhatsApp and also through RPD also it is served. And it is informed to the Milord, the respondent counsel. Only in respect of the Milord, the extension of the interim.
Acknowledgement not served ಅಂತ ಬರುತ್ತೆ.
ಹೌದು.
ಮತ್ತೆ?
Copy served.
ಏನ್
I sent through WhatsApp also, I informed.
Let us see. List this matter after Dasara vacation.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ Milord, the amendment Milord.
ನೋಡೋಣ, at least ಬಂದ್ರೆ it can be held that it is served and we can go proceed. ಇವಾಗ ಬೇಡ.
ಅಲ್ಲ, for extension of interim, IA only Milord, I served to them Milord.
Yes.
Serial number 35. Basarajappa.
This case, I complained all the office objection except objection number 5.
For the petitioner.
Petition.
ಈ ಕಡೆ
Respondent.
ಈ petitioner respondent.
Correct. I complained all the office objection except objection number 5. Objection number 5 is documents to be stitched as readable. My lord, in this case, some documents are issued by the police department, FIR. all those documents printed very narrowly to the left margin.
Rectification of office objection raised on IA number 1 of 2024. Ada, ಯಾವ್ದ್ರಿ ಇದು?
Serial number 35.
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ?
D. Basuraj.
Office objections are overruled. List this matter for preliminary hearing.
Yes.
On 30th of September.
36, Shauri HR, first time.
Two weeks time is granted to the petitioner to take steps for service of notice on answered respondent.
37,
Beg
anyone
to,
from G?
beg to represent the petitioner, my lord. Notice has been served to the
This matter of the service of
counsel
notice
appearing
on
before
response
the
number
trial.
1 to 3. But that
38,
will not be taken as service of notice, sir.
Lord,
Issue M. Datta.
Allah, you have taken steps, sir.
I've taken
It has
steps.
not yet returned. Let us see. Yes.
38,
Lord,
Issue M. Datta.
I've sought for an order of stay, my lords. Matter is on 28th, my lord.
Cannot be considered, reconsidered now, not possible. Yes.
38, Keshav M. Datta.
A
awaiting.
date could be fixed, my lords.
List this matter after service of notice on the respondent.
38,
38 ಆಯ್ತು 39 ಹೋಗ್ರಿ.
39.
My lord, we have.
For the petitioner, my
My
lord.
lord,
Number
38, we have filed an
First
idea
time.
for police protection, you know. Kindly matter be taken up
Not
tomorrow.
now, not now, sir.
My lord,
Yes,
27, my lord.
38, 39 ಅಲ್ಲಿ 2 weeks time is granted
39 for the petitioner, my lord.
to the
We have,
petitioner
we have done the needful, we have served the copies.
today.
Yes, my lord, today we have. Supplementary this one.
Huh?
We have served the copies to the respondent, on the respondent, my lord.
Learned counsel.
How, I'm for the petitioner.
2 weeks time is granted to the petitioner to take steps for service of notice on the respondents. Yes,
Kindly extend the interim order, my lord.
interim order granted earlier stands extended till next date.
Grateful.
The 40 order passed, 41,
Yes,
Shivraj N. Harali, interim conversion. Serial number 41, Shivraj N. Harali.
41. Matter is called out. There is no representation for the petitioner. List this matter after Dasara vacations.
42, Vinayan.
Office objection note, one is not certified copies note of the order sheet. I'll place it on record. But some urgency. Lord, I had an ex parte order of injunction. But the respondent comes and files objection written
It
statement.
has to come up for preliminary hearing, isn't it?
Very well. Day after, Lord.
List this matter for preliminary hearing on 27th of September.
Great.
43,
43 ಅಲ್ಲಿ I'm approved for the petition.
Sappa, MS Sappa.
That office has raised objection to place the original photocopy on that. What happened on that? These photos are produced before the trial court on that. The trial court
Office
has.
objections are overruled. List this matter for preliminary hearing on 27th of September.
Please.
44, Swati Shivkumar. 44,
Abhinav Ramanandri.
Abhinav Ramanan.
Only office objection is, Lord, plaintiff passed away after the order was filed, but before the writ petition is filed. So I have filed an application under 146 to file the writ petition. They want me to file an LR application. LR application, my lord, will apply only after I have filed the present case.
ನೀವು ಮಾಡಿದ procedure correct.
146.
ನಾವು, I don't know. Many times we have held in that Dharwad and Kalburgi also. Even in writ petitions we have seen, forget about writ petitions coming under 227. Even 226 kuda, they will mention the name of the dead person. Then say LRs. No orders are passed by the court
Correct.
permitting you to bring the LRs on record. You are filing a petition in the name of a dead person.
Exactly. So Aditya, I have filed an application to permit me to file the petition again.
Office objection is overruled.
Lord, this matter.
List this matter for preliminary hearing on
This can be connected
27th.
with another matter where the same order is challenged and my lords have given a stay.
Kodi.
Lord, this is that matter where court commissioner is appointed.
Ah.
The court says you come and examine him in the court itself. Same order is challenged in this writ petition also, my lord.
Same order as in WP number 21887 of 2020.
Yes, my lord. It may be tagged along, my lord.
List this matter along with so and so.
Yes.
44, 45, eradu.
Illa, 45, my lord, same objection. But it is a different matter, my lord,
All right.
proposed it for preliminary hearing.
45 ಅಲ್ಲಿ office objections are overruled. List this matter of preliminary hearing on 27th.
Yes, very well, great.
Still number
Serial number
64, 230 list, your lordship. Still number 64.
230 matter.
Put it clear.
Serial number 62.
230 matter. Yeah.
Matter was heard for some time, section 65 of the Evidence Act.
My lord, I am for the petition, my lord, in cell number 64, interim order. will kindly
Citations also to be produced.
extend.
Kindly have it on 27th.
Number 64 ಮತ್ತೆ 65. Release this matter.
My lord, the serial number 62, the
on
interim order is
30th of September, 230.
230.
30th, my lord.
Matters that
230.
have not reached, there is no need to extend the interim order.
No, serial number
Serial number 56, my lord.
Attachment of personal property.
The serial number
56, my lord. 56 interim order may be extended. 56.
ಕೇಳಿಸ್ಕೊಂಡ್ರಲ್ರಿ ಈಗ matters that have not reached, there is no need to extend.
Please, oblige, oblige, oblige.
Whatever is there in the previous order sheet will remain.
Please oblige.
My lord, serial number 57, my lord.
I can't give dates in any other matter.
Allegedly, it will become infructuous by 30th, my lord.
64 parallel.
ಆಯ್ತಲ್ಲ, 39.
Huh?
39.
ಸರ್
ಸರ್, ಇದೇ ಇಲ್ಲ ಅಲ್ಲಿ preliminary ಗೆ
ಸರ್ ಇವಾಗ ರೀಚ್ ಆಗ್ತಿರೋದು ಯಾವಾಗ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ಯಾವಾಗ
after vacation.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಏನಾ ಸರ್ ಶೋರ್ ತಾನೆ
30th, both the ತಾರೀಕು.
ಸರ್ 63 ಆಫ್ಟರ್ ವೆಕೇಶನ್ ತಾನೆ
ಎಲ್ಲ after vacation.
38, sir. ಯಾವ date? 38.
Await service of notice.
Sir, sir, ಅದು interim order extend ಆಗಿ. Interim order.
ಯಾವ್ದಲ್ಲಿ?
38.
serial number ಏನು?
So 49 only.
Sir,
ಅಭಿನವ್ ರಮಾನಂದ್.
sir.
So 49 only. 49.1.
ಏನಾಗ್ಬೇಕಾಗಿದೆ? ನಾನ್ ಕನ್ಸಿಲ್ appeared, but ಏನು ಹಾಕ್ಬಿಡ. ಬರೀ
Sir, memo book ಕೊಡಿ sir. ಆಯ್ತು. Memo book.
So 49.1 ಅಲ್ಲಿ ಇದೆ. 49.1.
ಆಯ್ತು.
Interim order extension sir.
ನಾಳೆ ಏನ್ ಡೇಟ್ ಇಲ್ಲ, ನಾಳೆ ಏನ್ ಡೇಟ್ ಇಲ್ಲ, 26 ಅಲ್ಲ? 26 ಯಾವ್ದು? 27 ಅಷ್ಟೇ. ಕರ್ನಾಟಕ ಕಡೆಯಿಂದಲ್ಲ ದಿನಾಂಕ ಆರ್ಡರ್ ಫಸ್ಟ್ ಹಂಗೆ ಬರೀ
What officer sir?
Sir, memo book ಕೊಡ್ತೀರಾ?